Which party is not a IFP?
IFP. Yeah.
So what are we doing? We are. What was your? Okay. No, let us greet everybody and. Today, the 16th of August, and let me welcome everybody that is in the meeting, the members of the committee. Welcome, Honorable Mani, to our committee. You are coming at a very crucial stage of the work that has been continuing since 2021. DM, can you lead a prayer for us today? Let me not start with Pastor. Let's say DM, Deputy Minister of Department of Basic Education.
Okay, let's pray. Just bow your heads. Seated or standing. Our Father, who art in heaven, the Father of our Lord and Savior Jesus Christ. Lord, we invite you in this meeting this morning. We believe, Father, that we are leaders because we are ordained and specially prepared by you and selected by you and made people to make it manifest because it started with you. Lord God, if you put people in positions of leadership, you not put them for themselves, you put them for your people. We're in this process, in this meeting, Lord, not for ourselves, but for your people, that we know that we love them, not less than we love the leaders. Father God, as we start this meeting, we invite you to lead us through your Spirit. Get into our minds and hearts, that we know that what we're doing today here, we're building the future of this beloved country, South Africa, which is the country of our descendants to come, even those that will come even 10,000 of years to come. The laws that we're making in this country are not for the present generation only, are the laws that will determine the future of this country. Father God, we pray that guide us, lead us, give us your wisdom. We can use our own earthly intelligence, but it's only your wisdom, Lord, that will guide us. We pray, my God, my Father, that you help us. We cannot do it on our own. We ask you, Lord, believing that you are going to help us and guide us to the right path. Lord God, protect even the chairperson of this meeting against us and against herself. In the name of Jesus Christ of Nazareth. Amen.
Amen.
Because I look at the Lord.
Yeah, no, yeah.
Let us say amen. Amen.
No, thank you very much, DM. Siyabonga. Siyabonga very much for the prayer. For the prayers. I think as we are starting, the good thing to do would be to apologize to the people of South Africa for what has happened yesterday. And that apology comes first from myself, from the table. I apologize for anything that has happened by any member yesterday. I think what we did yesterday, we brought us first and we focused on representing the people of this country. And I want to say, as the chairperson of the committee, and on behalf of Basic Education Parliament, we sincerely hope that the people of South Africa will be able to forgive us for what has happened. It's not basic education what was happening yesterday. We've got our way of dealing with our differences. But members also, I think, would understand, and I apologize if I've managed to hurt anyone from you. My prayer again today is that we are able to differ constructively, like we normally do. We are able to give guidance to the process. I have prayed to be calm, and I will become, I promise. And that's for all of us. And I'm not going to speak too much. I'm going to chair the meeting today. So if we agree on that, I know, man, we are a family here of differences, of differences. So I hope that it ended. We will be able to proceed. I just want us to mention that, one, what we missed to discuss yesterday is it possible for Treasury to come and give us the financial implications. And now I'm asking Llewellyn to write a letter to them. And I want us to agree that as and when they arrive, even if we are in the middle of the process, we allow them space to present so that we don't hold them here. We get that report. But of course, I'm gonna tell you what their response will be. Two, we have dealt with the national report yesterday of our committee. And I must mention that we have noted the objection of the DA and ACDP. And my guidance to that, because of there are numbers and there's work that needs to be done, I have asked Sis Posh, our content advisor, together with Mr. Bandi, to bring up a team that will work on that. And that response we will get as and when we are towards the finishing. And when they are ready, even themselves, if we are in the process, we will ask them to give us that, and then we will proceed. But what I can promise you is that we are not going to leave this room without that information. And then the third issue. There is an issue that has been referred to as a legal implications, or rather constitutional implications. We are going to start now with the process of the clauses. But our approach to that process of the clauses would be Advocate Gema to guide us on how to deal with that process. She needs to tell us and caution us of the process. She needs to guide us as a parliamentary legal person. And then we will ask the content advisor to read a clause, how the clauses came from DBE, their recommendations. And then when she is done, I'm going to allow members of the committee to speak on each clause. But for us to manage the process, I am requesting you that I will allow you to speak only for 3 minutes. And when I'm saying 3 minutes, I'm not saying that you cannot come back if you feel strongly that you want to come back. We will read how it works, but I'm going to for instance, if you've got a clarity or you've got something that you want to raise, you can come, but if we don't manage time, we might end up losing it. We need to manage the issue of time. After the members have exhausted to speak on the clause, if, for instance, we say clause 1, she reads, you speak, and once you have exhausted that, I will allow Department of Basic Education to speak. Because of course you will be telling them what you've gathered on the ground. So you will tell them this is what you think it must happen. And then Bona, they will advise whether it's possible or not possible. But immediately when they have spoken DBE, I'm going to give the state law attorney to speak immediately after DBE on each clause. Then after the state law attorney, the final person that would speak would be our parliamentary legal services. And then we would have got what we call, it's a construction of a clause. Then we put it aside. Then we move to clause next. And when we got to clause next, we use the same approach in all clauses. So that is my approach for the day, which I hope that it's acceptable to the members. Can we proceed with that approach? Not that.
No, thank you so much, Chair. I'm glad that you started the meeting with a very calm approach and an apology, which I think is important from all of us to the public. And I think the approach that you set out for us it's acceptable. I think it's the correct process on all the 4 components that you've mentioned now. The only request that I would maybe want to make to you is if, for example, on that report, there were questions that were still outstanding, we maybe construct them in writing of any discrepancies, even though the report has been, you have now adopted it, so that we get some form of clarity. You spoke about numbers, but there might be other elements within the numbers that we maybe want to ask questions. I think that's the only thing. But the process itself, as you have outlined, is acceptable. And when those presentations come from National Treasury and the guidance from the State Law Advisor and the Parliamentary Legal Services will obviously accept those. But I think the process as outlined is acceptable. The only request is just that one of written questions. Thanks, Chair.
Good morning to everyone. Good morning, Chair. Thank you for responding to the concerns that were raised yesterday. My question is around the submissions, because we're not sitting with a matrix of the comprehensive public submissions. So how we would keep track as we go clause by clause with the submissions as pertaining to that clause. If we can just get an idea on that. And the presentation by DBE yesterday that we've missed, obviously, has not responded comprehensively to the public's submissions. How will we incorporate their response to what the public said on those particular clauses? Thank you.
No, thank you. Okay. Honorable at once.
Thank you very much, Chairperson, and good morning to everyone. Chair, I would also support the move that you made on the process, and I take it that it is actually today's agenda on how you have presented the issues that we're going to raise. It's supported. Thank you very much, Chair.
No, thank you very much. You want to?
No, I failed to say that I support the process that you've put together. I just put my hand up to say that I think I didn't say that in my questions that I was asking.
Okay. Look, the issue of the, in fact, that's what maybe I omitted when I spoke on the national report, is that except for the issue of numbers, there are issues of submission that are raised. And I think it's a matter that whatever that is raised would be responded to. But the reason I'm saying after she has read, you must speak, because you were part of that process. That's our process. So the submissions which were in the public hearings. That's the submission you are referring to, or which submission? The submissions that you are speaking about is the written submissions.
Chair, normally there is a comprehensive matrix that accompanies the clause by clause in the processes that I've been a part of in other committees. That has a comprehensive matrix of all the written submissions, includes the written submissions, and it gives the department and it gives the committee guidance on the submissions that was made by the public on specific clauses. So I'm asking, how are we going to do justice to those submissions without having a matrix of the submissions before us? I do hear you saying that we have been part of the process, we've heard the public, those certainly is going to be helpful. But I do not see how, I'm asking, how do we do justice to those so that the department responds to those submissions and so that we're cognizant of the submissions that was made by the public? Thank you.
Mr. Bandi, can I ask you to advise?
Thank you, Chairperson. Good morning, honorable members and colleagues. If the request is to produce a version of a matrix, I'm sure with our team, the content advisor, we can work on that. We're getting the request for the first time. If there is such a request, where we start with clause 1 and sort of highlight what members of the public are saying with regard to clause 1. We proceed to clause 2 up to the last clause. It's just a way of structuring things. We could do that if there is such a request. But it will probably take a little time. Maybe the content advisor can suggest on the time frame for producing such a structure of a report. Thank you, Chair.
I want to avoid that debate of whether we do matrix or I want us to avoid it. And let us not, for instance, in my view, how minerals would agree on how they do their process should not confine us as basic education. You know, if they decide to use that method, and I think such a method is purely administrative. It's purely administrative, and I want to plea with the meeting that let us leave it to administration to deal with that. Let us deal with the crux of clauses. I'm not sure if I'm making sense. But I want to say, Sukers, I hear you, but I would ask the meeting not to be pushed to do metrics. If they see it fit, they can do it. Let us leave administration to administrators, and then Tina, let us do what politicians are supposed to be doing. Thank you very much. Can we close it there, Principal? Advocate Ngem.
Thank you, Chairperson. Greetings to the members and everybody in the House. My name is Phumelele Ngema, the Parliamentary Legal Advisor. Chairperson, I'll be very brief on the request or instruction that you've indicated me to do. I think basically we must appreciate, all of us as we are present here, to do this task, that Parliament is a creature of statute, and so whatever we do, we are guided by what is on the statute book and the guidelines and the rules of Parliament. That said, Chairperson, the process that we are on and embarking on now is in terms of National Assembly Rule 286, which is the process in committees. And the subsections there basically set out what some of the things have already happened and some of the things that we are embarking on right now as we speak. So, Chairperson, what is happening now, as I understand, is that the committee is going to be starting to deliberate on clause per clause of the Bella Bill from the inputs, submissions, and all the considerations of the public hearings in all their different formats that have taken place. And if I may, specifically just in National Assembly Rule 286, subsection 4, I think. Yes, Chairperson, it's subsection 4, where it says in A, the committee must inquire into the subject of the bill and report on it to the Assembly. And C, if the bill amends provisions of legislation, must, if it intends to propose amendments to other provisions of that legislation, seek the permission of the Assembly to do so. And then in terms of the other provisions, Chairperson, like the JTM processes and all the other things have already been done, and it was tagged and decided that there will be a Section 76 bill, and that is the process that is continuing, and that is also why the inclusions that the committee, when it decided on its own processes, that's how it will go about. It included, after taking the submissions and hearings within Parliament, that it is going to go nationally, and all the reports that the committee have had arising out of those processes. In terms of I, Chairperson, which is also the process that has taken place after due deliberation, which is partly done because more so deliberation into the content and the decisions is now going to be starting today. Subsection 4 says, after due deliberation, the committee must consider a motion of desirability on the subject matter of the bill, and if rejected, must immediately table the bill. However, there are further processes. If the motion of desirability is adopting and they proceed into the process, which is what we are engaging into today, where we are going to unpack each clause, members make their comments, and as they are doing so, we are taking notes, we are taking directives as to is there a possibility of amendments, and if there are possibility of amendments, because as I read the provision, we are dealing with an existing legislation, which means it's a principal act that is already in place. It has set out some of the things, and so whatever we are trying to change as the legislature, as the empowered body, is to change what is already in the statute, and it's following from the power that the National Parliament has. And that being the case, Chairperson, if, as I read the other provision, there are other sections to which the introduced bill, which is sponsored by the executive, because this one is not the one bill that comes from Parliament either as a member's bill or as a committee bill, but this is an executive bill that we are dealing with, which means it is sponsored by the executive, and therefore most of the information will be coming from them in terms of policy and guiding us as to whether policy-wise are we sticking to what is intended or to what the white paper drafted, as well as the existing legislation is speaking to. Now, moving forward from that, Chairperson, that's why we are here to keep in mind the existing provisions and how the introduced amendment is trying to make the changes, and perhaps to understand the background as to why the amendment bill. I think members would be aware by now from all the engagements and the submissions, there is too much of jurisprudence and court contestation that has taken place in the space. Because clearly one can make a view, perhaps things are not clear in the existing legislation. The power are not clearly deliberated or outlined as to the extent, and that is why the interpretation by the courts has been sought by those who are feeling aggrieved or feeling that they did not understand. In most of the cases, the court cases, whether be it the High Court or the Constitutional Court, which is the apex court, that we finally take at least the direction from them to guide and to give a proper direction in line with the interpretations and the provisions of the Constitution. So what we have seen is that from that jurisprudence, the contestation is serious in terms of who has what power, what is the extent of that power, how to implement and exercise that conferred power. Most of the cases are like overlapping and trying to find a solution as to what are the provisions that are in the statute drafted. What are they saying? For an example, in the MLO and harmony judgments, the court is trying to say, if we look at Section 16 and Section 16A of the SASSA Act, the powers there are outlined. To tell the partnership that the white policy on the white paper giving the policy on how the SASSA Act was meant to eventually function and be implemented. There's supposed to be a partnership structure that sets out the role players, that sets out the functions of the role players, and that sets out the interest and the legal rights that must be protected, arising from Section 29, because that is where everything starts, from Section 29 of the Constitution, which gives the learners and as well as the adults who are no longer just minority or minors, who have a right to be educated, and the obligations of the state, and the partners that can then play roles together, and that is what the submissions have been speaking to. If one looks at the cases, for an example, Chairperson, just to quickly get into, just to give the overview, for an example, Chairperson, the school governing bodies find themselves in a serious contestation with either the principal or the executive structures, be it the minister, be it the MEC for education, be it the HOD who is running the department provincially to guide the processes. Those sections that are referred to, they are speaking to the governance and the management of schools. As I was trying to find myself and understand the space, I hear the courts, they speak of the school. And then they speak, the school brought the matter to court. And then somewhere they will say the SGB brought the matter to court. But perhaps there are questions we need to be asking ourselves when we're dealing with the subject matter. Who is the school when we say the school? Is the school the learner? Is the school the learner, the educators, the principal, everybody in charge? Is the school, in terms of management and way the provisions are drafted, does it make reference to the school governing body in the exclusion of all the others? But then, furthermore, the same provisions have been interpreted to say the roles have been delineated and clarified. This is what the school governing body can do. This is what the principal can do. This is what the learner can do. Who can issue policies? What is the extent? What does it mean to say a policy has been issued, the circular has been issued? Where does that power come from? You were given the power to make regulations as the minister, but you make the guidelines. The determination of what eventually goes out to the public, I think, creates the confusion that we are now finding ourselves, and we are trying to correct and bring the clarity that is necessary. And I think basically, Chairperson, that is what the draft bill or the draft legislation that the department has put together to make attempts to all the issues that they have confronted, to make attempts of all the submissions that were made to them even before the process came to Parliament. It is a product of engagement, is a product of trying to say there are challenges. Can we go back to the drawing board and see how the challenges that have played out can now be clarified and be given solutions? And basically, this is the process now. This committee, as the extension of the National Assembly, is now attempting to do as the national legislative body, to say we are seeking to amend the SASSA Act. There are provisions that need to be looked into, because clearly we wouldn't be having so much jurisprudence or litigation if everything was as straightforward. The fact that courts daily or yearly are undated with the contestation between the role players in the education sector, it does mean that things are not clear. So the provisions that have been put, I think it's 56 clauses that have been put before this committee. But what I wanted to point out is that, for example, if there was anything the committee would have desired to change in terms of section 16 and 16A, which is basically the main provision about the partnership, that provision is not part of the amendment bill. And if the deliberations go as far as saying, we do actually, I'm just making an example, we do actually need to be making something that speaks to the changes in those two provisions, then a process which can run concurrently with this process, where the committee is seeking permission from the National Assembly that we can get into the other clauses that are not part of the bill, but the sections of the Principal Act, because they are impacted by the deliberations or from what is coming into the decisions of the committee, that we do look into the provisions that are not part of the introduced bill. So it's going to be a very complicated and convoluted task, Chairperson, and because also we have seen the interest that every stakeholder is interested to make their voices heard, which is their right. That is why the committee must satisfy and has, to a certain degree, satisfied the constitutional obligation to facilitate public involvement so that there is meaningful engagement to guide the end results, to guide the decision that the committee will finally take. Because the process of public participation is to make sure that the voices of those who must have this legislation enforced upon them and implemented by them and respected by them, they are clear and they have actually played a role so that they can know we were part of this. This is the end result of each and everyone involved. And that's why the submissions and everything, as the members were present and were hearing, are now supposed to be taking back this into the process, make changes into the clauses if there are any, and the committee will then deliberate and agree, guiding us then to effect the changes, whether it amounts into an A list or it amounts into a completely new bill altogether, speaking into the issues that have been raised. So that is basically the process. And in terms of how it's played out, Chairperson, each committee, as you have pointed out, makes its own decision, because the rules are merely a guideline to say, just ensure that all these factors have been taken into account and each process has been followed. But as to how the latter of that process runs out, each committee makes its own decision. And as the chairperson has indicated, what we are doing now, maybe in other instances we would have done a presentation that sets out before you get to deliberations. It's up to the committee, but also if we have to make our input, because we've been part of the process as well and we are following where we haven't been in the meetings like the public hearings, because in terms of capacity for our office, we can't really do provincial public hearings, and those we either follow on the stream or follow on the reports, or do get one way or the other to ensure that the information that came out of there, it does land in our hands as well. For instance, the submissions were submitted to our offices and we've been studying them and we've been looking them. The same thing with the state, with the state law advisor as well. And I think with the department, the submissions are also shared with the department so that when they prepare the responses and they guide the committee, they are aware fully of what has transpired in the past. So that is where we are at, Chairperson. Every clause, if we have a legal issue or a constitutional issue that we need to bring to the attention of the committee, we will do so, and that's why we are fully present in all the meetings. Thank you, Chairperson.
I think that's, not unless there's anyone with clarity, but I think that's more or less guiding us. I get we are not the people of law, so can not that principally that's okay.
No, thank you, Chair. I do think that maybe just for guidance purposes, because the presentation was done by the Parliamentary Legal Services when we first started, and there's an indication that there's certain things that we need to follow in the process despite whatever the committee's approach is to it, but the specific things. And I think those things may be shared with the committee for the purposes of making sure that all of those elements that are required in the process have been followed. And there's also an indication about the importance of the public participation process hearings. And the question I would like to ask from the Parliamentary Legal Services team is whether the public participation on all components, whether written or oral, or even the public hearings we went to, are we supposed to take a particular sizable sample, or do we analyze all of those submissions as a guidance to this particular process? I just need to get clarity on that. And then the last one from me, Chair, the Section 16A process, where there's an indication if, for example, the committee deems fit in the existing law or statute that exists, which we are now dealing with amending, and there's some elements in it that we intend to maybe amend, would that require a committee decision and to take that to the National Assembly to request? What would be the process of that? If we've identified an issue that we think should be amended to accommodate the moving time in the system in other provisions of the existing statute. Thank you so much, Chair.
Chairperson, good morning to yourself. Good morning to the Deputy Minister and the team, Basic Education. And good morning to my colleagues in the Portfolio Committee. I listened very carefully, and there were quite a number of things that I was draw inference to. And number one, well, it's good what she said was served as an eye-opener to other things. But I think, number one, we must appreciate that in her input, she's not putting any prerequisite that we cannot proceed with the clause-by-clause discussions as it has been proposed from yourself or by yourself. And number two, is it possible that what she has been saying, for record purposes, I know we are in a meeting situation where there is a recording, but for recorded and reference purposes, is it possible that it could be provided to us in writing? And then so that some of the questions of course and consensus raised by my predecessor here and Honorable Nodada would, we also have got some other things to ask. You see, it would make sense from a documented point of view. So that is just my plea. And hence I would even say questions like as they are raised by Honorable Nodata could be reserved until input shall have been provided to the Portfolio Committee members in writing. It's a sort of report, which report we can't discuss if it is not documented, to be honest, because we are likely to miss some of the things which he has said. Thank you.
Thank you, Chair. Mine is to support the request that was made by Honourable Nodada for the legal parliamentary services to outlay the processes that she has referred to. And my question is that I appreciate the reply of the Chair and also what you mentioned of all committees working differently. What I would like you to ask, Chair, is if the parliamentary legal advisor could just give clarity on, without a substantial, comprehensive, written compilation, such as a matrix, would it not be that a case can be made that we not meaningfully have engaged clause by clause on those? And in terms of the efficiency of the process, when we're dealing with a clause and the department responds, if just a summarized report, such as the ones that we have, would be efficient and would be constitutionally, would do justice to the constitutional requirements. Thank you.
Let me clarify what we are doing. She is guiding us on the process. Now, what I'm picking up is that we are fearing the don't knows. Ne? Advocate Ngema, can you first respond? Can you first respond, and then after you have spoken, then we proceed. Thanks.
Difficulty and fear of making lawyers speak rather than make them assist and take the process forward. Chairperson, I think let me start with the permission issue and the provisions that might not have been involved. It's merely an alert and bringing the information to the committee, not that we are saying there is a provision we've picked up or that we are saying there will be that process taking place. The bill as it is before the committee with its provisions that the department and the ministerial committee, the minister decided must come before the committee, is what they have already requested and put as introduced to say, may Parliament consider this towards the process of making it law. But what 2864B says, it says this is merely to contain the process and not go overboard, especially when we are dealing with legislation that has already been drafted. It says, the committee may seek the permission of the Assembly to inquire into extending the subject of the bill. Now, in other words, if the committee is intending for some reason or the other to go beyond what is already in the bill, we cannot, as the committee, just go into those provisions without getting that permission, because the House is the main structure to which this committee is the extension of. So that is why, at all times, just to ensure that whatever is done in the committee has the backdrop as well as the approval and the authority necessary of the plenary house to which this committee belongs to. And that is why we have such a rule guiding and written in the rules of Parliament to say, should such an instance be necessary, the committee must make a decision and make a request to the House to get that permission. And it is merely done through a letter. Once a committee decision is made, the chairperson prepares the letter and it goes to the House, and then it is the permission is granted in line with that rule. There's never been an instance where that permission is refused. So, for an example, if there are instances that as we go through the provisions, for an example, if we are speaking on corporal punishment and for argument's sake, it was only done in Section 1 and Section 10 makes no amendment. But because of the definition that will come of corporal punishment in Section 1, there is then a consequential amendment necessary to do in Section 10, but Section 10 was not part of the provisions that are in the bill. That is where such kind of a permission is written, to say we are already foreseeing as we are deliberating, there are provisions that may be impacted, but they are not part of the introduced bill. Is it possible for the House to grant that permission? And through the processes of the House, that will be done, and the processes of the procedural office as well for the National Assembly, it will be channeled and then taken through until it reaches the right office and the right authority to make that decision. And that process is over. It normally runs concurrent because it arises out of the deliberations. It doesn't normally become an abstract thing that for an example, myself and the state advisor would think of. It comes out of the deliberations of the committee. So that is why I'm saying it's not like there are provisions that may require changes which are not here, and we have foreseen that. That is not what I'm saying. And then on to the other questions, Chairperson, in terms of preparing the opinion of what I've said, that will not be an issue. I'll try under the circumstances and make that possible and submit once I've put it together in writing, Chairperson. That is not an issue. On the question of public participation, as well as the extent and the reports, I think it's good and well that as we go on doing the work of the committee, we have foresight and also maybe thinking ahead what could be and what could not be. But clearly, in line with the prescripts that Parliament has, some of them have the status binding, some of them are merely guidelines. But in light of what the Constitution provides, that Parliament must facilitate public involvement so that it allows the public to make their views. It all depends on the resources and the capacity and the directives, if there are any, that the committee gives. And for us to make an assessment onto what was done and what has not been done and how it should be done, it's to a degree an unfair exercise or assessment for one to take a view on. And that is why even for the courts, it becomes difficult. And that's why sometimes there'll be dissenting judgments to say one of the portion of the judges would agree with the view of a certain judge who has penned the judgment and the other one would disagree. Because the assessment in terms of how things are done is normally very subjective. It's not an objective thing. And it's so not easy for me to indicate that the submissions, the metrics will assist or it will not assist. Like I said, each committee decides on its process. And if that is possible to do, it's always easy. And I believe perhaps even the department, if given a chance, may have done the same thing already, to speak to each and every clause and the submissions to say, because we were part of everything that was contested, because we are also serious to see this thing come to light and be a good product. This is what we've produced. This is what we had as we were part of the hearings, and these are our responses. So whichever way it's done, it is always possible to make sure that all of the information is before the committee. And the final point I would make in terms of that question is to say, every submission made is to be considered, is to persuade or influence the committee, and therefore, that is why it is submitted and brought to the committee. One way or the other, members are supposed to be influenced or take what was said there and consider it, deliberate, and eventually make a decision. The purpose of submissions is to influence the end result and make sure that the people of the country were heard, and not only just heard because they came here to speak, but whatever they've said was heard, was considered, and is seen to be coming out of the products that eventually becomes the law. And if the court, through an opportunity of a court case, gets to review the process and review what was done, as long as there is evidence satisfying the court that what the committee did is A, B, C, D, the courts have refused to set stringent procedures or strict, rigid ways to say Parliament do things this way. But if Parliament decides to set its own standard, then Parliament must stick by those set standards. So in this instance, Chairperson, I really cannot make an informed view to say this is the position in terms of the public participation. It's not my case.
All right, no, thank you very much. The only thing I would ask is that, as much as you have said that there's issues of time, can you, when you are able, that presentation to send it to us so that members can get it, what you have done? Aye, man, fighter. But
No, sorry, Chair, I won't switch. I won't take you back. I just wanted to make just a comment in passing. And the comment I want to make follows from the question raised by Honorable Nota about whether how many, or rather some separation of sorts that he was inquiring about on written submissions versus oral submissions. I just needed to just comment there that that question made me nervous. as to what is the basis of this question. What is the motive behind this question, given the illiteracy rate that the country has as a result of apartheid that we've had. So I'm just nervous as to what is the substance behind that question. But I'm just passing, I just thought I must just raise my concern on that issue without starting a debate.
Man, please, honorable speakers, please, let's try to move away now. Please, I'm requesting let us try to move away. I've asked Advocate Gemma to send us that guide that she has been speaking about. And I want to say the reason for that guide is that we are dealing with this thing for the first time. So it was important that we must be guided how to handle it. I don't want us really to deal with, now he's bringing politics. He's bringing serious politics now. I really don't want us to let us not divert, please. And with all that respect, I want now to say, let us move to clause 1. Let us move to clause 1. Suppose, can you read out loud the
Chair.
Can you allow suppose to read clause 1? We'll come to you, we will speak on clause 1. That's what I said. No, we are going to which I have outlined. Let's stick to it. Thank you very much. Okay. A copy of the Bella Bill is in the yellow folders as presented. I am now going to read the clause. Yes. Yesterday you got it. Who doesn't have yellow folder? Marasra. Everyone has the content. Can we proceed? The Bella Bill. It's in the yellow folder. Just I will go to page 4 of the bill. It is stated, be enacted by the Parliament of the Republic of Section 1 of Act 84 of 1996, as amended by Section 1 of Act 48 of 1999, Section 1 of Act 50 of 2002, Section 1 of Act 24 of 2005, Section 4 of Act 31 of 2007, and 4 of Act 15 of 2011. Clause 1, Section 1 of the South African Schools Act 1990 by amended. A. By section subsection 1
before the definition execution is underlined. Basic education means grade R to grade 12 as evidenced in the National Curriculum Statement. Benefit in kind means any benefit offered or afforded to an employee employed in terms of the Employment of Educators Act 98, Act number 76 of 1998, or Public Service Act of 1994, number 103 of 1994. Which is not a monetary benefit, including but not limited to a exclusive phone, benefit of the employee or guard services. Competent assessor means an educator registered with the South African Council of Educators as defined in the South African Council for Educators Act 2000, Act number 31 of 2000, or Qualifications Authority as defined in the National Qualification Work Act 208, number 67 of 2008. Chair, can I pause there? The entire. Is that 1A, B, C, D?
Read everything, that's on one.
All right. Clause 1, B, reads, by the substitution in section 1 for the definition of definition. Constitution means the Constitution of the Republic of South Africa, 1996, Act 1 of 8 of 1996. C, by the insertion in subsection 1 after the definition Constitution of the following definition: corporal punishment means any deliberate child comfort, however light, includes but is not limited to A, hitting, smacking, slapping, pinching, or scratching with the hand or any object. B, kicking, shaking, throwing at, bending, pushing children, and C, forcing children to stay in uncomfortable positions, forced ingestion, washing children's mouth out with soap, denying meals, heat and shelter, forcing a child to do exercise or denying or restricting a child's use of the toilet. D, by the insertion in subsection 1 after the definition of dangerous objects of the definitions. Department of Education means the national department established in terms of section 7, subsection 2, read Schedule 1 of the Public Service Act of 1994, Proclamation number 103 of 1994, responsible for basic education. Drug means any A, intoxicating or stupefying substance that has a psychological or physiological effect. B, in paragraph A, and that is possessed contrary to the code of conduct of the school, or contrary. C, substance, the possession of use of which, or the dealing with or legal authorization, or drug, dependence, undesirable producing substance, unlawful substance, prohibited substance, illicit substance, illicit drug, or scheduled substance contemplated in any South African legislation that deals with the control of medicines and related substances, with drug trafficking, substance abuse in general, and with substance abuse in sport and in any programs or policies aimed at curtailing social and sport-related substance abuse, and in any international instruments that deal with such matters to which South Africa subscribes or is a party. E, by the insertion in subsection 1, after the definition of education department, of the following definition: education district means a district in an area of a province which is demarcated by a member of the Executive Council for administrative purposes. F, by the insertion in subsection 1, after the definition of grade of the following definition: grade R means the reception grade. G, by the insertion in subsection 1, after the definition of head of department, of the following definition: home education means a purposeful program of education for a learner, alternative to school attendance, which A, is provided under the direction of the learner's parents, primarily in an environment of a learner's home. B, may include tutorial or other educational support, if necessary, secured by the parent on specific areas of the curriculum followed by the learner. And C, meets the requirements for home education contemplated in Section 51 of this Act. H, by the deletion in subsection 1 of the definition of illegal drug. I, by the insertion of subsection 1 after the definition of learner of the following definition: liquor means liquor as defined in Section 1 of the Liquor Act of 2003, Act number 59 of 2003. J, by the substitution in subsection 1 for the definition of loan of the following definition: loans mean any financial obligation based on agreement, which obligation renders a school liable for making payment in one or more installments in favor of any person, but does not include the payment of employees appointed by the governing body in terms of Section 20, subsection 4 or 5, or operational costs as determined in the annual budget contemplated in Section 38. K, by the insertion in subsection 1 after the definition of officer of the following definition: other financial benefit means any benefit of a monetary nature, including but not limited to: A, exemption from the payment of school fees to the school in respect of the child of an employee, but excluding exemption in terms of the provisions of Section 39 to 41. B, a credit card linked to an employee for his or her personal use. Or C, a petrol card linked to an employee for his or her personal use not related to any school activity. L, by the substitution in subsection 1 in the definition of parent for paragraph in subsection C of the following paragraph: C, the person who undertakes to fulfill the obligations of a person referred to in paragraphs A and B towards the learner's education at school. And M, by the insertion in subsection 1 after the definition of register of deeds of the following definitions: required documents for learners shall have the following meaning in relation to the following categories of learners: A, where at least one of both biological or adoptive parents of a learner are South African citizens, the following documents: Roman figure 1, an abridged birth certificate of the learner. Roman figure 2, the South African identity documents or cards of the learner's parents. And Roman figure 3, where either or both parents are deceased, the relevant death certificates. B, where both parents of the learner are foreign nationals and hold either permanent residence permits or temporary residence visas the following documents: Roman figure 1, the learner's foreign issued birth certificate; Roman figure 2, the learner's passport; Roman figure 3, a study visa or permanent resident permit used to the learner; Roman figure 4, the parent's passport; and Roman figure 5, the parent's temporary residence visa or permanent residence permits. C, where the parents of the learners are refugees or asylum seeker, the following documents: Roman figure 1, the parent's asylum seeker or refugee visa; Roman figure 2, the learner's asylum seeker or refugee visa; Roman figure 3, the learner's birth certificate if the learner was born in the Republic; Roman figure 4, where asylum seeker visas are provided, a refugee or long-term study visa must be provided within 3 years of admission of the learner; and D, where the learner is in alternative care, the following documents in Roman figure 1, the relevant court order granting guardianship or custody, and Roman figure 2, the learner's abridged birth certificate. Clause 1 ends there, Chairperson. I thank you.
No, thank you very much. That's the recommendation of definitions from the Department of Basic Education. I'm going to allow members. You heard what people said, you must speak. What are your views? What do you think must be amended? Or should we proceed as the department recommends? Honorable Nodata, then Mani. I'm so worried of. And then Sukars. Yes, President.
Thank you so much, Chair. Chair, just obviously you said 3 minutes on each.
3 minutes, yes.
Yes, cool. So on this particular one on definitions, I just wanted to check and get some guidance, Chair. But the proposals as follows. One, we insert the definition of meetings on this one. We know that we come from COVID times, we were forced to do online and virtual meetings. So I do think that it's important for us to insert a definition of meetings, of what that particular provision or clause could look like, that may be suggested. The second one is a definition on special needs education. As we know, we've got a component of learners that attend special needs, and there's a definition on homeschooling, for example, and what that looks like, what that means. So I think it would be important for us to make a definition of what special needs education is defined as, based on the intention of it as you look at the South African Schools Act and the Employment of Educators Act. The last one, which I need to also get guidance from, in fact, the two was a proposal to insert there. The last one I need to get guidance from before a proposal can be put on the definition is the definition on online schooling. And I see that there's a definition there on subsection, just need to get it right, subsection G, which only refers to home education, and it's very specific on what home education is. But we have been obviously aware of the different online schooling that have come through in the country. But also, you will find that in the South African Schools Act, there is no existing space where you talk about online education or online schooling in general. And would that, invoke, for example, a request of a section 16A? That's a question that, because I think it's a legal lacuna that does exist there. So I just wanted to check on that before making the proposal around that. Those are just the only three from my side, Chairperson. Thanks.
Honorable Mani.
Thank you, Chair. The Chairperson, on corporal punishment, I see the list on corporal punishment. I'm just wondering, and Chair, please indulge me because I'm joining the process at the tail end. Maybe this ground was covered. Maybe you'll educate me. When I look at this list here, and the way it's listed here, it's listed as if it's exhaustive. So it's almost like if you were to think about something else tomorrow, but it's not on the list, that thing is out. If maybe there is no way of creating a formulation, firstly, that will allow for anything that falls within this grouping, so that we don't become definitive here. And then, for instance, I'm thinking here, Chairperson, as to where do we put the issue of particularly African children that have to cross rivers to go to school? Why are we normalizing this? Why are we pretending as if there's nothing wrong with this? It's a way of going to school. Our children, they go to school. By the time they get, in fact, they swim across rivers, they walk. Some of them don't make it. They get washed away by rivers. Those that have made it, they walk until they are dry. Why is that not punishment to children? So I'm looking for a way of criminalizing that is wrong. And we can't pretend here, and we're talking about online here, when our children are barely able to go to school on foot. They have to cross rivers, and we're sitting here as legislators, and we're just blasé about it. There's nothing wrong with it. We're just on to online here. You know, our children are walking through rivers. How do we accommodate that in here and make sure that the legislation frowns upon that? There's budget for all of these things. There's all manner of things that could be done. Why are we okay that children must cross rivers when they go to school? I have a problem with that, Chair, and I think we have an opportunity in this legislation to put something that is going to ensure that when that happens, some adult somewhere sitting in a posh office must be held accountable. Thank you, Chair.
Honorable Sukers.
Thank you, Chair. Chair, I just would start with the definition on basic education. Our proposal, Chair, is that basic education be redefined, and I will. I have 3 minutes just all together.
Yes.
Yeah. Redefine basic education.
And it's actually for you.
Apologies.
Yes, it's actually for you.
Is it for me? Oh. Chair, redefine basic education means pre-tertiary education and may include education in public schools, independent education, home education, or other statutory recognized form of education. Because what if you don't follow the national curriculum, for instance, with the Montessori schools or the Sunlight curriculum, and if we can change that definition to be more inclusive. And I want to refer to Mr. Ndlebe, who in the public hearing said that that there would be freedom of curriculum choice. So that definition would certainly put a restriction on forms of education. Then the second is on competent assessor. The question that I have for the DBE is, what is the nature of a body registered with SAQA? Is it a curriculum provider? Is it a school? Can a school, an online school? And secondly, does this competent assessor, this does not include educational psychologists. And these should be added. And again, this goes back to the special needs, especially what was highlighted by the public in terms of the different tutors or assistance and support that they use, especially with special needs children. So if the DBE can give a clarity on that. Then there are various international and local benchmark tests. Will these not be added, or can it not be added to forms of assessment, to means of as a means of assessment? And then in terms of home education, in the definition, it defines home education as home. So that makes it very difficult for somebody, for instance, whose home environment is not conducive. And they are doing home education, but they're doing it, for instance, in a library, or they do it at somebody else's facility that is more suitable for the needs of a child. And this is specific to special needs children again. When we make it primarily in the learner's home, it restricts, for instance, your single mothers that have outside support, or families of homeschooling that needs to do it in a different environment because of that. In clause 2,
No.
sorry,
We are on clause 1.
my apologies, yes, clause 1.
Thank you very much. Principal?
Chairperson, once more, good morning. Allow me to utilize part of my 3 minutes accorded or allocated to me. The concern raised that physical education may be construed as a corporal punishment must be placed in its proper context, Chair. Physical education, sports, is an approved subject which is part of the curriculum and cannot be construed as corporal punishment. To include the word cruel and degrading treatment in the definition will be vague and ambiguous and difficult to establish. We believe that guidelines are bringing alternative forms of punishment to that effect. Thank you.
I take it you are speaking on the definition of corporal punishment. Ne?
Yes.
All right. So I request members just say you are speaking on this definition, because there are a lot of definitions, so that we know where we are. Honorable at once.
Thank you very much, speaking. Okay. I'll be speaking on the required documents under clause 1 on the definitions. Chair, on the definitions on clause 1 under the required documents, no clauses make the admission conditional to obtaining the documents. And by including this provision, we envisage that every learner is treated fairly and given his or her own right to dignity. And no person will be able to treat them unfairly by virtue of the fact that they do not have relevant documents. Nowhere in the proposed amendments does it state that the relevant documents are a prerequisite for schooling. Instead, the amendments clarify that any learner whose parent or guardian has not provided any required documents, whether of the learner or such adult person acting on behalf of the learner, during the application for admission, shall nonetheless be allowed to attend school, and the principal of the school must advise the parent or the guardian to secure the required documents and alert the provincial government, intergovernmental committee thereof. And lastly, Chair, the acquisition of the relevant documents will continue while the learner is admitted to the school. Thank you, Chair.
Honorable Moerane. Down.
No, thank you very much, Chairperson. And greetings to all who are in attendance. I just want to add the one on the definition of required documents. I think I'll add only one, which says not clauses makes the admission conditional to obtaining the documents. That is the view that I want to put also. Thank you, Chair.
Okay, all right, thank you very much. Honorable Madlingozi and then Honorable Boshoff.
Thank you, Chair. I would love to seek clarity on this grade R, what it means. I thought I would be seeing years, maybe being, put there like 3 to 4 years, something like that. So what does it mean actually to say like grade R in two? What year is that? Thank you, Chair.
Honorable Boshoff.
Thank you, Honorable Chair. I hope I'm.
Welcome, sorry, welcome.
Thank you very much, Chair. I hope this picks me up now. On the definition of corporal punishment, I wondered if it's not maybe a good idea to include some definition of legitimate punishment, because if I look at the sentence, means any deliberate act against a child that inflicts pain or physical discomfort, however light, to punish or contain the child. So I, in my imagination, I see my own child doing to sit in after school, saying no, but that's hugely discomfortable to her because she needs to run around. So if it may not cause any discomfort, I wonder if we should not abolish punishment altogether and say children should be convinced to do the right thing. I'm not very optimistic that that will work, but this boils down to the complete abolishment of punishment, because anything which is punishment is uncomfortable for the person to whom it is dealt. And then on the part about home education, I would suggest that we include collaborative home education, in which up to 3 or 5 families collaborate for educational purposes. I think in practice, it's very often that, say, something like a grandmother or one parent, but the cousins also collaborate or whatever. You have 2 families, maybe neighbors, maybe family of each other, and they collaborate in for homeschool purposes. In fact, it's nothing else than a homeschool. It's just that the workload is divided between more educators, home educators, and that there are slightly more children, because according to this, that would amount to an independent school, which is something quite different. Thank you, Honourable Chair.
Well, thank you very much. Those are the inputs from the members, Mr. Ndlebe, for clause 1, which deals with the definitions of a couple of words that you have used there. So we would allow you now to speak.
Thank you very much, Chairperson and honorable members and colleagues. Let me indicate that I'm surrounded by 3 legal brains from the department. In the absence of Advocate Misa, we have got the Director for Legal Services, Mr. Vickers. We've got 2 colleagues, one from the Provincial Department, to add to our comments. I'm going step by step, starting with Honorable Madlingozi, and say grade R is 5 years old. Grade 1, it's 6. So when you see grade R, we're talking about 5-year-olds. And the definition says 5-year-olds needs to be in a school. Competent assessor, Honorable Sukers, the definition there includes people that are qualified to offer education, people that are recognized as educationists. That's why you find them having been admitted by SACE. You find them having been admitted through the SAQA Act. So it wouldn't include psychologists because they are not teachers. They don't offer that service, but they do support education to happen. So it may not be a psychologist that can vouch that the child is receiving the necessary education that needs to be given to a child. Let's support the definition of meetings, if it can add it as well, because it will make sense that meetings are not only physical meetings only. Let's accept the inclusion of special needs in line with the rest of the definition, as Honorable Nodada has indicated, that other schools are indicated, homeschooling and all that, but special needs education, the definition is limited. We can request that it be added there. We didn't have something on online when we were working with this, but if we were to go into the future, the department is working on online education as well, that it will be a package of basic, of ordinary public schools, special schools, it will be homeschooling, it will be online schooling, so it's coming. So if we don't have to come back later and talk about online schooling, let's rather put it in now and request as legal services as advised that we go to Parliament and ask for permission to include online schooling as well, and it become part of that. The definition of corporal punishment here, it's limited to an interaction between a child and a teacher. How a teacher disciplines a child in a classroom or at school level. So the rest of the issues that Honorable Manya is bringing are issues outside the education department in particular, but are issues that requires the entire government. Why children are crossing rivers? Why is there no bridge there? Why are children not transported and all that? So it's not about the teacher that is dealing with the learner. And we say this is a broader discussion that requires the entire government. But our definition of corporal punishment is how children are dealt with at school level and how they get punished. The other issues that are coming from Honorable Bishop is that why, when we talk about corporal punishment, we need to be talking about punishment and not discipline. And why are we not putting acceptable processes that are allowed? So according to this definition and what we put in, our aim was to deal with the abolishment of corporal punishment, as all those definitions are in there which are demeaning to children. And what we had the public saying was that you need to come up with ways in which we talk about alternatives to corporal punishment. So that will be a separate thing that talks to positive discipline and alternative to corporal punishment, which is going to be either guideline or regulations that encourages teachers that follow this. Now that this is abolished, this is what you need to follow. And we thought it may not be possible to put it in an act and say teachers do 1, 2, 3. Because we still allow teachers and schools to come up with code of conduct that allowed that. There's also issues on home education, and Honorable Bishop, you're saying, why can't we have collaborate families coming together? And you quickly move away from that and oppose yourself and say it might lead into an independent school. Yes, if you do that, it now becomes a school. But nothing prevents families and parents to come together and do that. But the onus to have this home school recognized still lies with an individual parent. so that we don't group these parents together and say you are all accountable for ensuring that your child receives education. We want each parent to be accountable for raising up the child and ensuring that the child is receiving education. So the clapping is allowed, but the allowance of the clapping must not prevent the accountability of an individual parent, where you say, no, my grandmother will answer to this. We want that type of a thing to happen when we deal with homeschooling. There is one that Honorable Sukert also brought about homeschooling, where the definition says is provided under the direction of the learner's parent primarily. That primarily, our understanding is that it's not exclusive. It's saying in the main. So education takes place in the field. Education takes place in the library. Education takes place in the zoo, where children are taken all over the place. But primarily, it's things that happened within the confines of a home. So it's not excluding where the child can go in. Children are taken into computer centers and all those stuff. So it doesn't affect where the child might be. It's not a clause that says lock your child in the house and teach him only in the house. Probably it adds into that collaborative. Some children are even taken into classes somewhere where they meet other children, but primarily these are children not in a public school, but the parent is in charge of that. So we thought we can leave it like that because it's still covering everything that a homeschooling means. The last one were required documents. I didn't find any dissenting or any opposition to the documents that we're referring to, but we need to emphasize that the submission of these documents are not conditions for a child to be at school. But when the child is already at school, it's the responsibility of all of us to ensure that the child is registered correctly, and these documents are made available whilst the child is at school. But there were no changes in the definition. All honorable members are happy with the definition. So thank you.
No, thank you very much. What I'm picking up is that you do not really have an issue without papers are raising, except that, which I think the legal people will speak on the permission to get online education. And I'm going to allow now the state law advisor or yourself, anyone or both of you, maybe, to speak on that.
Thank you, Chairperson, and thank you to the members for the questions and the directions as we already see where to go. Chairperson, because Section 1 or Clause 1 is already part of the bill and it deals with generally all definitions that could come in. And therefore, for example, as Honorable Notata spoke to a few insertions, if those definitions were to be inserted as new definitions, there is no need because Clause 1 as definition section is already there, is already part of the introduced bill. So there will be, in this instance, specifically under Clause 1 and what could be added, there is no need to require that 2864B permission from the National Assembly. Thank you, Chair. Maybe just one more thing, Chairperson, to add. I think that members must keep in mind, as I said, it's a principal act that we are amending. So that explanatory note, which is before the preamble there, will assist the members to understand as well that those things that are bolded black, they are coming out. So it's what the department is suggesting must go, and those things that are underlined, where perhaps you would see parallel and vertical lines, it's what would be coming in. So where it might not be clear, but you see bolded things and you're like, so what's happening here? That explanatory note will guide the members as well. The advocate as well.
Thank you, Chair. Just a concern regarding the definition of basic education, that it may be too limited, that we should perhaps rephrase or redefine the term. Chair, the term is a constitutional right, and our courts, the constitutional rights are constantly being interpreted by our courts. So to have a limited definition that may eventually be in conflict with a court judgment in respect of its interpretation. So I would suggest that it's something that the parliamentary advisor and I will come up with eventually when the A list is prepared, is that what we could say is that it includes, we can insert the word includes grade R to grade 12, because having a limited definition, that is, because constitutional rights are something for our judiciary to interpret and to develop as well, Chair. Regarding the concern for the definition of corporal punishment, that the term or the definition may be too limited. Chair, the definition is in fact consistent with the United Nations Child Rights Committee's definition of the phrase. However, you'll see in the definition, it states there, it includes, but it's not limited to. So what we have reflected there is not a limited, it's not limited instances that would apply to corporal punishment. So I think that wording would cover the concern in respect of a limited definition, Chair. Yeah, that's all from me. Thank you.
Asoze niyenze lonto. Never. Anizosibuyisela umva sigqibile ngeapproach, anizuphinda ngoku nize nezinto. Fighters. Aninoze nize nefu. Ayini mansana ubhaqa meeting yami. Please.
Chairperson, I'm just worried about the. I come from a history where, as a kid, our parents were told that you start to go to school age 7, or you have to have your hand, over your head to touch your ear to start learning. Now, we know, like today, kids from the age of 3, 4, they start, their brain power is very much, wonderful, and they understand their cognitive, like usage, and must we look at that age 5, thinking that is when the kids should be starting to learn? And life is too short. We always talk about that. Life is too short, but can't we take that the starting age to be less than 5, but at least to be 3 or 4? That's my point, Chairperson.
I don't, honestly, now the hands are becoming more, are coming. And this is not what we have agreed to do, honestly. This is not what we have. Maybe also I must try to be objective by saying, Honorable Madlingozi and Honorable Mani were not part of us when we started the process throughout. So let me just clarify where we are so that you don't take us, because what you are doing now, you are taking us back. We are amending what has been there, 1. And 2, you go to your clause 1, what Sposh has been reading. We want your comment on that, on each clause, on only what she has been reading. Not your own interpretation. Your own interpretation you should have brought when we got this briefing last year, 2022. So, as andiniceleke bahlekazi ukuthi asilandeleni this approach. Silandelayo. You speak on, we are going to clause 2 now, compulsory attendance. Compulsory attendance, she's going to read. What she reads, Nina, you will say, probably you don't agree, you think that this must be inserted. So to say now, it's there now. A child will start at age 5. You can't want to use this meeting to say, at 3, This is not the right meeting for that. So please, let's stick to that approach. Fighters. Thank you very much. We are going to close 2. I'm sure both the department and our legal minds are satisfied with what has been raised. You know what you are going to do. We are done with clause 1. We are moving to clause 2. Ms. Posh is going to read out clause 2. And then I'm going to allow members to speak on clause 2. Huh? Okay.
Just a clarity, Chair. If you may remember, when we do close.
But my hand was up first, Chair. This is not fair. My hand was up first.
And it's true. My apologies. Honorable Man.
Thank you, Chair. Chair, I accept the explanation that you gave, but I think it amounts to suppression. Because, you see, if, for instance, an issue was raised, as you are raising now, let's say she has read what she has read, and then we have an issue, we raise the issue, the explanation is given, but maybe not happy with the explanation. Surely a follow-up question to close the matter should be allowed as part of that. If you said, no, don't introduce a new matter, I would understand. But the follow-up question, because the answer given was not satisfactory, should be allowed, in my view. That's the first point. The second point, Chair, as you are going to go into clause 2, I was just going to ask, as you say that we here were not part of these processes and all of that, I accept. And I would also accept that members here would have received these documents timelessly and all of that. I'm just worried that we are now going to go to clause 2 and read as if people have never read these things for themselves. Why can't we say clause 2 taken as read, and then we then take questions on clause 2? Why are we, what assumption are we making here that people did not read documents? What assumption are we making? Why are we reading line by line? Didn't people get these documents weeks ahead? Why are we reading line by line? So that's, but on the first issue, Chair, on that corporal punishment one, just to, so that I don't have to raise my hand again, just to say, Chair, that if, because that definition at a general level, it talks about something that is against a child. And I think it's against a child. It's inflicting pain. It's degrading to a child. It's doing all kinds of funny things to a child if a child has to go to school and cross rivers. And the explanation given here that, no, we only worry about you when you walk through that gate. We don't worry about you, what happens to you before you get that gate. I think that response by the department is wholly unsatisfactory. And in fact, if you look, Chair, the posture of government on housing, just to give an example, the reason government moved from housing to human settlement is because government understood the integrated approach of settling people. Now, if when we come to education, we're going to take a narrow approach and say, you are a student only as soon as you walk through that gate, but as to the hell you go through before getting to the gate, as Department of Education, I'm not part of it, find other societal solutions for that. I think it's an irresponsible posture and it should not be encouraged. And I would be saying, for instance, as part of this, is an opportunity here, Chair, we're here to fix this country. We have an opportunity here to say, if, for instance, we're going to have a river problem, then we must not have a situation where schools are built across the rivers. Maybe build schools everywhere so that you remove the need for children to cross rivers.
Your 2 minutes is up. Sukers?
Yes, Chair. I just want to say, comment first to your, to what you said when you concluded that members are fine with the definition. I just want to, for the record, say that no, the definition of basic education as it is here, I do not support that. It is in fact that definition to stay in the way that it is in the Primary Act, and for it not to be defined as grade R. So that's the one thing. The second is, in terms of corporal punishment, I just need to know, especially special needs children, there are times when children needs to be constrained in order to protect them from harm. If the definition as it stands now, if there is any other provisions that would be applicable or that would, in this context, be applicable to especially special needs children, where their care, because it says it's very specific in terms of corporal punishment, what is deemed as corporal punishment. So my question is around especially special needs children when they need to be constrained or they need to be, constrained, basically, if that doesn't impact in that definition, yeah.
You're done?
I am done,
Not
yes.
Thanks, Chair. Chair, I think you have outlined the process here. And my clarity, I was literally going to ask a clarity that we've now dealt with clause 1 on the process. The presentation was done on clause 1 with all the definitions. The members engaged clause 1. The department responds to clause 1. State law advisor, parliamentary legal services respond to clause 1. Now, in terms of concluding that process, because there's inputs that are made, some things are accepted, and some comments are made there. There needs to now be a determination as to what happens with clause 1, and then put the question to the members. I would assume that's the process, but I would be guided by that. And that's my clarity-seeking question, so that we don't leave things hanging and say, okay, everything is fine with clause 1, but there's inputs there. The state law advisor saying, look, the definition of this and making inputs on that, this is acceptable and so on. So I just want you to guide us on that. Once we've concluded that round of things, how do we deal with the clause and the inputs that have been made to conclude that clause? And then do we then put the question thereafter? How are we proceeding just on that portion so that we don't find ourselves in the situation where we're going back and back and back. Because I think some of these clarity-seeking questions are because we haven't closed some of the inputs and said, this is how we're proceeding on this, and it's done.
The issue, when I was giving over to the lawyers, I had said these are the issues that has come. 1, they need to seek permission on online education. There is issue of basic education, which both of them they have spoken about. There is issue of corporal punishment, which both of them they have spoken about. So that, in my view, not unless you would want me to say something else, those are the issues where you are bringing how you would want clause 1 to be consolidated. So not unless, and they ask who must guide, who must consolidate? Because clause 1, these are the issues that have been raised. Can you advise lawyers so that we do law, right?
Thank you, Chairperson. I think that's why you see us constantly trying to catch what you are saying. But what is going to happen from here with the direction and the deliberations as they go, you sort of give a directive as to consider that. So what we are going to do once the process is done here, Chairperson, and as you've closed each clause, we prepare the draft amendments that are now speaking to what was said, and those amendments would turn into an A list, which is still going to come back to the committee for consideration to say, okay, if you were to come up with a definition for special needs, and we do come up with it and we bring it before the committee considers that and said, no, we don't like what you've come up with, do 1, 2, 3 there and all that. So there's going to be a document that we will comply, myself and the state law advisor, which is going to then come back once we are done for deliberations, which is called an A list. And only once that A-list document has been approved by the committee, then a process which will then produce a bill for this committee, which is called the B version bill, out of the introduced bill. So the process is still ongoing. It doesn't end here. That's why we're getting direction per clause, and then we will attempt to come up with something from those directives and directions.
Are we together? Thank you very much, sis. Huh? Okay.
My hand was up, but maybe I'm just a little bit far. I just want to know if, as the lawyer told us now, if we, the madam lawyer, sorry, told us, we are having that A list with all the changes, and then we have the B version. Are we going to vote about it clause by clause then, or do we just get the bill and we say yes or no on the clause, on the whole bill? It makes a little bit of a difference. It's like eating an avocado. You know, it's still green, oh no, it's rotten yet. You don't know when to act because you think it's still coming, and then suddenly somebody tells you, no, it's gone now. You've had your chance.
Everything is to be voted on, Honorable Bishop. Like the A list, we will present it and you deliberate on it, and if you are happy, then it must be voted and adopted. Only once the A list is adopted do we then go to the next step of preparing the new bill now that will discard the current one, but be the committee bill, which will be called the B version of this one.
Thank you, Chair, for giving me.
Thank you, Chairperson. I'm Advocate Lynn Culridge-Zolls. I'm part of the task team of the Ballot Bill since 2013. So I'm just because I've got a lot of background and understanding of the interpretation of it. But what I can see is that if we, just moving forward, if we can make suggestions to help the team, like colleagues are indicating, I would suggest that, for instance, basic education, we must at least say, means grade R to grade 12, and as evidence in the National Curriculum Statement, or we can say, or any other curriculum which is not inferior to the National Curriculum Statement. And that would cover the members' comment about what about other curriculums, like the IB and so forth. And so that we could insert something that it is not inferior to the National Curriculum Statement. And then in terms of the corporal punishment, I think we've addressed the issue. It's not limited. It's not limited to what's covered in these clauses. But it covers to whatever we find, which is unacceptable behavior, obviously. But I do concur with the member, forcing a child to do exercise, I think we should insert, which is not part of the curriculum. Or we can say which is not part of extramural activities, just to help the members, just to say where we can just strengthen that. I concur with DBE and our honourable colleague here that we can insert provision on meetings, special needs education. Online schooling is a bit of a technical issue because Section 12 of the South African Schools Act only makes provision for public schools, which is an ordinary public school, a public school for learners with special education needs, or a public school that provides education with a special focus on talent. So if we talk about our online schooling, is it a different type of school, for instance? Because there is different versions of online schooling. You have blended learning, you have where learners are doing online schooling at home, or they're in an institution doing online schooling at the institution, and then in schools you also have blended learning. So I just want to mention that. So that is a an issue that we have to look at. And then just in terms of admission age for grade R, it is dealt with on page 8, where we say the admission age of a learner to a public school to grade R is age 4, turning 5 by 30th of June. I'm just saying there is some direction there for the members. Thanks, Chair.
Thank you, Chair. My name is Chris Leekes. I'm Acting Chief Director, Planning Info Advocate Mister. But I was also part of the original team that started, the drafting team that started in 2013. This is my colleague here behind me. I'm not going to repeat what Dave already indicated. I just want to make a few short suggestions on the comment made by the honourable member here around physical education. We all know that physical education is part of the curriculum and we cannot regard that as corporal punishment. So we would suggest that perhaps that can be clarified in the definition to say that forcing a child to do exercise that's not curriculum related, that should be that should be regarded as corporal punishment, but not the physical education as we know it from our school days. That's part of the curriculum. That is not part of a definition of corporal punishment. Then also just on the comment made by honourable member here. So this definition is not a closed list because it includes the words which it says, but it's not limited to. So it says, means any deliberate act against a child that inflicts pain or physical discomfort, however light, to punish or contain the child, which includes, but it's not limited to. So that wording there opens the definition up to other instances. These are examples listed here. So it's not a closed list for that purpose. Thank you.
Okay, no, it's fine then. Which it helps me then moving forward. How must we handle the flow of the meeting? So guys, can we really move now, please?
Just the issue around special needs that was not addressed, Chair, on the point of corporal punishment that I asked.
What do you want them to do? You want them to give you response now because they are saying they are going to put everything together. It goes to the A list, it comes back to us, and then we vote or not vote on the issues. Or you missed that clarity.
I asked clarity on the issue of the definition as it is being used, if it penalizes especially those people that are dealing with special needs children when they are constraining them. So I asked clarity around that. But if you feel that it's not to be addressed, then it's fine.
Can you speak on that, Cleve?
Thank you, Chairperson. If we have to understand what corporal punishment is, it's a deliberate act to inflict pain on a child, whether emotional or physical. But if this pain is inflicted in your doing a particular responsibility, like physical education, children have to do exercises. It's part of the curriculum. You're restraining a child. You're not deliberately inflicting pain as a punishment for wrongdoing. So it can't be part and parcel of corporal punishment. And when teachers are subjected to discipline because they were involved in corporal punishment, for example, there are due processes that follow in there. And these are also found in our SAYS Act corporal punishment.
So the 3H, sorry, Chair, so the 3H thing we're not going to deal with.
It's out, but it's out. That's not.
Please.
ECD.
Please.
Oh.
Education starts from from year zero until we talk of long learning. So the reason why this social development was, the powers were taken to put into basic education, is that we wanted to put the element of education, not just looking after the children. So there are programs for all age groups. Now, we start with 5 to say this now needs to go to a formal institution, which is a school. Then the others who are not 5, they go to what we call grade RR. It's also a formal year for those 4 years. And there's a program for 3 years, the twos and all that. And that goes into small creches and those that are run into houses. So there are education programs for all. But this bill is focusing on those who have to be physically in a building that is called a school and is then managed in that particular. So we say 5 is the starting age of those that we can. But the rest have programs in different places.
Thank you, Chair. I'm covered. Yeah, but is RR covered somewhere? Where is that RR? Where is it?
It is covered.
Can we break for tea? It's it's now 11:36. I suggest that we. The principal, wait.
Unofficial.
Can you?
I endangered myself any last class. First aid doesn't. I tried with the.
There's no first aid here.
No, but I damaged myself.
You must go to the secretary.
Very sharp and I don't know it.
Huh?
But I suspect this one.
They are asking for 5 minutes to bring the tea, but we can scratch a bit. We are coming back at 12. 12, we are starting with clause 2. You are in, you are out, we are proceeding. Asiqhubekeni, people of South Africa.
Let's move.
No, I think clause 1 took some time because procedural. Now we've got the procedure of how are we going to move. And I think clause 1 is the longest clause anyway, because it's bringing all the definitions that the department is using. So at least now see a graplisha. We learn, we crawl, we stand. At least we are getting some sense of some confidence. Asien to clause 2. Fighter.
Thank you, Chair. No, Chair. Without taking you, without taking you back, just by ways of a way forward, having had all the various explanations that were given by the technical people here, that I was going to propose, Chair, if it's allowed, that this ECD thing, which worries me, that we have described outside this Bella bill that we're dealing with today, just as a proposal, that is there no way maybe that the technical people can look into integrating it as part of this process, because what we're going to have if we don't do that, we'll look at a situation where maybe 10 years, 20 years down the line, then we remember again that, hey, by the way, this is actually part of education. Why is it sitting at social development or somewhere? Why is it not here? So I'm just saying, it looks like we have a perfect opportunity now to integrate the two, but I just want to propose, Chair, that maybe something that from where you sit, you can perhaps give direction as to how we can process it. Thank you.
I don't think we must waste time on it. What I think we need to do, for some reason, Fighter, it makes sense because ECD shifted last year, the function, the basic education, and this bill must have been long there, so it never considered it. So now would be our advocates there, you also get permission, because anyway, you're going to have to come back and insert it. They are now your baby, the ECD. So I think we must just say that you just put it as like the issue of online, you just put also the issue of ECD. I think on this clause, the mandate of the fighters is the 3 to 4 year olds. They must be considered. Or from birth. From birth. No, thank you very much for that input, Honorable Mani. Our legal minds are going to insert that. Let's move to clause 2, support. And I want to clarify to you that we are reading also in Parliament. You see, most in Parliament, they read. So we got the documents, but it must be read because we are dealing with it. Thank you.
Thank you, Honorable Chair. Honorable members, we are now going to look at clause 3. Sorry, my apology. The amendment of section 3 of Act 84 of 1996. Clause 2, section 3 of the South African Schools Act 1996 is hereby amended by clause 2, subsection A, by the substitution for subsection 1 of the following subsection. 1. Subject to this act and any applicable provincial law, every parent must cause every learner for whom he or she is responsible to attend school starting from grade R on the first day of the year in which such learner reaches the age of 6 years and not leaving school until the last day of the year, in which such learner reaches the age of 15 years or the 9th will complete grade 9, whichever occurs first. Provided that a learner who will turn 6 years after 30th June must start attending grade R the following year. Clause 2, subsection B. By the substitution for subsection 6 of the following subsection. 6. subject to this Act and any applicable law. A, any parent who without just cause and after written notice from the head of department fails to comply with subsection 1, is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 6 is getting out to 12 months, or to both a fine and such imprisonment. Or any other person who without just cause prevents a learner who is subject to compulsory attendance from attending school is guilty of an offence and liable on conviction to a fine or to both imprisonment for a period not exceeding 12 months, or to both a fine and such imprisonment. And C, by the addition of the following subsection, 7, any person who unlawfully and intentionally interrupts, disturbs, or hinders any school activity, or hinders or obstructs any school in the performance of the school's activities, is guilty of an offence and liable on conviction to a fine or to imprisonment for a period not exceeding 12 months, or to both a fine and such imprisonment.
Thank you very much. That is close to attendance. Can I note members? Would want, or should we pass? Honorable Boshoff, Honorable Sukers, Honorable Nodada, Honorable Moerane.
Honourable Chair, thank you. I remember it was under consideration several times during the public hearings, and the risk of homeschoolers which were not properly registered and so on being imprisoned, and I think some of the parents and even children also mentioned that in the public hearings in the provinces, and that might really prove to be a problem. What I want to say actually is this is very wide, and also it's a very harsh penalty. I mean, couldn't this be, delineated a little bit more to say, a willful obstruction? Because I know when we were in public participation, they said, no, but it's about, somebody blocking the school in a protest or something like that. But that's not what stands here. Thank you.
Sukers?
Thank you, Chair. In terms of the clause 2 and the making grade R compulsory, there's an issue that was raised several times in the public hearings, and it's the issue around the socio-economic impact assessment, socio-economic impact assessment. And the problem in terms of the socio-economic impact assessment to ECD is that it is only concerned with the financial impact on the state. It does not look at the financial impact that it would have on other sectors, or like, for instance, the public. And if there is, then the DBE can maybe respond to that, because it will have the unintended consequence, of course, if you make it compulsory, that we do not know. The research is lacking from DBE side in terms of ECD. We do not know how many grade R programs are not conducted at schools. The ECD census does not cover grade R, and it is estimated that grade Rs are 95% of grade 1s, but there's no research to prove it. We also do not know how many parents would choose to homeschool their grade R learners. And if the clause is adopted, we will potentially then have the issue that was raised by Honourable Boshoff, that you're going to have thousands.
I'm calling him to order. Principal, order. Apologies, Sukers.
I am apologies. But she did not even hear what I said.
No, but you are. Yo. Proceed.
I apologize to the House, not to her.
Eish. You must join the red things. I think you must belong there.
Can I continue? Is
Yes,
there-
please.
So you will have a backlog of registrations when you have parents that opt to homeschool their grade R's. And we know that currently there are backlogs in provinces around homeschooling registrations and the processing thereof. The compulsory, if we extend the compulsory education age to grade R, from all grade Rs will then have a right to basic education. And it is a issue that I actually have with the previous definition, because they can then enforce that they, have a right for immediate, for education. And the state will have to realize that right. And this is a principle that comes from the Juma Mujid case. And Parliamentary Legal Services can possibly provide us with a statement or an opinion if this is correct, and how this will impact the bill. Then lastly, I also have a concern. Then when we put the bill through, any grade R program that is not at the public school will need to be registered as they are educational institutions in terms of section 29(3)(c) of the Bill of Rights. So how many programs are there? Has Parliamentary Legal Services perhaps considered this point, and can they perhaps provide us with a written opinion or a report on, and have the impacts been considered in a social environmental impact assessment? Thank you.
You have to talk, Mrs. Baba, otherwise it's not that. Makacemo sukars. Not that.
Chairperson, can you protect me from Honorable behind me? Thank you so much, Chair. Chair, I think, obviously, I've allayed my fears before, and that's precisely why I requested the department to give us a presentation of what would be required to make grade R compulsory financially. And obviously, we'll wait for that National Treasury report on the assistance of making sure that, we've got enough teachers, infrastructure, food in front of those children. But in terms of this particular clause, I just wanted to ask a question. The rationale behind increasing, because there's a concern from parents when we were doing the public hearings, that if grade R is compulsory or mandatory, it's commendable that we want to take children to school. I mean, I think it's a noble thing to make sure that children are at school at a very early age, so that we don't have the reading crisis problems that we have in modern day. But also they are in a protected space. But the question that remains is, what recourse mechanism exists for parents that don't take their children to grade R at that particular early age and choose, for example, to either homeschool their children or keep them back because maybe they may feel that they're too young or safety reasons. I mean, we live in different societal environments, and I think the reference, for example, to crossing rivers and all those things were made. So what recourse mechanism? Because I know that you put just cause. Just cause there is very broad. So what recourse mechanisms does a parent have that chooses maybe to either alternatively not take their child for whatever reason that exists in that school, and how do you then determine that? And then the second thing is that the penalty of saying you don't take your child to school is increased to 12 months. Has anyone ever been arrested for not taking a child to school when it was 6 months? So what's the rationale behind increasing this thing to 12 months? And do we think really that is the best way possible to deal with the issue, with the situation whereby a child is not taken to school? Or should we be thinking about a different recourse mechanism? Because if no one has ever been arrested when it was 6 months. I mean, why must we increase it, and what's the rationale behind it? And I think that will inform us as to how do we deal with grade R. But I think it must be noted that it being mandatory and children being sent to school is a commendable one. And so long as we don't find ourselves in a constitutional dilemma where we can't fund or realize that particular right or meet the obligation in law that we put there. And then the two questions that I've asked around just cause as well as the recourse mechanism for parents that choose to take a different route. And this one of putting parents to jail, it's really a questionable one for me. Thanks, Chair.
Okay. Honorable Morane.
No, thank you very much, Chairperson, for the opportunity. I think already DBE has clarified, because the matter of grade R has been brought in, that grade R is 4 years turning into 5 by 30 June of the year of registration, and grade 1 is 5 years turning 6 by the end of June of the year of registration. I must indicate, Chair, that the SASSA already has a penalty clause. Increasing the penalty provision does not target a select group of parents, but applies horizontally to all parents who prevent the learner of compulsory school-going age from accessing education equally. In an attempt to address the high learner dropout rate, it is anticipated that by increasing the penalty provisions serves as a deterrent for those parents who prevent the learner from attending school. It does not discriminate against any parent. A penalty clause is legislated, gives the courts the power to prosecute a person who transgresses the law. Based on that, I also submit that subclause 6 has a deeming provision which provides for the registration being automatically approved after 60 days of submission to the HOD, provided that there is a proof of having submitted the application of submission and registration. Thank you very much, Chair.
Okay. That is close to DBE.
Thank you, Chairperson and honorable members. The clause will not affect home scholars. The issue of home scholars is just proof that the child is receiving education. That is what is important. Now, there's no way that a child that is receiving education at home will have a parent being subjected to the conditions of this clause, because we worried about basic education and that the child is receiving education. This clause has been put there specifically for those parents who will refuse to take children to school even when conditions allow it to. There are still children, especially those with physical disability and mental disabilities, that are locked into houses by parents, and parents refuse to take them out and allow them to receive a little bit of education. There are also parents that follow particular sects that will deprive children from going to school. So these are the parents that we're looking at. But the parent who says, I will educate my child, we know the child is receiving education. That parent cannot be arrested. Remember, there's a rule of law in South Africa. Any parent who might be suspected of violating that act may not just be arrested and locked up without due processes being followed. Obviously, reasons have to be sought why the parent is unable to take the child to school. Probably it's Honorable Manya's problems of the rivers and all that. So if that is the case, that the parent feels the child is too small to can cross these rivers, I'm waiting for him to grow up a little bit. There is a reasonable response there, and obviously the court of law will understand, because it's not the education of department that will be sentencing people, but the court will have to adjudicate on why the child is not taken to school and what will be the reason of that. So when you look at other institutions outside the school itself, What are we fighting for here? We're fighting for the fact that a child who's 5 years must begin to receive formal education. And we're not saying this formal education can only be accessed in a government institution. Hence your question, Honorable Nodada, that what happens to these institutions outside the ordinary public school space? If they are registered, they are offering a curriculum and the children are learning, then it means as long as we know about it, children are learning, they cannot be subjected to this clause as it stands now because education is being given them. It covers the issue of parental choice. The parental choice that says, for now, I'm homeschooling. For now, I'm taking him to that independent school. And as long as we prove that these things are happening, the law, this clause does not respond to that child. The rationale between 6 years and 12, it's a matter that honorable members can guide and say, we as politicians feel we want 12 or we want 6 and we can debate about it, we will accept it. All we're interested in is that parents who are not taking children to school when they're supposed to be taken to school, something must happen there so that we become that society that enforces basic education to be applied at all costs. The first section, Chairperson, that talks about the ages and all that is a bit confusing. And let us accept as the department that it's messy. And we want to correct it. The legal brains are here. For a child to be a grade R, the child must be 5 years old. And it's a child that is 4, turning 5 by 30 June. When a child goes to grade 1, the child must be 6 at the year of registration. So it's a 5-year-old that is turning 6 by the end of June. That will be in grade 1. But what we have there is a confusion between the age of registration and the compulsory school going age. So we're mixing the two, and it has been confusing the sector for a very, very long time. When you look at the compulsory school going age in the current SASA, it says 7, which means children needed to be at school by 7 by hook or by crook. But there's a school going age which is not 7, which is 6 for grade 1. So people read the compulsory school going age and confuse it with the age of admission. And these are not two similar things. The one that talks about compulsory, it means a 7-year-old child should have been at school by hook or by crook. And then you become guilty of this offense. But when do you take a child to school? That's an age of registration. So for grade R, it's 5. For grade 1, it's 6. So this needs serious cleanup by ourselves and the members. And then we need to differentiate between that compulsory school going age and the age of admission. Thanks, you.
And maybe
so. Why? Actually, you know, for the function, you could make it 21 days, and it would have the same deterring effect or not, because the poor lady who has a child to beg for her will not be deterred by 14 years in jail, no more than by 6 months or by 1 year. It's just a survival strategy. She'll do anything to survive.
At the expense of the child.
Exactly. I don't defend that. I hope that's clear. Thank you. Okay, it should be clear because now I said so.
What happened? Can you share the joke, please? We did not catch. No, Chair, thank you very much. I think honourable members have expressed their views emanating from their own different background and the society that they live in. But I think one member indicated that we are here because of the interest of the child, not of our own different interests. And if a child is not given his or her right, of which is to be in school, it's criminal. And if there's anyone or anything that is standing in front of, you know, the rights of a child, then it needs to be attended to. I do support that the 12 months, even though we feel with the Honourable Mani that is little, for now let's stick to the 12 months. We agree with the 12 months, Chair. Thank you very much.
Okay. Clause 2, let us say that on everything that has been raised to our legal people, I think there is a proviso which we've agreed we are going to take out. I think you will have to look into that. The one of the issue of age. We will have to deal with that. But this issue now, and unfortunately again now you will just have to go with what politicians are saying on the issue of the penalty. But I want to bring to the attention of everybody that the country would not be. In fact, it is happening now that you are penalizing them, those who don't take their kids to school. But just to benchmark with other countries, in Jamaica, for instance, they are convicted for 14 days. In Bahamas, it is 1 month. In Nigeria, it is 2 months. In Malaysia, it is 6 months. In California, it is 12 months. In Singapore, it's 12 months. And in England, it is 3 months. So we are not doing something that other countries are not doing here. And I think then we are going to take a decision that is going to be 12 months. That is what you are going to put. Let us move to clause 3.
Agree.
Clause 3. Clause 3 is monitoring learner attendance.
Honourable members, clause 3 is on page 7. In section of section 4A in Act 84 of 1996, clause 3, the following section is hereby inserted in the South African Schools Act 1996 after section 4, which relates to monitoring learner attendance. 4A, subsection 1, the educator, principal, and governing body are responsible for promoting and monitoring the attendance of learners at school. 2, the governing body must ensure that the code of conduct for learners contains rules dealing with punctuality and regular school attendance. 3, if a learner is absent for 3 consecutive school days without valid reason, the class teacher concerned must report the absence to the principal. 4, The principal must, within 24 hours after being informed of the absence, investigate the matter by making a reasonable effort to contact the parent of the learner by whatever means are suitable for the circumstances of the school and the family concerned, and report the matter to the governing body of the school for further intervention.
Thank you very much. It's very clear. Very straightforward. Any member? No, Tata?
No, Chair, I think it's a straightforward matter. It's clear. Because obviously we've got a massive issue of dropouts and about 3.8 million youth not in education, employment or training. I think as much as the clause is strong, more of the problem may be rest in the systems that exist for them to be able to use this. But the clause in itself, as written, is acceptable. But I do think that there may be a further investigation in terms of the tools that can be used for principals and the school itself to be able to track dropouts. That's the only comment that I would have had, Chair. Thanks.
Oh, the what? The principals to be? Just repeat that.
I just said, Chair, that it would be important to investigate the tools that are given to the principals and the schools to be able to track these particular dropouts. Yeah.
Okay,
So
no,
I think it's a much more an administrative issue, but the law itself is very
fine.
clear.
Principal?
Chairperson, thank you very much. Maybe for the first time, let me support what Honorable Nodata is putting forward, but add that maybe his fears could also be addressed by the point which would say, let's also request the strengthening of the role of parents in order to address that. Thank you.
Okay. Mani?
Yeah, thank you, Chair. Not necessarily that I have a problem. I just maybe can just get clarity. What was the thinking involved to say report the matter to the governing body as opposed to, for instance, maybe the head of department or something? Just the thinking, not that I am opposed.
All right. DBE? Oh, sorry. Sorry, Honorable Matango, sorry, I did not see your hand.
Thanks, Chairperson. I'm also wanting to find out what, why 3 days? Why don't fewer days than 3 days to report it? Because in the day that we live in, 2 days is more than enough, for the teacher to be finding out where the learner should be. Let's make it lesser days than 3.
Okay.
Thank you, Chair.
DBE?
Thank you, Chair. We accept the request to invest on the tools to deal with this and strengthening the role of parents in playing around that. 3 days, it's suitable for us because even at work, if one is absent for a day, it's taken that you might be ill, so we give you an opportunity again, we see tomorrow, but on the 3rd day, that's when we start raising an alarm to go and investigate what the challenge might be. So it can't be on a day-to-day. It's a very big administrative challenge for us to do that. So 3 days, it's suitable.
Okay. Yes, ma'am.
Chair, we just want to refer to 4 capital A3. Currently, as it reads, it says if a learner is absent for 3 consecutive school days without valid reason, the class teacher concerned must report the absence to the principal. Jay, this is actually the parent's responsibility. This is part of parental responsibilities. If a child is not at school, the parent must report that to the school and to the principal. So we want to suggest instead of the class teacher must report the absence, that the parent of the child report the absence to the principal.
No, you see, This is your law. Don't confuse us, please, with all due respect to.
Yeah.
This is you. We are discussing your things here. Now you are changing. Yes. No, don't do that.
Okay.
Don't do it.
It's fine. It's fine. You can leave it, Chair.
Yeah. Thank you, Chair. Can I give to the lawyers that side? Agree? Yeah. We agree with clause 3 days. Honorable Martin Bosi. Martin, they will look into your tools administratively. Clause 4.
Amendment of Section 5 of Act 84 of 1996 as amended by Section 2 of Act 50 of 2002. Clause 4, Section 5 of the South African Schools Act 1996 is hereby amended by A, the substitution for subsection 1 of the following subsection 1. A public school must admit and provide education to learners and must serve their educational requirements for the duration of their school attendance without unfairly discriminating in any way. B, by insertion after subsection 1 of the following subsections, 1A, in facilitating the admission of learners to public schools, the minister must establish a national intergovernmental committee within 12 months after the commencement of the Education Laws Amendment Act of 2022. 1B, a member of the Executive Council must establish a provincial intergovernmental committee within 18 months after the commencement of the Basic Education Laws Amendment Act of 2022. 1C, the function of the provincial intergovernmental committee is to provide assistance to public schools that refer cases of learners who have not submitted the required documents to the school, and such assistance shall include acquiring the missing required documents in respect of such learners. 1D, the function of the National Intergovernmental Committee is to monitor and evaluate the progress of the Provincial Intergovernmental Committee in obtaining documents for learners and to provide assistance when necessary. 1E, the National Intergovernmental Committee and Provincial Intergovernmental Committee will include representatives at the level of Chief Director from departments, including A, paragraph A, the Department of Basic Education, B, Department of Social Development, C, Department of Home Affairs, D, Department of Justice and Constitutional Development, E, South African Police Services, F, Department of Labor, Department of Employment and Labor, G, Department of International Relations and Cooperative Affairs, H, Department of Health, I, National Treasury, and J, Department Statistics South Africa. 1F, the meetings of the National Intergovernmental Committee must be chaired by the Director General or by a person designated by the Director General, and the meetings of the Provincial Intergovernmental Committee must be chaired by the head of department or by a person designated by the head of department. G, any learner whose parent or guardian has not provided any required documents, whether the learner or such adult acting on behalf of the learner during the application for admission shall nonetheless be allowed to attend school, and the principal of the school must advise the parent or guardian to secure the required documents and alert the provincial intergovernmental committee thereof. C. By the subsection in subsection 4 for paragraph A of the following paragraph, subsection A, the admission age of a learner to a public school to grade R is age 4, turning 5 by 30th June in the year of admission, provided that if a school has limited capacity for admission in grade R, preference must be given to learners who are subject to compulsory attendance. D. By the subsection for subsection 5 of the following subsection 5, subject to this Act, any applicable provincial law, the admission policy of a public school is determined by the governing body of such school, provided that A. The head of department, after consultation with the governing body of the school, has the final authority, subject to subsection 9, to admit a learner to a public school. B. The governing body must submit the admission policy of a public school and any amendment thereof to the head of department for approval. C. The head of department may approve the admission policy of his public school or any amendment thereof, or may return it to the governing body with such recommendations as may be necessary in line with the circumstances, together with reasons for such recommendations. D. The head of department, when considering the admission policy or any amendment thereof for approval, must be satisfied that the policy of the amendment thereof takes into account the needs in general of the broader community in the education district in which the public school is situated, and must take into account factors including but not limited to Roman figure 1, the best interest of the child, with emphasis on equality as provided for in section 9 of the Constitution, and equity. Roman figure 2, whether there are other schools in the community that are accessible to learners. Roman figure 3, the available resources of the school and the efficient and effective use of state resources. And Roman figure 4, the space available at the school for learners. And E, the governing body must review the admission policy determined in terms of this section every 3 years, or whenever the factors referred to in paragraph D have changed when circumstances so require, or to the request of the head of department. E, by the insertion after subsection 5 of the following subsections, 5A, the governing body of each public school must, within 30 days after the commencement of the Basic Education Laws Amendment Act of 2022, submit the admission policy of that public school to the head of department for approval. 5B, the head of department must respond to the governing body as contemplated in subsection 5, paragraph C, and subsection 5A within 60 days after receiving the admission policy, failing which the admission policy will be regarded as having been approved by the head of department. 5C, when a public school has, as contemplated in subsection 5, paragraph B, and subsection 5A, submitted its admission policy to the head of department, such admission policy will be regarded as valid of the school during the 60-day period referred to in subsection 5B, or if the head of department responds to the school's request for approval of the admission policy before the end of the 60-day period, until the earlier date on which the head of department responds. 5D, the governing body of each public school must, after the commencement of the Basic Education Laws Amendment Act 2022, submit any amendment to the admission policy to the head of department for approval, and the head of department must respond within 30 days after receiving the amendment, failing which the amendment will be regarded as having been approved by the head of department. F, By the substitution for subsection 9 of the following subsection 9, any learner or parent of a learner who has been refused admission to a public school may appeal against a decision to the member of the Executive Council within 14 days of receiving the notification of their refusal of admission to the public school. And G, by the addition of the following subsections. 10. If an appeal contemplated in subsection 9 has been received, the member of the Executive Council must, within 14 days after receiving such an appeal, consider and decide on the matter and inform the learner or the parent of the learner of the outcome of the appeal. 11. If the governing board is not satisfied with the decision of the head of department as contemplated in subsection 5, paragraph C, the governing body may appeal against the decision of the member of the Executive Council within 40 days after receiving the decision of the head of department. 12. If an appeal contemplated in subsection 11 has been received, the member of the Executive Council must, within 14 days after receiving such appeal, consider on the matter and inform the governing body of the outcome of the appeal. 13. While the member of the Executive Council considers the appeal, the admission policy shall remain valid and applicable, and only the provisions that are subject of the appeal shall be suspended pending the finalization of the appeal process.
That's clause 4, admission to public school. Can I note and dear, police. No, what's it? I think that we look at the bill in the department. We looked at 4B. It might not be implementable. We may not have control over other departments. We then agreed in the department that when this is debated, we can even upfront as the department recommend that we just do it away, because intergovernmental relations of course is there, but we cannot have a formal structure that basic education will control other departments. Thank you. I think we have captured that. They are coming to say, we've made a mistake. So they are removing 4B. So we need not to speak on the intergovernmental relations. Boshoff, Van Zyl, not that. That the principal.
Thank you, Honourable Chair. There are many details in which one can go into, but I want to make two overarching statements. The one is that this whole section implies a huge bureaucracy. To be able to receive all these policies, to process them, to give feedback within 60 days, either one is going to stick to the idea that if the head of department hasn't responded by 60 days, then it's a policy, then we could have left it just as well, because he's not going to be able to respond in 60 days, or he's going to have to employ a whole army to help in processing this. And that has not been discussed in the fiscal implications, which the department discussed with us yesterday in a non-formal meeting, when there wasn't when we didn't co-rate anymore. So it's going to have a huge bureaucratic implication, therefore a huge fiscal implication, and then something else happens, which is actually the case already, but it is entrenched by this, and that is that the department acts as both a service provider and a regulator. Now, in all other sections or sectors of the economy, like energy, like broadcasting, communication, we started to divide regulation and service provision. Back in the days, ESCOM was everything about electricity. The provider, the regulator, the lawmaker, it was a god of electricity. Now it's not so anymore. It has to listen to NERSA these days. Now, this is my two, we can go into all the little points, but these two things, we are legislating into existence either something which is not going to happen or a huge bureaucracy for which we'll have to budget, and we are entrenching the entangling of regulation and service providing, which should actually be separate or distinguished from one another in separate institutions. Thank you, ma'am.
Thank you, Chairperson, Ma'am Chairperson. I want to talk briefly on 4 subsection C, further A. It talks here about the admission. Now, I know it was touched on earlier in clause 2, but I want to talk, and it says the admission age of a learner to a public school to grade R, it's age 4, turning 5 by June 30 in the year of admission. So if you do your maths and your calculations on this specifically, your child has to go to grade R, age 4. Now, the same rivers that we've been speaking about and the distances that the DM said about, it becomes 6 kilometers, you have to send your child on her or his merry way at age 4 to walk those 6 kilometers, to walk through those rivers. This means that in matric, the grade 12, you will be 17 exiting, and the next year only you'll be 18. I don't know when this has changed or how this has changed, but for me, this is a very young age. Even if you think about the special needs that was also mentioned here, I think Mr. Ndlebe actually spoke about the special needs children when we spoke about the criminalizing, that these children must go to school. Same, at age 4, you need to walk to school because the transport is not necessarily there. Same with farming schools. These are few and far in between, which means that you have to send your child at age 4 to a hostel. So for me, the starting age is too young. I know it's contrary to what the river walkers have said, but for me, age 4 as a starting point is extremely young, exiting school when you are 17. Thank you, Chair.
Noted.
Thank you, Chair. I don't know whether Honorable Letsie behind me took a picture and sent it to the DM about this intergovernmental thing of my notes, but we'll leave it as such. I'm glad well, he's sitting directly above my shoulder. Now I must shift a little bit, but I'm glad that that's removed. Chair, I think obviously on that one we would be compensating for the work of another department, and I'm glad that the department has noted that you can't control, and it shouldn't have been on there to begin with. But speaking to clause 4 in its entirety now, just on principle, this is a clause that for me requires a legal opinion or an opinion from the legal team, because it's one of those clauses that may have a constitutional implication about the separation of powers. And I want to put it this way, that it's important for us to recognize that school governing bodies have a fundamental role to play. So they are actors in this situation. And in this entire clause, we should simply retain the status quo of saying school governing bodies must determine the admission policies, because they are the one who's well vested about the capacity in that particular school. They are the ones who are vested in the community in that school, because the school governing body is constituted by parents that come from that particular community, by learners, by the teachers in that particular school. But what we should say, that the appeal mechanism that is there should exist when admission policies are being used by a particular school for whatever reason that may be discriminatory to other learners. And I think that the appeals mechanism is the most important part in this one. But the status quo should remain rather than this all administrative burden. I mean, the HOD is being required to approve every SGB admission policy, which will be extensive, and I think we know already the administrative burdens that exist. as well as the practicality of this requirement should be interrogated. I mean, it's practically impossible to do that. And I don't think that we would be doing justice if we agreed for the department to be a player in approving a policy and then being a referee, again, when the policy is being challenged. I think the principle of separation of powers becomes important. And that's why I'm saying there needs a constitutional opinion or constitutional implication opinion or separation of powers opinion legally on this. Now, consideration may be given to changing who the appeal is made to, whether it be the HOD or the MEC in this case. But I think in existing legislation, it may be the MEC that you appeal to when a child is not administered at a school. So the alternative clause that I would like to propose on this one, rather than what we've been provided on clause 4, is to say that let's retain the status quo of school governing bodies having full power over admission policies. An appeal mechanism then remains, and then the appeal mechanism, we then determine whether that goes to an HOD or an MEC. What we can never run away from is that there are some schools that utilize admission policies to exclude certain learners. And it then becomes the responsibility of the department to then make sure that there's a recourse mechanism for those parents when a complaint is given to the department that this particular policy of this school has put together a policy that is exclusive to certain learners, and therefore they are challenging it. And I think there then you have a situation whereby you leave the parents and the community that knows what is best for their school to determine that policy, but have an interventionist mechanism from the department. Thank you so much, Chairperson, on that one.
Thank you. Principal?
Leader Studio, thank you. And thank you for this opportunity that one must talk to this contentious policy as is. But for starters, let us agree, Chair, that this is one of those contentious clauses where our audience during our public hearings expressed themselves either for or against. I think that's an area where we must draw reference that we are not just talking to it as is, but people talked about it. Or, I mean, for or against. Number one, as people or our audience spoke, they expressed that this policy has been illegally used by a number of SGBs to exclude some learners from accessing some schools in one way or another. I'm quoting what the audience were saying before I come and say, I think we have to do this or not. Number two, they were also honest to say some policies, of course, SGB policies, are so selective in the sense that they select learners on the basis of language, academic performance, sporting achievement, you can name them. Very selective in their nature. Number three, one of the reasons for amending the SASA is to align it to the recent court decisions and to ensure that due processes are followed in any decision taken by the HOD. I'm quoting what people were expressing as they propagated for this amendment. The HOD may only disapprove a policy if he follows the steps as set out in the Act. They further indicated that the SGB cannot be the player and the referee on its own policy. You can't make a policy and later on you declare yourself that you must adjudicate on it, you play, and at the same become a referee and a player on it. In the Rivonia judgment on appeals to the Constitutional Court, the majority of the bench concluded that the HOD had the power to admit learners. In other words, it was an empowerment and in a way agreeing to the amendment as put. I can go on and on, but because of your 3 minutes, let me indicate that sometimes it becomes very necessary, Chair, that we must accede to change. I know for certain personally, change is pain. Change is inevitable. Change is dynamic. Change is, I can go on and on if you did not give me 3 minutes. Let me conclude by saying, you see, when addressing change in America, Sir Abraham Lincoln ascending his podium as the President of the United States of America, he said the following, I quote, "The dogmas of the quiet past are inadequate for the stormy present." I close the quote. What did he mean? He meant there comes a time when we must change things if we realize that things are no longer working for us. And this admission policy, which is currently in use, is a trouble to our communities. And therefore, I propagate that it must be amended as proposed by the Department of Basic Education. Thank you very much.
Chair, I want to, from the onset, Honorable Madata, indicate that I did not take a photo of your laptop and give it to the Deputy Minister. I think what they did, the department listened to the inputs of the people during the public hearings, and they are self-correcting, which is good. So I also want to say, Chair, that Honourable note that I can't say the department they want to propose a law and implement it as it may. So it makes them the referee and the player at the same time. And on the same sentence, he suggests that the SGB must be the player and the referee at the same time. So it doesn't make sense. You can't say the SGB must exclude the admission of a child and you must appeal to them. I mean, what is that? It doesn't make sense. So the appeal goes to the department, which is what the bill seeks to say, and want to agree with the principal. In fact, on the Ribonia judgment that the principal made mention of, it's not a fallacy. There's a judgment, that the majority of that court concluded that the HOD must indeed have the powers to admit an excluded learner by these naughty schools. There are many, it's not a handful as it wants to be portrayed in this meeting. There are many of these schools. I mean, where I come from in Gauteng, towards the north, from Centurion going up, I'm sure they've got almost 3,000 of these schools that continuously, over 2,000 of these schools that continuously exclude some of these children, most importantly based on their ability to pay school fees. But on this judgment that I want to make a point and sit down, this judgment principal held that the SGB may, in terms of the Schools Act, determine capacity as part of its admission policy. However, this power is subject to other provisions of the SASA, which state that the department maintains ultimate control over the implementation of the admissions decisions. Further, the provincial regulations afford the HOD specific powers to overturn a principal's rejection of a learner's application for admission. The court held that the capacity determination as set out in the school's admission policy could not inflexibly limit the discretion of the of the HOD. So what the department is asking with this, which I agree with, is that we must implement the court's judgment on what is it that must happen. So I rise here to emphatically support the amendment by the department as it is. Thank you very much.
Yes, Chair. Mine is comments to make, and I think also to ask. The one is that my children, when I moved to the Western Cape back from Cape Town, I am one of those people that was affected by Clause 44. My children became English. We Afrikaans, they had to become English. So I know materially how it feels when this is used in a discriminative way to keep children out of schools when people move into areas. I've experienced it myself. I fought this fight for a long time. So, but it is not the way for us to do it in this way, because it is bureaucratically heavy, it's administratively heavy. And I do think that we need a national dialogue on this issue. I think what the emotion around this shows us that we need another Codesa moment. And maybe the Codesa moment or the moment for reconciliatory forums is, yes, our schools, to have those moments. It needs a national dialogue, Chair, and I think we need, the ask that I have is to broaden to allow for a public school to become a private school. But in terms of the way the amendment stands now, it gives more work for officials. We have more officials, and it ultimately will have a material impact on the outcome of our education. Thank you.
Thank you, Chair. Sorry. Thank you, Chair. Yeah, Chairperson, I think maybe the department didn't say this loud enough, that this, what they put here, is really a summary of what the people on the ground are saying. And some of us that are on the ground can relate to why we have this and all of that. We know of the various racist SGBs that are out there that are making it difficult for our children to act, even if you live in the same area. Initially, they would say, no, you're not in this area. Even if you're in the same area, they find another reason why to exclude you. So I really don't think we should be wasting a lot of time on this Chairperson and betray the mandate of the people. People said government must fix this, and this is what we're trying to fix. We're not going to have a situation here that we're told about bureaucracy and all of this to try and frustrate this progressive submission here. So from where we sit, we think this submission seeks to correct the problem. Those public hearings, we may not have been in these rooms at that time, but we watched them. We've heard people talking, we've heard people raising these issues. The department has done a great job here in putting this together and saying, this is what the people have said. So we can't sit here now and betray the mandate of the people. The people have spoken. Ours is to make it happen. Thank you, Chairperson.
Chairperson and members, the Constitution calls for basic right to education, and the Department of Education is the custodian of that clause of the Constitution. I know we can talk about separation of powers and how we share powers with the SGBs, but the responsibilities and the accountability of that clause are not equal. When a child is not at school, nobody will ask an SGB why the child is not at school, but it is the department that must account and ensure that every child is receiving education. We can't compare the role of the SGB vis-a-vis that of the education department and compare it with ESCOM and service providers and all that, the Department of Basic Education is not a service provider, it's a custodian of the education of every child in the country. The powers that the SGB has cannot be compared to the powers of the education department. What the clause seeks to achieve here is that we're still allowing SGBs to determine these policies. It's their responsibility. We're sharing this responsibility. But the clause is saying the head of department must have a final say on what the SGB has come up with. Powers are separated. There need to be an authority. We can't be equal when it comes to that because one of the organizations needs to have that power. The SGB cannot be given all the powers and the authority to develop a language policy and at the end be the only ones that can have a say on it. Somebody else needs to deal with that. It's like the department has outsourced its responsibilities if it says SGBs determine this policy and run with it. Where we want to concede, and probably we'll have a discussion with legal gurus in parliament and ourselves, is the administrative burden that has been raised, especially by members of the communities there. The issue of saying submit within 30 days and all that, we're beginning to see that the risk under that, because a school may submit this and after if they don't have a response, it's considered that then the policy is acceptable. And when this policy is found to have been racist, you can't challenge it anymore because this law says it is approved because you did not submit it. And I think that's where we got challenges with the Velcom case when we were dealing with issues of pregnancy, where the school says, we have submitted to the department this policy that will expel every pregnant learner in the school, but the department did not respond. So we think we might fall under that trap again if we're going to put these timelines and the administrative processes that you're raising. So we will talk to the lawyers. We still want to maintain SGBs develop a policy, but whatever you have developed will still be subjected to the HOD in case what you have developed is not in line constitutionally. And the HOD must have a final say. Hence, the court cases that you're indicating are saying the same thing. So we want to draw back on the administrative processes that says every school within this period of time submit, and then the answers will come, and like you are marking an assent. We want to talk to the lawyers around it, that maybe that we need to concede. But the final say still remains to the HOD. And should the SGB not be happy with the HOD, then it goes to the MEC and all that. And that's our input, Chairperson.
Yes, Chair. The proposed provision which adds a proviso to Section 5.5, which provides that the admission policies be approved by HOD, that's actually in compliance or consistent with the Constitutional Court judgment of MEC for education in Gauteng versus Rivonia Primary School. So I think that's the judgment the honourable members are referring to. To add there is that the court actually held that the department maintains ultimate control, and also admission policies cannot be in conflict with the Constitution. And if there is good reason to depart from the policy, it is always open to an HOD of a provincial education department to do so. However, that is subject to a procedurally fair process, which the provision does provides for necessary consultation, and also provides for an appeal process. So the proviso which they are proposing is in line with the Constitutional Court judgment, Chair. That's all from me. Thank you.
Chairperson, the Honorable says, when did this start? When did these changes start? There has never been a change. When we deal with admissions, the policies around admissions always said grade 1 is children that are 5 years turning 6 in the age of admission. It has been like that forever. It's not something new. Now that we're bringing grade R, we just take a year back, and then it says 4 years turning 5 at the age of admission. No changes. The confusion comes in when you look at the school compulsory age. In SASA, the school compulsory age in the current SASA, it's 7 years. That's saying any child who turns 7 must be at school by hooks or by crook. Any parent who then deprive a 7-year-old child from attending then is then guilty of this offense. It was also saying if a 7-year-old child turns up in a school and there are many grade 6-year-olds, the 7-year-old then gets preference over the 6-year-old. So that is a compulsory school-going age, which is different from the age of admission. So the age of admission is 4 turning 5 by June 30, and the age of 5 turning 6 for grade 1 when the child is at school. So all the children for all this time have been in grade 1 from the age of 6. It's nothing new. Then they finish their schooling at 17, as Honorable has indicated. Then at 18, they are in universities unless they have repeated. It's nothing new. It is like that. We can go into all archives of the department, whether it's CIMIS, whether it's EMIS, you realize that it's 6-year-olds that are in grade 1. And there are no changes, Chairperson.
Just to say that we've been taken to court many years ago on the age requirement because parents felt if the child was ready enough and there were places at schools, it's the Harris case, that the child can be admitted. And if the child is eligible to be admitted to school, and therefore this has been the norm to say compulsory school-going age versus admission age, if the school has places for younger children.
Thank you, ma'am. For me, it's just a question to the department for clarity in the full context of the, because I understand the discussions and what is sort of the direction we're taking in respect of the provision on admissions policy. And I also appreciate the judgments in respect of the empowerment and the powers conferred in regards to that and the proper hierarchy of the role players. But what I'm not clear on from the bill itself, and perhaps the department can clarify the position or their thinking, in respect of the other policies, for an example, the expulsion or the policies on pregnancy and expulsion and management of that issue. The bill is quiet, and so perhaps an understanding in terms of the position in respect of those other policies, whether what is their take and understanding in addressing the clarity that is necessary to address the position in respect. Because if the bill currently speaks to the admissions policy and we say the legislature has come to this position, that's only the only part we have addressed and spoken to in law, but the other ones will remain blurred and abstract.
Thank you, Chairperson. In fact, the rest of the legislations are like that the SGB will conduct a disciplinary hearing. If they find a child guilty and they have to expel the child, they then recommend to the head of department for expulsion. Simply, no SGB has power and authority to expel a learner. It's only the head of department the head of department that has the authority to expel a learner. So if the head of department has authority to approve a language policy, an admission policy, then it becomes in line with expulsions and disciplinary and all those. So they're done by SGPs, but the final authority remains with the SGP. So we didn't go into that because in the current SASA, it's clear and straightforward that the HOD is in control. So we put in these other controls which we left out before. Thanks.
And the appeal is with the member of the executive authority if parents are not happy about the decision of the HOD. And on matters of pregnancy, all learners have a right to education, whether you're pregnant or what. What the department has come up with is the administration of learner pregnancy, that when the child is pregnant at school, because some schools will decide to expel a child and this and that. So every child has a right to be at school, whether the child is pregnant or what. So that policy is there, the administration of the learner pregnancy by the department, the policy is there by the department.
Check that request that I'd made, that we be furnished with an opinion on this, inclusive of the judgments that we're spoken about, just to be furnished with that opinion on this particular clause. It will assist us to get perspective on what has been concluded on by the state law advisor and so on.
Just, I'm getting confused. Maybe you can unconfuse me. Which opinion actually is Honorable Nadara requesting? Because we have got the legal gurus in our midst. Where else should we go to check for a legal opinion? An opinion? Because my understanding is the portfolio committee has invited the major stakeholders and especially with regard to law, the legal part of it. We have got law, the legal team from DBE. We have got the parliamentary legal team. Which opinion and from whom are we actually trying to seek? Because I think some of these things will be just means of trying to while away time to say we can't proceed because we said we must first get a legal opinion. Which legal opinion we're busy getting now? Even on case laws at the Rivonia trial that some of us have just quoted, which further legal opinion are we waiting for? Are you object to that? Thank you.
So yes.
Yes, Chair. I to note my question or my ask for the Act to be broadened to allow for a public school to become a private school, and then in terms of the issue of legality, I think the issue is around the centralization. And and therefore it is important to know what is the impact, the constitutionality of that, Chair. So I just, yeah.
Can I just clarify, Chair? I think the principal may have interpreted what I was asking wrong. This is simply just putting together whatever you are saying and what they are saying, put it together, put it in writing, just send it to us. That's all we're asking for. We made a request earlier about online learning and policy. I mean, there was no objection there. You see, if we ever act in suspicion when we make a request, we're going to have a challenge. For us is to make sure that we clarify what the position of this particular clause is based on the information that came out of this. And the reason why I asked that legal opinion is based on that, Chair, that there may be a constitutional argument made. We were in public hearings, people raised these things. So we need to make sure that we clarify them. There are some things that have come out of the meeting and the discussion about judgments and so on, and we need to be able to come up with a conclusion to say, look, based on X, Y, and Z, this is what the opinion is on this particular clause. It's just a request. Yesterday we were told that we can raise that request. I don't know why it's an issue today.
Barona, do you want it separately out of the process?
No.
When yeah, okay, no, it's fine then, no problem. Clause 5.
Honourable members, amendment of Section 6 of Act 84 of 1996 Clause 5 reads as follows. Clause 5, Section 6 of the South African Schools Act 1996 is hereby amended by paragraph A by the substitution for subsection 2 of the following subsection. 2. The governing body of a public school may, subject to subsection 13, determine the language policy of the school, subject to the Constitution, this Act, and any applicable provincial law, provided that the language policy of a public school must be limited to one or more of the official languages of the Republic as provided in Section 6, subsection 1 of the Constitution. Paragraph B. By the substitution for subsection 4 of the following subsection 4, please note that text in bold now is substituted by the text South African Sign Language. So it reads section 4, South African Sign Language has the status of an official language for purposes of learning at a public school. And paragraph C, by the addition of the following subsections. 5, the governing body must submit this language policy of a school and any amendment thereof to the head of department for approval. 6, the head of department may approve the language policy of a school or any amendment thereof, or may return it to the governing body with such recommendations as may be necessary in the circumstances, together with reasons for such recommendations. 7, the head of department, when considering the language policy of a public school or any amendment thereof for approval, must be satisfied that the policy of the amendment thereof takes into account the language needs in general of the broader community in the education district in which the public school is situated, and must take into account factors including but not limited to paragraph A, the best interest of the child with emphasis on equality as provided for in section 9 of the Constitution, and equity. Paragraph B, section 6, subsection 2 of the Constitution. Paragraph C, section 29, subsection 2 of the Constitution. Paragraph D, the changing number of learners who speak the same language of learning and teaching at the public school. Paragraph E, the need for effective use of classroom space and resources of the public schools. And F, the enrollment trends of the public schools. Section 8, the governing body must review the language policy determined in terms of this section every 3 years or whenever the factors referred to in subsection 7 have changed, when circumstances so require or at the request of the head of department. 9, the governing body of each public school must, within 30 days, after the commencement of the Basic Education Laws Amendment Act of 2022, submit the language policy of that school to the head of department for approval. 10, the head of department must respond to the governing body as contemplated in subsection 6 within 60 days after receiving the language policy, failing which the language policy will be regarded as having been approved by the head of department. 11, when a public school has, as contemplated in subsection 5 and subsection 9, submitted its language policy to the head of department, such language policy will be regarded as a valid language policy of the school during the 60-day period referred to in subsection 10, or if the head of department responds to the school's request for approval of the language policy before the end of the 60-day period, until the earlier date on which the head of department responds. 12, the governing body of each public school must, after the commencement of the Basic Education Laws Amendment Act 2022, submit any amendment to the languages policy to the head of department for approval, and the head of department must respond within 30 days after receiving the amendment, failing which the amendment will be regarded as having been approved by the head of department. 13. Notwithstanding the provisions of subsection 2, the head of department may, wherever it is practicable to do so, and subject to subsection 7, direct a public school to adopt more than one language of instruction. 14. The head of department, in determining whether it is practicable for a public school to have more than one language of instruction, must take into account factors including, but not limited to, paragraph A, the best interest of the child with emphasis on equality as provided for in section 9 of the Constitution and equity. Paragraph B, the changing number of learners who speak the language of learning and teaching at the public school. Paragraph C, the need for effective use of classroom space and resources of the public school. Paragraph D, the language needs in general of the broader community in the education district in which the public school is situated. And then subsection 15, the head of department may not act in terms of subsection 13 unless he or she has, in paragraph A, in writing, informed the school and the governing body of his or her intention to act as contemplated in subsection 13 and his or her reason thereof. Paragraph B, notify the parents associated with the school and the community in which the school is situated of his or her intention so as to act and the reasons therefore. Subparagraph Roman figure 1, by means of a notice in at least one newspaper circulating in the area where the school is situated, if any newspapers circulate in that area. Subparagraph Roman figure 2, by causing the principal of the school to, item AA, hand to every learner a notice containing the relevant information, and item BB, instruct the learners to hand the notice to their parents, and item Roman figure 3, by means of any other acceptable form of communication that will ensure that the information is spread as widely as possible. Paragraph C, granted that the school, the governing body, the parents associated with the school, and the community in which the school is situated a reasonable opportunity to make representations to him or her in relation to such an action. Paragraph D, conducted a public hearing on reasonable notice to enable the community to make representations to him or her in relation to such action. And paragraph E, given due consideration to any such representations received. Subsection 16, the head of department must, paragraph A, inform the school and the governing body of his or her decision contemplated in subsection 13 and his or her reasons thereof. And paragraph B, by means of the methods listed in subsection 15, paragraph B, notify the parents associated with the school and the communities in which the schools are situated of the decision. Subsection 17, if the head of department acts in terms of subsection 13, he or she must, before his or her directive is implemented, take all necessary steps to ensure that the public school concerned receives the necessary resources, including but not limited to, paragraph A, educators, and paragraph B, learning and teaching support material, to enable that public schools to provide adequate tuition in the additional languages or language of instruction. Subsection 18, if the governing body is not satisfied with the decision of the head of department as contemplated in subsection 6 or with the directive contemplated in subsection 13, the governing body may appeal against the decision of the directive, as may the case be, to the member of the Executive Council within 14 days after receiving the decision or the directive, as the case may be. Subsection 19, If an appeal contemplated in subsection 18 has been received, the member of the Executive Council must, within 14 days after the receiving such appeal, consider and decide the matter and inform the governing body of the outcome of the appeal. Subsection 20. While the member of the Executive Council considers the appeal, the language policy shall remain valid and applicable, and only the provisions that are the subject of the appeal shall be suspended pending the finalization of the appeal process.
Thank you very much. That is clause 5, which is about the language policy of the public schools. Can I note members' hands? Principal?
Chairperson, you see, I am too much of a pragmatist when it comes to this, because I've lived almost my entire career in this situation, somewhere defending and somewhere being directly affected. If one was to make a straightforward summary, one was going to say this clause, the response to this clause in principle is consequential to clause number 4. If one was just, and therefore say, can we proceed to the other clause? But however, let me indicate why I am saying somewhere I fell prey to it. I joined this parliament in the 6th parliament. And by that time, and of course maybe until now, I was a single parent. I had to take my 2 kids with me here because there was nobody to take care of them in Zanin. This portfolio committee knows the hell that I went through for as the other one was already at the university, but for this small one, who was to be admitted at the secondary level. The child could not be admitted simply because of this policy, the language policy. The minister and the deputy minister had to intervene at some stage. And my boy only got admitted in the first week of March, when other kids were already miles ahead. And as a result, Chairperson, like I've talked about change is unavoidable. Let us face it, it's inevitable. But change is a formidable must. I would say this proposal by the department, so that we do not remember and suffer from whatever you can call it, remembering the bad past, I would say let's admit and agree with the proposal by the department. The argument is very clear that the final arbiter the center must hold should always be the HOD, and in case of an appeal, it goes to the MEC, and for fairness' sake. Thank you very much, Chairperson. Let me just stop there.
Thank you, Nodada.
Thank you so much, Chair. Again, I'm going to make a request on this one as well, that we get an opinion legally on the separation of power. You see, if we ever make the mistake of making laws for the exception, we're going to have a problem. And we know very well that on principle, it's important for us to ensure that parents and communities are involved in their schools. And by determining what is best for that particular environment, based on that environment. You know, I come from Engo, Kutsole, Mashlubi. And there I'm proud that the Eastern Cape is making sure that mother tongue education in isiXhosa is enhanced. Because even myself, when you listen to this accent, you may think that I think in English. and I don't. I think in this cause, because I understand the depth of knowledge of things in my own mother tongue. Now, if we don't leave the decision making on policy on what is the best language used for the children there to the parents and the communities that know what is best for their children, we're going to have a challenge. Somebody somewhere will be sitting in an office as an HOD, one individual, and we're saying, have all the powers to determine all of these policies. And when we've got a problem, we must appeal to one other individual, who, by the way, is the MEC. So we've got a problem of principle here, that the majority of parents all of a sudden don't care about their children's future. We make that assumption. And then we want to give the power to determine a language policy, and similarly to the previous clause, an admission policy, to one individual who must now determine all of our futures and all of our children's future. I think on principle, there's a problem there. If we centralize control and power to one individual, what if tomorrow they wake up and drunk, you know, and decide that no, the language policy of ENCO is going to be Sotho? And then we must go and appeal to the very same MEC who sits with this individual as an HOD to make this determination. I think there's an argument. What we can't run away from is that there are schools that utilize their language policies to exclude certain learners. And if you make the mistake of wanting to make this, this point separate from each other, you're going to have a problem. There are schools that we have dealt with that use language policy to exclude certain learners. And that's where the recourse mechanism must be. That yes, determine your admission policy and your language policy, school governing body. You are parents, you care about your children's education. But once you decide to formulate a policy that is going to exclude principals, a son, then the HOD must then intervene, or the MEC or the relevant executive must intervene there. But to give the power to make a determination of to one individual, to say, no, we trust you. We know every single thing that we've come across in the system. Fortunately enough, I don't hear about these things. I go to these places myself. And you see the devastation of parents that have to, where the decision-making power has been given to the hands of a politician or an administrator in a department, whether it's in a district or in a second, and all their lives are dependent on that one individual. When that one individual messes up, all of those parents suffer. But if those parents take a responsibility to make their own policies, as on principle, and if they decide to make the wrong decision, you then intervene, I think it's best. Because you are giving them responsibility to understand that the education of their children is in their own hands. If they decide to formulate policy that is going to discriminate against others, then it's against the Constitution. So I want to propose the following alternative clause, Chairperson. Because as set out here to say, no, the HOD must approve every single policy. One is an administrative burden, and I think I've mentioned it in the previous clause as well. Secondly, beyond it being an administrative burden, the centralization of power on principle to the HOD is not correct. My understanding of even the judgment that was referred to was that an HOD must be a final arbiter. An arbiter is somebody who comes in when there is a problem, who's a custodian of that particular policy. Now, if, for example, the SGB makes the language policy and there's a problem, the HOD becomes the responsible one to make sure that that's resolved. Now you're saying HOD approve, be a player, HOD become a referee. And the misconstrued idea that to say that the appeal must go to the SGB, maybe Honorable Lucia had me wrong, but the appeal mechanism must either to be to the HOD or to the MEC, because those are responsible parties. So Section 6, so I want to propose the following clause, that the alternative clause be that the governing body of a public school may determine the language policy of the school subject to the Constitution, this act in any applicable provincial law, provided that the language policy of a public school must be limited to one or more of the official languages of the Republic of South Africa. Obviously, you may know that a recognized sign language has now the status of an official language of learning at a public school, and obviously that automatically is included there. If a parent of a learner is not satisfied with the language policy, this is the recourse mechanism of a school governing body based on the Constitution. This act and any applicable law they must, or they may appeal against the decision to the HOD and or member of the executive of the member of the executive council. And again, I request that we get some legal guidance on this one, because it may have a constitutional implication in terms of centralization and the separation of law. Thank you so much, Chair.
Honorable Mani.
Thank you, Chairperson. I really just think that the speaker before Honorable Notat, I think it pretty much covered me in terms of saying this is consequential of the previous one, and they know that formulation. I think that is correct. I think what is missing in this discussion, maybe, Chairperson, is perhaps we are not understanding the same thing when we talk about the head of department. Who is this individual that is called the head of the department, and how does this person come about? And I think it's important for all of us to be aware that when you're talking about the head of department or HOD, we are talking about not a politician, we're talking about a professional here. Let's start here, a person that would have submitted a CV, a person that would have ticked the boxes in terms of understanding the constitution, the law, and everything else, and is there to ensure that policy of government is implemented. Not only a politician yet. And I think it's important to compare and contrast that with what SGBs are. SGBs, for all intents and purposes in that particular area, will depend on the strength of the politics in that area. This is why we're having such a mess. Because if you are Mani, living in Sentin in a DA area, as an example, then you have a problem. Because there will be a whole lot of ideological issues that SGB is going to say my child must be subjected to, which I have a problem with. And therefore I would have a problem with those people purely because there are too many in my area, therefore they must decide what must happen for my child. When you have a professional who supposedly is not politically aligned, is a professional that submitted a CV, ticked all the boxes, and is doing this thing rationally. So, in my view, Chairperson, I think it's important to understand that when we talk about an HOD, by definition, that person is rational, that person, and therefore, this whole characterization of an HOD as somebody, a powerful individual, and some abusive things being said that he may be drunk and say this is quite unfortunate, as it were. Because here we're talking about a person whose interest is to further the constitution. You must remember that in this country, Chairperson, we have a constitutional democracy. Rule of law is what is supreme. You have to have an administrator that is going to put rule of law, not what my political party is saying, rule of law that would have agreed to, that this is what needs to happen. When that HOD makes a decision, that HOD does not make a decision based on his likes or don't likes. He makes that decision based on all the prescripts that are at his disposal. So I think it is important that we understand this, and I think the more we give power to the bureaucracy, as it were, in government, the better. Because then you take away all the political nuances, you make this thing, you make this thing much more rational, much more objective, and all of that. So, Chairperson, I think, and I think I must take also exception to this thing that we're sitting here with lawyers that are giving, what's the right word? That are giving
opinion,
input on a running time. There's a word I'm looking for. You know, for me, English is the seventh language, so I forget these things. Yeah, but they're here. They're giving information on a time. I think it's a bit of. I think it's off. It's offish to be saying legal opinion. I think the minutes that will be provided here will provide the input that others have given. I don't think we should live here with a minute and that is going to be saying want a legal opinion, all of that. We must not insult the people that are here and undermine them. They're giving this thing on a real time. That's the word I was looking for. We're getting real-time advice legally on these things. You know, if other people want a legal opinion, then take the minutes, take them to your lawyers for your legal advice. But as far as we're concerned here, we're getting real-time advice, and there should be no expectation that something special called a legal, this is going to come out of this. They must just get minutes and do what they want to do with the minutes of the meeting. Thank you, Chair.
Thank you, Honourable Chair. I would concur with both Honourable Manye and Honourable Morwachela that this is, in a certain sense, a mirror image of the previous clause, and that much of the same comment should go for this than for the previous. And therefore, I would not repeat everything I said in the previous clause. I want to add that which I didn't say with that one, which is also applicable to that clause, but also to this one. The first thing is that I think we are getting to the point that it crystallizes very clearly that the central question is whose schools are we speaking about? Do we speak about the community schools or do we speak about the state schools? Is it the state's property to define and to delegate some powers to the SGBs as the state likes, but also to draw a line through those decisions if it doesn't suit the state? Or is it the community schools and that the state only intervenes in some ways or sometimes when there's a clear infringement on people's rights, on the rule of law as executed by school governing bodies, which is actually as a group often called the fourth tier or tier of government in South Africa. Actually, the third biggest election in South Africa is when school governing bodies are elected. So it's clear to me that both the fighters and the comrades believe it is the state school for the state to decide what happens over there. And for me, from the Freedom Front, and I perceive it equally from the Democratic Alliance and the ACDP, it's the community schools. But I don't want to speak for anybody else. The second thing is that this is language policy. And we all know it's all about Afrikaans schools. Nobody has had a problem with a Sesotho school or with a Sepedi school or anything. And I think it is very commendable that the Eastern Cape has made it possible to write matric in isiXhosa. And I followed that with I would say, with appreciation. The thing is that we are getting to a certain extent to the core of the settlement of 1994. And that is where people said, okay, the previous, powerful people, the whites, if you want to call it like that, said, we can go into the settlement, but as cultural communities, we need our schools. That was a very strong sentiment at that stage. And the settlement was, you can have your schools, but you may not discriminate. So it can be an Afrikaans school, but you can't exclude somebody because of race or gender or religion or whatever. You can have a Christian school, but you can't exclude somebody from a public school because that person is not Christian. And that was the settlement. So the state schools of the previous dispensation were turned into community schools. And where a school community constitutes itself. In the area maybe of Afrikaans hoor in Pretoria, many schools change their language policy from Afrikaans to English or to bilingual or whatever. But the school community of that specific school is all over the country. and they identify with that school and they provide the resources to keep that school intact. Now that is in accordance with Section 235 of the Constitution, something which may be done, something which should be recognized, and something which this bill, if it becomes law, removes, and that is a problem. Thank you.
Yes, Chair, mine is to maybe emphasize and then reiterate what I said partially. I said that my experience is the same as was by Honourable Morasetla, Principal. And I know what that does, especially when you are under pressure as a parent to get your child into a school and you live in an area. Absolutely, I fully get that. As I say, it was a lived experience for me. The right to educate your children in the language of your choice is an inherent human right. And it must be noted, if we make laws, one of the key things that sometimes we forget, especially when it comes to legislative processes, is we are dealing with human beings, and it is hearts and minds that we need to reach if we want to really make a success of any system or any change. And what is being put forward here, as was visible and was evident from the inputs from all communities in the public hearings, those that spoke passionately for change and transformation, and those that spoke passionately for the rights of communities and cultural groups to be protected. This bill has been in development for 10 years. Why it is that we have not tried to reach the hearts of people so that we make it a part of what we sometimes only speak of during Heritage Month, which is that we collectively address the issues within the context of what matters to the heart. And language matters to the heart. I want to concur with what was said by Honourable Boshoff around the issue of subsidiarity. The state must not do what the community can do. And also what was said by Honourable Nodada in terms of the constitutionality and the need for us to understand and understand the constitutional implication. So I maintain is the opportunity for us to do, the department at least for DBE, to really engage with schooling communities surrounding these issues. But the amendments as it stands is not the way for it to be done. That I maintain. And I think that is, those are the total of what I wanted to say, Chair.
Thank you very much, Chair. Without going to town, I would first and foremost want to say that the clause as presented provides for all the checks and balances that would pass the test of a rational man. We can also say reasonable man. The clauses, as read, do not come across as handing over arbitrary power to a single individual. For instance, the requirement that a school government formulates a language policy remains. The requirement is that that formulated policy is then given to the department for the HOD to approve. So the powers to formulate are not taken away from SGBs. There's accountability on what it is they formulate. When the HOD wants to amend a language policy, there are steps to be followed, first of which is to conduct a public hearing. I don't know. Does that sound arbitrary to you, Chair? That one man can control, allowed for it here. Yes. This alarmist attitude around transformation is worrisome. When a clause is written with all the inherent checks and balances to qualify and to pass the constitutional master, I don't know, Slan, but there is absolutely nothing untoward with this clause. Nothing. I have gone through it, I've read it. There's nothing that gives the HOD arbitrary powers of a superman or superwoman to go in a school, change language policies without consulting anyone, and to be a law unto himself or herself. Nothing, nothing. Perhaps colleagues must take time to go through this thing. The steps are there. If the HOD does not approve, by the way, a language policy developed by a school governing body within a specified time period, it is taken that the approval is moot. It is approved. If they don't respond within that period, the school governing body does not have to make any more correspondence between themselves and the HOD to try and get it in writing. As long as they can prove that they submitted and that time period has lapsed, that proved as per what is here. I don't know. But I want to put my 2 cents worth. I agree with what is written here in this clause, as is. There's nothing alarmist here, or that is worth alarm. There's nothing that gives an individual arbitrary powers here on what is written. I'm saying if we are removing politics on what is the letter here, nothing. Thank you very much, Chair.
No, thank you very much, Chairperson. You know, when we went to public hearings, it was basically to hear what the public is saying on the bill that is before us. And majority of the people have viewed or add their views, and they were actually even excited that this process has came before them, because as members of the committee, we can't really take decisions on behalf of the entire community without even engaging with them. And Chair, I can assure you that, you know, the way we proceed with the process of this bill, many people are going to be happy to see that we are doing something about it, because come January, we know what happens in schools. We know it's a struggle every time. You know, the principal has just, gave evidence to that. But imagine for somebody who doesn't even know where to go. At some point, we were even entertaining letters that were written to the committee about the similar matter that we are addressing today. To say, my kid cannot be accepted to the school or admitted to the school because of language. We are from an area where my kid used to, attend a school or English school. Now we are in an area where there's an African school. My kid cannot be admitted. There was a case like that from the Northern Cape. Now, when we are trying to, to deal with what the communities or the public has put before us, and majority of them, by the way, to say these are some of the challenges that we've been living with ever since. Even from 1994, we have never enjoyed freedom, some of us. And now we come here and sit here and say the department is not doing, the right thing. For me, where I'm seated is that this clause as it is, it must be passed as it is because it's going to assist many of those people that have really been, closed outside to some of the schools that they cannot even take their kids to. Let me pause there, Chair. Thank you very much.
No, thank you very much, members. Mine is just clarity on 5. We're saying that the South African language has a status on an official language for purposes of learning at a public school. Why did you not add Braille? It's just an ask. DBE, over to you then.
So thank you, Chairperson. Since I hear that can be added, but that statement needs correction because it says for the sake of teaching and learning, but it should just remain as an official language because it's declared now as an official language. Chairperson, it cannot be a mistake that we have children that can I was saying it can be a mistake that we have a lot of children that can't speak their mother tongue. A lot of children are attending school taught in other languages despite their mother tongue. I think Honorable Manye Bomorosetla, when they arrive in Joburg for the first time, they'll find that there are no Sepedi schools around, and they end up doing Setswana because the community there and the SGBs are saying this is a Setswana school, and therefore if you want to be taught here, irrespective of your numbers in Tembisa, you'll have to be taught in the language of Setswana. And the SGB stands there and say, when this school was built, it was built for Setswana children. So if you come here, get into the Setswana class. It'd be a mistake that you grow up in a township like me, in a township called Shawela. In that township, if you want to be taught in Sevenda and you live in Middlelands, you have to travel 2 hours to go to Shawela because that is the only place where you'll get a Sevenda school. It can't be. When you can walk meters to a school and you are 40 of you that can make a class and another grade and another grade, but simple because the language policy of a school says not here. It can't be. It is these issues that makes parents to sit in a mall when they talk to one another, they speak in Xhosa, but when they turn to their child, then they turn into English because the child won't understand what they're saying because this child has been forced into a school where the language has already been determined. We wouldn't be here if SGBs were listening to communities. We wouldn't be here. I work in Pretoria.
Pretoria, it's an area where you've got all nationalities because that's where all these departments are. It's a capital. And therefore, all the head offices, the national offices are there. Who get employed in Pretoria? Everybody from South Africa is in there. It can't be right that there's a school somewhere in Pretoria where all these officials who even work for government live, but they can't access those schools because there's a language issue there. They can organize themselves in kumbis. These fighters will sometimes even come in buses and trucks and storm the Department of Education because they have a group of children who cannot access a school in a particular area. The numbers are there. But because he has decided this is our school, you can't come in. If you come in, this is the language and that's it. Honorable Bishop, we don't want to make it an Afrikaans issue. It's not an Afrikaans issue. I tell you now that children in Hammanskraal who are Xitsonga speaking are not taking lessons in Xitsonga, despite that the whole area speaks Xitsonga. But because originally it was Botswana, therefore the school is Xitswana. It's not an Afrikaans issue. What makes it difficult that you open up a school that is a Setswana school surrounded by Sepedi children and have 2 languages introduced there? What makes it difficult? Because the SGBs do not want to allow that process to happen. Because we're trying to say this is this community's decision. Forgetting community has changed. Tell me in South Africa which community is a Zulu community now. Whether you go to Rustenburg, you find people that work in Marikana. Why would you say the schools there must teach children in Setswana in Marikana? Because most of the people, some of them come from the Eastern Cape and they speak Xhosa. But you're struggling to use Xhosa there. Additionally, it's a Setswana area. I mean, as Xhosa speaking, but we're struggling as a department. We wouldn't be here if SGBs were doing exactly what we expected to do. Now, we want to reduce an HOD into something that is not. Nothing. Whereas an HOD is a person that is appointed to be a custodian of the very same education. And we want to compare him with an SGB chairperson and say they have the same powers. Or her, or Women's Month. It can't be right that there's no custodian of the education. We now want to differentiate between a state school, a public school, and an independent school. Yes, it's a public school. And this is a government school, which then works with the public, and it becomes a public school in terms of the fact that roles and responsibilities that are given to the public. The custodian of that public education remains with the education department itself. When parents are happy, where do they go? And who then intervene? It can't be an ordinary person because the head of the department has a job description. And one of these job descriptions is to ensure an eye in a school and children are receiving education. Now, you can't take that power away and say it's a public, as a public will decide what you want to do. Now, why these things are not happening is because the SGBs tend to take this responsibility to themselves, very few people deciding on behalf of the majority. Honorable Yabo is right. You read the whole of these things, it starts to say, you mess up with the language policy. The head of department needs to intervene. How does he intervene? Steps. The head of department will not do this unless He has consulted, he has put it in the communities, he has had a public and that. So all those things, who then decide the language of the school in the area? It is the public. Through these consultation processes that are now legislated. And what could be wrong in that? We're not talking about a he or a she that goes to a school and instruct the school that as from tomorrow, you're going to have a Setswana language in here. We're not talking about that. But we're talking about a person who will say, did you see that we have 500 Setswana families around here? Can we talk? And these are the steps that he does it. If he comes and issues a letter and says, tomorrow you're introducing Setswana, then he's out of order. But you've got recourse here. Because this is what he must do. And we can even tick the boxes that this was not done. And therefore, talking about a dictator here, you're not talking about a centralized power, because he's not exercising those centralized power, but he's speaking to the communities. I think the problem is that the SGBs have been so used to controlling and doing things without even getting a mandate of the communities. And now this clause is saying nobody can do that. SGB or HOD, you can't do that unless you get the mandate of the community. Tatu, you are correct. Just follow the steps. And they're saying exactly that. Because this clause is the same as the previous one, we said we want to look at the issues of the administrative burden. And we'll talk to the lawyers on how we deal with it. But how the HOD steps in are things that are indicated here. And we request again, don't make it an Afrikaans issue, make it a community issue. Who the community must decide what needs to happen. Then the right to education in the language of the parent's choice then gets covered. Issues of home language then gets covered in that fashion. And the voice of the communities get addressed, because there are steps on how communities need to come in. And should they depart out of order, honorable members know what to do in case the law has been violated. Thanks.
Thank you. I want to address the issue of the separation of powers raised by the Honourable Doda. And I want specifically to refer members to a document that is called the Memorandum Laws Amendment Bill, specifically page clause 2.5. And I will read this into the record, Chair, because I think this captures this issue very succinctly. So paragraph 2. I'll start with 2.5.4. It says, the proposed amendments in 6 of the SASSA are consistent with the Constitutional Court judgment of Head of Department Mpumalanga, Department of Education, Ms. Ermelo and another, which provided guidance with regard to the approval of a school's language policy. The Constitutional Court made it clear that even though the function of determining a school's language policy is a devolved function in terms of section 2 of the SASSA, it is not the exclusive preserve of an SGB. The devolution of power does not mean that the SGB's right to decide a language policy is absolute. The power is subject to the Constitution, the South African Schools Act, and any applicable provincial law. The Constitutional Court in the Ermelo judgment further held that the SGB's extensive powers and duties do not mean that the HOD is precluded from intervening. Reasonable grounds to ensure that the admission and language policies of a school pay adequate heed to section 29 sub 2 of the Constitution. Then further, moreover, the Ermelo judgment as well, Head of Department, Free State Province versus Welcome High School and another, Head of Department, Free State versus Harmony High and another, made it necessary to incorporate further checks and balances above those that are currently in the SASSA in respect of the language and admission policies of the school. The Constitutional Court in the Ermelo judgment held that the SGB of a school must recognize that it's entrusted with a public resource which must be managed, not only in the interest of those who happen to be learners and parents at the time, but also in the interest of the broader community in which it's located and in the light of the values of our Constitution. And then for the above reasons, it's also necessary to empower the HUD to direct a public school to adopt more than one language of instruction where it is practicable to do so. A number of checks and balances have been included in the clause to guide the HUD's decision in this regard. Furthermore, a comprehensive consultation process is provided for to ensure that the views of all interest parties are obtained and given proper consideration. Chair, so this is what our court has already pronounced on this issue. Thank you.
Thank you. Thank you, Chairperson. Again, for me, what I'm coming up with, already the department has indicated that we shall try to find one another on administrative burden and other issues that arise. But it is also clear that to a degree, clause 4 and 5 are supposed to be mirroring one another to a certain degree, which is not the case. So what I want to raise right now, Chairperson, for the department to consider, or if they already have an answer as well, we can speak to it when we engage in preparation of the A list. What I've picked up is that in respect of clause 4, Chairperson, when we look at page 8, clause 4 for subsection 5 substitution, it says they're subject to this act and any applicable provincial law, the admission policy of a public school is determined by the SGB of such a school, provided that A, the HOD, after consulting with the governing body of school, has final authority, blah, 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 it goes on. But if we go to clause 5, on a most similar provision, which begins to start the process after the SGB has done, it is mandated to do. At sub 6, we are saying that will be now page 9, clause 5 at sub 6. The head of the department may the language policy of a public school on any amendment thereof, or may return it to the governing body with such recommendations as may be necessary. For me, I'm thinking that's a step that has no end or a way forward, other than just saying, if the SGP says we are not taking your recommendations, then what? We leave it like that, or we take you to court, or what? It's sort of abstract and left hanging. Whereas on the other one, there is a clear end from start that is outlined. So just to point to the committee that perhaps if they have an answer, or if we will have to find one another on that when we clean up the process, Chairperson, and prepare something.
Thanks, Chair. We accept the advice. The two clauses must mirror one another. So we need to find way, synergy to mirror them.
Oh.
Thank you, Chair. I just want to speak to the principle of the separation of powers. That is a constitutional principle, Chair. And what it envisages is that there cannot be a separation between the function, 3 branches of government, which is executive, judiciary, and legislature. So I just wanted to make that clear. And our judiciary has in fact referred to that principle numerous occasions. One example is the Doctors for Life judgment, Constitutional Court judgment. Chair, what Section 29(2) provides is that a learner has the right to receive education in a language of his or her preference. So that is a right in the Bill of Rights. So what Section 7(2) provides in the Constitution, Chair, is that the state must respect, promote, and fulfill the rights in the Bill of Rights. So in my view, that is what this provision is attempting to do, to ensure that constitutional right is fulfilled. with regards to language. And I'd also like to refer the committee to a constitutional court judgment, which my colleague from the department has referenced. It's the HOD Mpumalanga Education Department versus Mellow High School. So I'd just like to add what the Constitutional Court said there. It held that providing governing bodies with the exclusive power to determine language policy is inconsistent with the transformative designs of Section 29(2) of the Constitution. And further, that the power to determine language policy is not absolute and is not exempt from executive intervention. Thank you, Chair.
All right, can we resume? We are nicely after lunch. Hopefully now we will flow, because at least now we've gotten an approach of flowing. We've dealt with a contentious issue. Aye, aye, aye. What is it now?
Chair, I just want you to know a word on my behalf. When I looked for parking this morning, I saw the part where the Freedom Front parks is shut off. So I parked in the ANC's parking base. And I thought maybe you can just put in a if somebody wants to evict me.
We are a very friendly organization. Clause 6. Curriculum and assessment.
Amendment of Section 6A of Act 84 of 1996, as inserted by Section 3 of Act 50 of 2002. Clause 6 amends Section 6A of the South African Schools Act 1996, is hereby amended by the addition of the following subsection. Section 3. The minister may, in writing, appoint a person, an organization, or a group of persons to advise him or her in regard to the determination contemplated in subsection 1.
Members, that's clause 6. Principal?
I attended almost all of the public hearings, and I might not have been privy in looking into the oral submissions and written submissions, but the public apparently did not make any comment on those, and therefore I wanted to humbly move that we pass it and go to the next one. Thank you.
TBE? Aye, Suka.
Yeah, just don't don't preempt what I'm going to say. But I just want to caution us from that approach, because we are representatives of the people, so we need to consider all the clauses. I'm not saying that there's a particular comment, but I just want us to caution from that, so that even if the public didn't comment on a particular clause, but as representatives of the people, if you've got a comment on it, we are able to make that comment. But this particular clause, Chair, is all well.
Our lips are sealed, Chairperson.
We are now moving to clause 7 of Section 8 of Act 84 of 6, as amended by Section 4 of Act 50 of 2002 and Section 6 of Act 31 of Clause 7, Section 8 of the South African Schools Act 1996 is hereby amended. Paragraph A, subject to the Constitution and any applicable provincial law, a governing body of a public school must adopt a code of conduct for the learners after consultation with the learners, parents, and educators of the school. Paragraph B, By the substitution for subsection 2 of the following subsection, subsection 2, a code of conduct referred to in subsection 1 must be aimed at establishing disciplined and purposeful school environment dedicated to the improvement and maintenance of the quality of the learning process, taking into account the diverse cultural beliefs, religious observances, and medical circumstances of the learners at the school. Paragraph C. By the substitution for subsection 4 of the following subsection, 4A, nothing contained in this Act exempts a learner from the obligation to comply with the code of conduct of the school attended by such a learner. B. Despite paragraph A, the code of conduct must contain an exemption provision in terms of which a learner or the parent of a learner may apply to the governing body for exemption of that learner from complying with certain provisions of the code of conduct on just cause shown. Paragraph C. On receiving an application contemplated in paragraph B, the school governing body must communicate its decision to the learner or the parent of the learner, as the case may be, within 14 days after receiving the application, and must, in the case of a refusal, provide written reasons for the refusal. D. A learner who's been refused exemption as contemplated in paragraph C may, within 14 days of the notice of the decision, appeal to the head of department against the decision of the governing body, and the head of department must, after considering the reasons of the governing body, communicate his or her decision to the learner or the parent as the case, and to the governing body within 14 days after receiving the act, must provide written reasons for his or her decisions. And paragraph D, by the addition to subsection 5 of the following paragraph, which is paragraph C, the disciplinary proceedings referred to in this subsection must be age appropriate, must be conducted in the best interest of the learner, and must adhere to the principles of natural justice, fairness, and reasonableness prescribed by the Constitution. It ends there, Chairperson.
Just a question, Chair, to maybe the proposers of this particular amendment. Obviously, the term judge is obviously too wide in this in this context, and sometimes it can lead to frivolous application for exemption. So I just wanted to whether should it not be maybe replaced with much more specific language like religious, cultural, or medical grounds, or maybe there would be a rationale based just cause, but it obviously is too wide based on what exists in law. When you talk about just cause, it's just a question, Chair. Thanks.
Thank you, Chair. Chair, most schools have codes of conduct that are not legally compliant. SASA was drafted in 1996. 10 years later, the Children's Act and the Child Justice promulgated. The Children's Act is a piece of umbrella legislation, and SASA and Bella should fall under its protection. In this regard, I would like to quote Dr. Marietta Reineke, a leading expert on discipline in schools, who said, and I open quote, "In contrast to the explicit child-centered requirement of the Constitution, the Schools Act does not have an explicit child," quote. My question is, does the Bella Bill fix this, and has it been reviewed and reformed to incorporate the principles of the Children's Act and the Child Justice Act? Yes.
Joseph?
Thank you, Honourable Chair. I realised the department said just now that discipline will be dealt with in some kind of or another regulation, set of regulations. But isn't this an appropriate part of the bill to include something about what kind of, I don't know if one may use the word punishment or if that is a wrong word also, but what measures can be taken by the school when a learner does not according to the code of conduct? Because I am actually a little bit concerned still, despite what our colleague said just now, that this bill is very clear on what is not allowed. But once you have a code of conduct, you must be clear on what happens if you don't follow the code of conduct. And the bill is silent on the phase, really cause a problem. Thank you. While the chair is not listening, say that learners are really very clever at seeing loopholes in the rules, and these loopholes are huge. Thank you.
Modula Stulo level the opportunity granted. It is true that issue code of conduct, there has been actions between the code of conduct of particular institutions with regard to contravening directly the Bill of Rights as enshrined in the Constitution. But I want to believe that given the agreements that we have done on the SGB, issue of the code of conduct, which will also be part thereof, particular institution. The department is spot on in that this discrepancy of cultural and also religious affiliation will definitely come to an end, because it's exactly the point where there were contradictions with the Bill of Rights as enshrined in the Constitution of the Republic of South Africa. Therefore, we do support that this is in order. Thank you.
Thank you, Chairperson. The just cause, we're thinking that if we do list what the just cause will be, like religious, like cultural, it might tend to be limiting of schools where they will think there's an exemption under this. But if you leave it open like that, it then allows the school to apply its mind on any application that they got. For example, on medical grounds, Elena might be allowed to do 1, 2, 3. So we thought if we give examples, people will think this is the end, anything outside what is given. But it's still subject to correction, especially from legal. So that's why we left it open, that people need to apply their mind when they deal with that. The other acts, Honorable Sukers, like the Children's Act and the Justice Act, because they're there, we felt it's not necessary for us to put it in the South African Schools Act, because they apply even in schools, even though they've been developed by other departments. because it will end up being a cut and paste of the very same act. And remember, when an act is there, it helps the judiciary, especially when they have to pass judgment on particular thing that they'll be saying according to the Child's Act. So if we add and say, and also the South African Schools Act, and they're all saying the same thing, is that we felt as education, we're not differing with the Children's Act, we're not differing with the Justice Act, and therefore we can just leave it as it is and apply them in our schools as they are. Honorable Bishop, let's not assume that there's nothing happening in schools in terms of discipline. Schools are disciplining children. You do coming back from school saying, I've got a demerit. I'm going for detention. So those things are there in school. Because we have been teaching schools on how to develop from time immemorial, where we say when you must indicate also what happens when this gets violated. So this is there. What we're saying we are doing in dealing with alternate corporal punishment is in addition with what is happening already in schools. So we're saying let's not assume schools are not punishing children. Maybe punish is the wrong word. Are not disciplining children. There's in which they discipline this. But all we're emphasizing here is that clause that is there should be an exemption in case a parent wants to protect from a particular clause that is, and this is not exemption from the code of conduct. It's a clause. Yeah, sure.
Thank you, Chair. Yeah, so Chair, this judgment in the case of the education KwaZulu-Natal, but that specific case, the conduct of the Durban Girls High School was challenged because the code of conduct in that particular school indicated that girls are not allowed to wear jewelry. Ms. Pillay had a nose stud. She indicated to the school that she, for religious reasons, had to wear a particular nose stud, and that therefore she should be for religious reasons be it. The Constitutional Court agreed with her argument, and in fact the court indicated that schools should in a code of conduct allow for exemptions to the code of conduct of a school based on religious or cultural reasons. And that's also what informs this clause.
I think from us, Chair, regarding the reference to the term just cause, we will work with the department. We can maybe more clearer language with regards to that. And I do see that the term is used elsewhere in the bill, so we'll probably make an amendment there as well. Thank you, Chair.
Amendment to Section 8A of Act 84 of 1996 as inserted by Section 7. Section 8 South African Schools Act 1996 is hereby amended. Paragraph A, by the substitution for subsection 1 of the following subsection 1A, unless authorized by the principal for legitimate educational. No person may bring a dangerous or, note the text, illegal is substituted, a drug onto school premises or have such dangerous objects or in his or her possession on school premises during school activity. Paragraph B, no person may bring liquor onto public school premises or have liquor in her possession or continue or sell liquor or any public school activity. Notwithstanding the prohibition contemplated in paragraph B, subparagraph figure 1, the of department may appoint from the governing body to supplement the resources of the school, permit the possession, consumption, or sale of liquor during any school activity premises, and subparagraph Roman figure 2, the governing body of a public school may, upon receipt of an application from any person and in consultation with the head of department, permit the possession, consumption, or sale of liquor during any private or religious function held on the school's premises, provided that such possession, consumption, or sales during school hours. Provided that the governing body of a public school, in consultation with the head of department, may attach certain restrictions to the granting of such permission. Paragraph D, the permission contemplated in paragraph C relates to subparagraph Roman figure 1, fund activities of the school by the governing body. Subparagraph Roman figure 2, the letting of the school's premises to members of the community for private functions, services, and the like, in order to augment the school fund. Subparagraph Roman figure 3, function held for the staff of the school, and subparagraph Roman figure 4, instances where the staff members live on school premises by the school, provided that the governing body of the public school, in consultation with the head of department, may attend to the possession and consumption of liquor in the living quarters of staff members. Such restrictions over and above those contemplated in paragraph C. Paragraph E, in deciding whether or not to grant permission as contemplated in paragraph C and D, and whether or not to attach restrictions as contemplated in paragraph C, the governing body of a public school, in consultation with the head of department, must take into account at least the factors. Subparagraph 1, whether the school will be able to provide a staff delegated by the principal or delegated by a governing body to monitor the function so as to ensure that liquor is not consumed irresponsibly and is not served to already intoxicated persons, and that the restrictions contemplated in this paragraph C, G, subparagraph are adhered to. Subparagraph Roman figure 2, whether children will be present at the function, and subparagraph Roman figure 3, if children will be present, whether the organizers are willing to give a written undertaking to ensure that liquor will be available to children. Paragraph F, in all decisions taken in terms of paragraph C, D, and E, the best interest of the child must remain paramount, and the right is that of protecting children from exposure to harmful practices, such as the irresponsible consumption of. Paragraph G, possession, consumption or sale of liquor as contemplated in this section is subject to subparagraph Figure 1, the Liquor Act 2000, some restrictions imposed as contemplated in paragraph E. Paragraph B. By the substitution for section 2 of the to sub his or her delegate at random such a learner or any group of learners on the or the property of a learner or group of learners for any liquor, dangerous or not a bold text that is muted, illegal drug, and reasonable suspicion has been established. Paragraph A, a dangerous object, a drug may be found on school premises during a school activity, or paragraph B, that one or more learners on school premises or school activity are in possession of liquor or drugs. Paragraph C, by substituting in subsection 5 for the words preceding paragraph A of the following words in subsection dangerous object or that has been seized must be section 6 of the following subsection 6 if the police cannot dangerous object or drug from the school immediately. The principal of it must, subsection paragraph A, take the liquor, dangerous object, or drug to the nearest police station, and paragraph B, hand the liquor, dangerous object, or drug over to the police to dispose it in terms of section 31, the Criminal Procedure Act, 1990, the Criminal Procedure Act of 1997. Paragraph E, by the substitution for subsection 7 of the following subsections, 7, the police officer issue a receipt for it to the principal, to his or her delegate. Paragraph F, by the substitution for subsection 8, the principal or delegate may at random administer a urine or other non-invasive test to any learner or group of learners that is fair and reasonable grounds suspected of using liquor or drugs after taking into account all relevant factors contemplated subsection 3. Paragraph G, the substitution in subsection 9 for the words preceding paragraph A of the following in subsection 9, a learner contemplated in subsection 8 may be subjected to a urine or other if in paragraph H by the substitution for subsection 12 of the following subsection 12, a learner may be subjected to disciplinary proceedings if paragraph A, liquor, a dangerous object, or any drug is found in his or her possession, or paragraph B, his or her sample tested for liquor or any drug, and paragraph I, by the substitution in section 14 for paragraph A of the following paragraph, a search contemplated in subsection 2 was conducted and liquor, a dangerous object, or any drug was found. It ends the Chair, Honorable Chairperson, ends there.
That's clause 8 members. Principal.
My chair, thank you. Yeah, on this clause, very long and winding. Let me right away say we sympathize with. See, the intention might have been good, but is not executable. Yeah, I think that English is the dictionary. Execution part of is the most controversial part. And you see, you talk about liquor and then um, possession of liquor and later on, and also being legalized, and then the dangerous objects, also bad, and the stupefying the drugs, also bad. But later on, you say during the weekend it could be sold for whatever reason, as it is said. So the whole thing is causing terrible confusion, and it made us during the public things. To an extent, we were called names, or we have earmarked the teams. And then we swallowed. We had to swallow our pride and admit in all those what we've been told. In almost all public hearings, this clause was shot down. And it will be a terrible misrepresentation in this portfolio committee meeting to think we can try and defend it. And then after all, Gamwara Bibili, only this clause here usirise milikong, umorupuluse bobe. So to approve liquor during weekend and then say during the week this and that, it creates a problem here. They are leading people into temptations. Some will still be drunk on Monday, and then those some of the teachers, because you have officialized something in the school, even though it is for the time being. My Bible further goes on to say, anything which is similar to save. So this thing is not executable, and hence it is in this light that I say I want to propose to my fellow colleagues in the public, we shoot it down. Thank you very much.
Sorry, thank you, Chair. Chair, you know, I'm a product of Bantu education. I come from the time when Trainer was still a minister of Bantu affairs and all of that. Even in his time, he would never have put a thing like this for children at school, including African children. This would never have happened. Now, in this democratic government, to be getting some kind of a proposal that seeks to normalize alcohol in the premises is totally repulsive proposal, this, when we are trying to look after the interests of the child. Once these people are drunk from these functions, from a school function, then they go home and even beat up children and all of that. So I don't want to waste a lot of time. I really think the good work that the department is doing will be undone by trying to drunkenness and making it fashionable school premises. Even weekends, whatever, we must treat the school as a sacred place. This is the formation of our children. This is the formation future. Now, if you put alcohol in a school environment, what do you think you're doing? You know, so pictures have to be taken there with the people getting drunk at school and children thinking these are role models and all of that. So, Chair, I think the whole thing must just be taken out. No permission, this permission, that. Strike the thing out, and then we do other things. Thank you.
Very much, Chair. I was hoping before the department like did earlier on, they have stood and say we roll. we withdraw this because it's in all public hearings. This is the most rejected clause in the entire process. So I think as a public rep myself, somebody who's here representing at least some section of South Africans, I want to speak with authority that I also don't support. So I'm hoping that when we give to the department, they will give in and say that they are withdrawing so that we don't have to even speak about it. Probably, I don't know from where, it made sense to them, but honestly speaking, we can't have a liquor license requirement saying it must be certain of alcohol should be certain kilometers away from the school. And then we say, because there's a rugby match between St. George's High School and St. Philip's and St. Edwards. I did call it, I will not that. Because they are playing rugby, they must be allowed to sell alcohol. It was unfortunately it was going to be abused by certain SGBs and schools, and it was going to end up really affecting our kids. I'm happy that the public, the general public of South Africa rejected it. I'm hoping the department will also come and withdraw and apologize for such a thing. I think they did not, I think there was a mistake somewhere there. So yeah, so that is my suggesting. What is that? The weekend, the school. So it was in Philips, it's about that. Who were good benefit from this. Thank you very much.
Come on.
No, don't be scared, Honorable. I won't respond. No, Chair, I think, we sympathize with the public on this, and they've got quite genuine concerns about liquor just generally being a challenge in South Africa. I think, traveling the country almost every week to go do oversights and help communities, you even find, some liquor establishments not far from schools, even against the law. And sometimes you ask yourself the question, how are they so close? And we know very well, the cause of gender-based violence and so on. So the concerns of communities are generally well put, and there was a reason behind it. But the flip side of the coin as well is that we also find ourselves in a situation where we live in communities where there's not enough facilities to be able to use for various other activities. If you go to my village, there's no community hall. The church itself is under a tent. If there had to be a wedding there, the only closest public building they'll be able to use is a school. So I think maybe the rationale behind it as well from the department may have been understood. That, sometimes the communities may need to use those facilities for their own functions. But the concern raised by communities in our public hearings, but generally in the country that we are aware of, alcohol is a problem. I also want to indicate, Chair, that, the Quintile 4, Quintile 5 schools that Honorable Itzia refers to, also have what we call budgetary constraints because they get a certain allocation from the department. And they have to find other means to make sure that they preserve and uphold the standard of infrastructure in those schools, employ more teachers through the SGB and so on. These mechanisms do help in making sure that, they fundraise for them. But we can't take away from the great risk that has been put there around the selling of alcohol in schools. And I think maybe thought out, terms of how it was put there. That we should revert to a situation, a custodian of the school, given the power to play a particular role, should facilitate discussions of any activity that needs to happen on a school premises. But this particular clause itself has not passed public participation muster, and I don't see how we would even consider it moving forward. But I do think that whatever arrangement is available for school governing bodies and the department at the moment for the utilization of school facilities or any activities that has relation to fundraising should remain, unless there is an alternative that is put on the table of how matters of this nature should be facilitated. There is a liquor law in the country, and I think that should guide us at all points. So I just thought it's important for me to make those points as to what the rationale was behind, because I think it's one of also the most misconstrued clauses in the public participation, because people may have not understood it. But as be as it may, Chair, I will submit those points. Thanks.
Thank you, Chair. Chair, ek weet nou nie wie verkoop wyn gedurende die kerkie. I don't know if anybody sells wine or a liquor during during church functions, as per the description. But I want to concur with what was said. I think the sale of alcohol and the impact of alcohol in our communities was well expressed by every single, I think, in the majority. I don't think there's even, we can count on our fingers if anybody spoke to support this amendment. And I would also say, Chair, that it was for many community members an insult for the committee to even, and they made the committee responsible to even have this amendment being considered by them for submission. Thank you.
Thank you. Boshoff?
Honourable Chair, thank you. I must add my sympathy to the department, because, I mean, some people were really, we saw it when people came to give their testimony here and also in the provinces. I was only in the Northern Cape, as you know. But there are some questions which I still have if we do not include this. What do we do with a staff member who lives on the premises? May that staff member not consume any alcohol in his own home? Or how does a church go around with communion on a Sunday? May they only use grape juice for communion? And also, I think there are well-established practices going on without scandals or catastrophes, where at certain functions there is alcohol available. I mean, it is the case at the moment. Without turning the school into a shebeen, is all that going to be illegal from now on if we do not accept this? Maybe the department could also inform us on what basis is it done at the moment. In Kimberley, they refer to something with which I'm very much acquainted, and that is the Willekławer Week for winter sports, rugby and netball, and the people come from all over the country, and the schools compete with each other. And the beer tent, if I may say, is a prominent part of the whole event, and there's nothing flowing out of that the whole Kimberley drowns in the beer afterwards or that weekend or anything. People use it with a level of responsibility. But I understand that the way it stands here, I would be able to apply to a school to rent their hall and, in fact, have a shebeen there. And then I would just say, no, but, you know, it's legal. I may do this. and it's definitely not the idea of this. So, on the one hand, I think, could we refine this? And on the other hand, I think the reaction, the popular response was so forceful that maybe it's beyond salvation. That's the idea I got, but I wish there was another way. Thank you.
Honorable Batlingos.
Chairperson, this topic is traumatic. Look, we have a traumatic past as people who are coming from the townships, and of course, there are those people who could accept to have liquor every now and then, in places like schools, as Honorable Vaynard is saying. But I believe that if schools should be respected and changed, they should be sacred places where nothing like that is accepted whatsoever. Even if someone is staying there, that person should know that there is no liquor allowed in that space, and it will set up a very good precedent that school is a very, it must be a very protected space.
DBE.
Chairperson, we know what you wanted to achieve with that clause, but our views are immaterial now. The removal of the clause doesn't make any material difference to the bill. There are more important things in the bill that we want to achieve. So withdrawing the clause with its sub-clauses.
Legal people? No comment? Clause 8 removed. They don't want?
Not fights that you can win. You must speak about vice correctly.
All right, clause 8 removed. Now we move to clause 9. Suspension and expulsion from a public school.
Chairperson, correction. It's not clause 8 that you're removing. We're removing the alcohol bill.
Oh, we're removing one?
We're removing the section that deals with conditions for the sales of alcohol and its subsections.
8. Oh, okay, all right. 9.
Amendment Section 9 of Act 4 of 1996, as amended by Section 7 of Act 48 of 1999, Section 2 of Act 24 of 2005, and Section 7 of Act 15 of 2011. Clause 9, Section 9 of the South African Schools Act 1996 is hereby amended by the substitution for subsection 1 of the following subsection 1, paragraph 1A. The governing body may, on reasonable ground and as a precautionary measure, suspend a learner who is suspected of serious misconduct from attending school, but may enforce such suspension only after the learner has been granted a reasonable opportunity to make representations to it in relation to such suspension. B. Serious misconduct by a learner is defined as subparagraph Roman figure 1, physical assault of a learner, employee, or other person related to the school with the intention to cause grievous bodily harm, or the imminent threat to commit such an act while on school premises or during any school day activity, or in any circumstances that could reasonably be connected to the school. Subparagraph Roman figure 2, any form of harassment including sexual harassment of a learner, employee, or other person related to the school, including via electronic and social media. Subparagraph Roman figure 3, repeated offences related to bullying or the imminent threat to commit such an act. Subparagraph Roman figure 4, the illegal possession of a drug or liquor. Subparagraph Roman figure 5, the repeated disruption of the school program or the imminent threat to commit such an act. Subparagraph Roman figure 6, serious transgressions relating to any test, examination, or examination paper. Subparagraph Roman figure 7, fraud. Subparagraph Roman figure 8, theft or any other dishonest act to the prejudice of another person. Subparagraph Roman figure 9, the possession of a dangerous object while in school premises or during any school activity or in any circumstance that could reasonably be connected to the school. Subparagraph Roman figure 10, the possession or distribution of pornographic material. Subparagraph Roman figure 11, engaging in sexual activity on school premises or committing an act of sexual assault or the imminent threat to commit such an act. And subparagraph Roman figure 12, any other serious act contemplated in Schedule 1 to the Criminal Procedure Act of 1977, Act number 51 of 1977, that prejudices the constitutional rights of learners, employees, or other persons related to the school.
Thank you very much, members. That's clause 9. No comment. Honorable Mani.
Thank you, Honorable Chair. I'm just wondering if, that formulation of not limited to is also not applicable here. I note, though, that there is that Schedule 1 of the Criminal Procedure Act. I don't know it off by heart, so I don't know what is contained or not contained in that Schedule 1. So I don't know what we're dealing with there. So I'm just wondering if, I just want to make sure that we leave nothing outside. That's all. Thank you.
Honorable Sukers.
Yes, Chair. So, yeah, clause 9, section 9. This is an example where the Children's Act and the Child Justice Act principles are not being applied. Could we perhaps consider here adding a consideration of the rights of victims and of other learners at the school, because this clause has a sole alleged perpetrator focus? That is my question and my comment. Thank you.
Honorable Principal.
My Chair, thank you. I just want to rise to say I support this amendment. Thank you.
And then, Honorable Itzia.
No, thank you very much, Chair. I think what this clause is trying to do is trying to respond to a situation where certain schools just want to get a reason to suspend and expel some students or some learners just because probably they don't like them or whatever the case may be. So I believe that it's intentionally explained this fashion so that it protects certain, some learners from being targeted. So you see here it explains what is a serious misconduct, and because if it's not explained, certain schools, they can use any misconduct and say they are using their own thinking to say this one is a serious misconduct, just because they were targeting that child from January, when probably those kids would have tweeted against the school principals and the schools, because some schools they don't want to allow students to tie their hair like the whip has done. So they will say, no, we don't take this kind of and maybe in January these kids they tweet and say, no, we can't allow to be taken this session. So Baba Bambara. And then later on a child arrives late, but no, it's a serious misconduct in the next function. So I think I support the bill because it clarifies what is a misconduct, minor or major. Thank you very much.
So that we don't waste time, Chair. With that explanation, I withdraw my input.
DB.
You are making some alliance
what's on it?
Order.
I'm looking at the definition there, where the governing body may, on reasonable grounds and as a precautionary measure, that maybe lawyers, we may not cover Honorable Sukers there, as one of the reasons being the protection of victims in that sentence, that we may be able to cover here as well, that the grounds of suspension also includes the protection of, because here it just mentioned it is on reasonable grounds, and we include that too. And then also cover Honorable Manye, not limited to. So we list all those and say not limited to those. I think the lawyers on my right may be able to find ways to play around with that. Thanks, Chair.
Legal people.
No, I think, Chair, not limited to, although I had proposed, is open to abuse. This is the explanation I got. Because now what you're going to have is that people are going to just make up their minds and say, you know, like you were saying, I mean, children can get suspended today simply because he's got an afro hair. And they say, we don't want this afro hair. And if you continue, we'll suspend you. And then they do this. So I think to be exhaustive like this, in this case, is justifiable. So I think we should leave it like that. And there's an addition here of Schedule 1 offences, because those Schedule 1 offences, I'm sure it will be objective measures that are there. So you leave nothing to chance. So nobody can just decide that because your father dropped you here off with a Lamborghini, you must be suspended. You know?
You're fine, Stanley. All right. Sukers?
Yeah, I think the part that is not responded to is the part that I have asked if that Mr. Ndlebe referred to the lawyers to respond to. So that part is not, I have not withdrawn what I have requested or asked. Mr. Ndlebe correct that he referred my comment to the chair, to the legal team. Am I correct? Did I hear you right?
It didn't sound like a request per se. I said find space. So I was asking them to find space to put that statement in.
Yes.
So that's how we close it, that they will find space.
Okay.
Fine? Yes. All right. Legal people, no comment? Find space?
No comment, Chair. I think we'll wait for the department to propose an amendment. We'll work with them regarding a possible amendment to incorporate that in the clause.
Next. Clause 10.
Amendment of Section 10 of Act 84 of 1996. Clause 10, Section 10 of the South African Schools Act 1996 is hereby amended by the substitution for subsection 1 and subsection 2 of the following. Subsection 1, corporal punishment is abolished, and no person may inflict or impose corporal punishment to a learner at a school, during a school activity, or in a hostel accommodating learners of a school. Subsection 2, any person who contravenes subsection 1 is guilty of an offence and liable to a conviction, to a fine, or to imprisonment for a period not exceeding 12 months, or to both a fine and such an imprisonment. Clause 10 ends there, Chairperson.
Anyone? Members? Honorable Principal, not either?
Yeah, short and to the point. Chairperson, thank you for the opportunity. There is no way in which we can lock horns with this kind of an amendment. We are from a bad past, Chair. Seated where I am, and underneath this soil, there are innocent people who died and were buried, having done nothing because of the capital punishment in South Africa. We don't want to start by citing an example, but the most gruesome once in 1983 was when innocent blood Marcus Mutau Mogwerane were hanged. As if that was not enough, you can even talk about Solomon Kalushi Matlangu, the young man with whom we are sharing the birthday. And they were killed, unfortunately, and in a brutal way. And the same thing is still happening. Of recent, when we were starting with the celebration of the Women's Month, there was, but I don't know where this woman come from, who was assaulting the innocent child, kicking that child. It was all viral. And these things are continuing to happen even in our schools. It's a very painful exercise. Hence, we say you can speed up on the lines of alternatives to corporal punishment. Whether you finish them today or next year, but corporal punishment in principle, it must be abolished in no uncertain terms. So we support this bill. Thank you very much. Amendment, of course.
Not other?
Thanks, Chair. I don't have anything specific on this particular amendment, but I do think that what came out of the public hearings was, what's the recourse mechanism for teachers or educators? And maybe the partners where we'll find the recourse mechanism, other than the South African Schools Act or the Employment of Educators Act. I'm not too sure which section it is, but part of the issues that were raised was, I mean, we know all the behavioral problems we've seen in schools. I don't think I should belabor the point. But the question was to say, all good and well, let's abolish corporal punishment. But what recourse mechanism do teachers have for children who bring pangas, knives, and other things at school to inflict some form of violence to teachers? Because there's a lack of discipline, behavioral problems, and so on. So I do think that the other side of the mirror side of the discussion must be to say, how do educators still do their job without a challenge of misbehaving learners in school? So maybe, I don't know if that's something that has been well thought out, but maybe we could be direct where that is located. But in terms of this particular clause, the principle is correct, but there must be a recourse.
Yeah, Chair, I just wanted to bring out what was brought out by the teachers in the different sections. It's all corporal punishment, abuse and corporal punishment in the way that I got corporal punishment at school is two different things, I would say. But that's, I'm not going to go into in terms of the extremes when we have people abusing people. But also have is there must be an acknowledgement of the outcry that was in all 9 of the provinces. And Honourable Nodada referred to that in terms of guidelines for discipline and recourse. There must be, it must be addressed somehow with the removal of corporal punishment being abolished and it being written into law in the way in this amendment. It must be that the guidelines must accompany the change, because in doing so, the teachers that has made their voices heard to say that our schools are ungovernable and that there is no way for there's no recourse for teachers to instill discipline. That must be addressed by the department.
Honorable Itzia.
Thank you very much, Chair. I think I agree with the speakers who are saying there must be an alternate to corporal punishment. Because what is currently happening, Chair, in one of the WhatsApp groups would have shared some videos of kids from a school in Western area in Simonia called TM Letlhake, where gangsterism was the order of the day. Teachers, you know, they were running away from these kids because one, when they put themselves against these children, we say it's corporally punishing these learners. So they must just allow them to join these gangs and make everybody's life. Imagine, as a teacher, you're a parent there. And this, you see these ones, they are stabbing each other, you know, breaking bottles and about to stab each other. You can't even touch them to separate them, because when you do that, the explanation was that that is corporal punishment, laying your hands on that student. So as much as we agree that the corporal punishment must not be there, I think we can't afford to let it be this way. So what I want to say is that the department, as soon as yesterday, the principal must finalize these guidelines of what is alternate to corporal punishment, so that one, we're able to protect the lives of other students against these others who are unruly, but also the lives of teachers there. I'm a child of a teacher. Mother was a principal. I can imagine, not as my father here as a principal. No. Imagine not having teachers not protected because of this corporal punishment. I don't think it will work. So the department must work as fast as possible guidelines of what is alternate to corporal punishment. Thank you very much, Chair.
Honorable Mani.
Chairperson, I think context of the flow, this bill. If you go to paragraph 9, these are where all the misdemeanors are dealt with, and all of that. And in fact, because we said we wanted to make it exhaustive, so that there is no room for playing around. Maybe we can add gangsterism in that list, and all of that. All the wayward behavior of these young people are dealt with there, that they must be suspended. What more do we want? So if we think there's a particular activity, just add to the list on 9. Then we know that all the matters are covered. What we are not going to... Is that a point of order, Chair?
No.
Okay.
No.
All right. What we are not going to do, Chairperson, which we should not even consider, is to try and find justification for teachers to children, to justification for teachers. You know, if a child is hitting a teacher, report him for assault. Let the police deal with that. Let's not create anarchy at school. Let's not create, you know, all of these funny things. What seeks to do seeks to remove abusiveness by teachers. Others, they slap you. Others, they do all kinds of things. You know, I mean, like honorable member behind me here, she was saying corporal punishment in her time is different to what's happening now. I agree with her. We're probably agreeing on this one point together. Yeah, I know we're closing, Chair. But what is happening now is war at school. So I think this clause is proper. Any other wayward behavior, put it at 9. And let's not mess up this clause.
Principal.
You see, Chair, thank you. I spoke at first, and many people, when they spoke, it was a bit of a provocation, but I'm just going to say this. The issue of discipline, you see, I started teaching in 1981, and the time I went to school at a high school, I was appointed the chairperson of the disciplinary committee. Let me be honest, that the fact that kids can be outrageous and what, hey, I've not seen. I went through 4 high schools, and the last high school where I lasted for 20 years as a principal, after having served 10 years somewhere, it was one of the most controversial schools, surrounded by up to 4 shebins. But let me be honest that I never had a problem with the issue of discipline. You see, the department will not come to our school and discipline learners for us. The discipline starts with you as the parent or the teacher. I even taught some of the people I schooled with in Form 1, Form 2, or Form 3. I taught them. But when the time came during break, when I stand outside, everybody was forced to run. So why are we crying foul about discipline and say we must end up corporally punishing the kids? The department can come with the guidelines, but the guidelines will not bring discipline in a school. It must start with you and all these teachers. You go out during the weekend, you drink liquor with learners, and you think then on Monday you will discipline them. I go on. It will not work. Thank you. I wanted to say this.
Chair, the other that I just forgot to mention is the issue around special needs. Again, I know there's a case, I cannot remember it. I'm speaking now from memory and not accurately, so possibly in terms of the detail of it, where a learner was constrained, an autistic learner. And I did ask when I was preparing for one of the advocacy groups to provide me with some of the detail around the issues that affects special needs children, particularly in terms of the issue of constraint, when children needs to be constrained. And in that case, there was a potential of a carer and a person being accused of handling the student in a way that is abusive, but it was to constrain the student. So my question is, should there not be, in this case, a definition in this amendment that allows that, especially with special needs children, that when the issues of discipline or the issues of addressing behavior that is a result of special needs, that exemption be, or exemption or definition, I do not know, I can be guided by the legal team, be put in this amendment. Thank you.
Boshoff.
Thank you, Chair.
I would just like to add that school is actually a kind of it's a place where power is exercised. The power relations in school is something which has been the subject of a lot of analysis, all the structural kind of power relations and manifestations of power. But power, just like nature itself, doesn't keep a vacuum. And if the teachers lose their authority, then the bullies are going to take it over, and they don't hesitate to exercise corporal punishment. They do it at will and fastly, and it is something which has to be addressed with a long process, due process, as it is said, and like our colleague said in the previous section. So, although I don't think I'm worse off because of the many hirings I got at school, I'm not advocating for corporal punishment. I know times have changed. But one must really, if I could say it of my own experience as a teacher, sometimes you don't want to act against a certain learner because you want to be sure that that learner really did something wrong. And then afterwards you find out you protected the wrong child. You protected the aggressor. And the victim did not find your protection because you wanted to be too sure. Now, you can never be too sure, but, you know, I say it as a matter of speech. You want to be so sure that you protected the wrong child. And if one has anything that you look back on and think, yeah, I should have done that differently, it is at times that you found that you actually protected the wrong learners. And, well, it's one of those things, I say it often, we can't legislate everything, all our problems gone, and we can't legislate all the good things in. And a lot of it revolves around persons with moral authority. And it does not surprise me when Honorable Murachela says he did not have problems with discipline. Because some people may just say something in a calm voice, but it conveys a kind of authority which makes a learner back off. While another one can scream on the top of his voice, and it actually just fans the flames. So it's difficult. This is a kind of thing that is very difficult to legislate into perfection. It's all about the professionality of our teachers, the way in which they conduct themselves after school hours, as others also said. But I must honestly say, I have a little bit of a concern that this very strict, I would almost say Finnish kind of description of corporal punishment may have problems, and I'm actually referring to the kind of school where I had been before 1994. I'm not referring to other schools. I was in a school where they were, you know, strong guys, and they didn't actually like people that disagreeing from them or withholding things they asked or something like that. And punishment did quite a bit to keep them in order. I'm sure if alternatives which is effective.
DBE.
Chairperson, I'm losing the discussions. I don't know what we're discussing. I thought it's just a clause that says no corporal punishment in schools. But the discussions are going to an extent of saying, yeah, we agree with the definition, but then we bring all these other things. Can we focus on this clause? No corporal punishment in our schools. Are you agreeing with the clause or are you not agreeing with the clause? Now, I understand the other things that you're bringing in. I think, Honorable Manye, I should have just invited you to respond on our behalf, because the previous section is talking about misconduct of children. So if children are beating up teachers, It goes up there in that section where you talk about the code of conduct and what is said to be a serious misconduct and not. And it's not just the beating of teachers, it's the beating of other children in the school, the beating of the staff in the school, anything that is a form of violence will go up there. So when you talk about the recourse of teachers that get beaten, the recourse is that the SGB must sit and either suspend or expel the child and all. So that is the recourse. If it's a criminal offense, a teacher is beaten, it then becomes the subject of a police to deal with that. So in this clause of corporal punishment, we can't bring all these other things like we're doing. The issue of restraining children, I think we dealt with it when we were talking about the definition of corporal punishment. When a teacher finds himself in a situation where he protects himself and he defends himself, definitely it falls under the issue of a corporal punishment, because this is not when the teacher was trying to help for something else. It becomes a self-defense type of a thing. And any teacher that is charged with misconduct because he has applied corporal punishment, it's not a given that it was corporal punishment. A teacher is subjected to a due process where there will be witnesses and answers whether it was indeed corporal punishment or we were just restraining this child or it was an accident. So our courts are open to that. And this is one section that falls under the SACE responsibilities. SACE follows up on teachers that are charged with misconduct, but they don't just charge them and expel them. They have to follow due processes. And it will be determined whether it was indeed corporal punishment, or it was an accident, or it was self-defense, or we were doing it in trying to restrain a child and all that. So, Chairperson, our request is, can you deal with with that clause and say no corporal punishment without putting but what happened? But the issue of alternative to corporal punishment, yes, we're taking the challenge. We said we have begun dealing with it. Allow us to finish that process, it will be there. And the reminder again, we said it doesn't mean there are no systems in schools to deal with discipline in schools. Schools are using that. They are disciplining learners as we speak. But if they become criminals, please include the police. And that's how it is. Or follow your code of conduct on how you suspend and how you expel them and how you do all sorts of things that are in the code of conduct of the school.
Okay. Advocate.
Yes, Chair, this particular provision is not new. It has been there since the beginning of the South African Schools Act in 1996. So what this amendment seeks to do is just to broaden the prohibition to also include corporal punishment at hostels and during school activity as defined in the Act. Now, the Act defines school activity as any educational, cultural, or sport activity of the school. And this provision was also challenged in the court in the case of Christian education versus Minister of Education, where the provision was challenged on religious grounds. This particular applicant, Christian Education South Africa, indicated that this is transgressing on the right to freedom of religion, because they say it's a religious right to discipline the child. This case was, the Constitutional Court found that indeed the corporal punishment is a breach of a child's right to dignity. And this particular provision was upheld by the court. So it already passed constitutional. Thank you, Chair.
Our lawyers at the back. We are fine. So what do we do now? Do we say DPE must look into other ways?
No, so there's nothing.
We agree. No. Aibo. Suker,
We need to be guided here because we are speaking to DBE on the basis of what we heard from the ground as members. DBE cannot say to members that we need to restrict ourselves in what we cannot. We are the lawmakers, we're dealing with the law, and we are dealing with the issues that we have heard from the ground. Now, when we speak of the guidelines, from the ground, in the public hearings, people were saying they want recourse and they need it. We cannot have the department say to us as a committee, I'm telling you that we are dealing with it and we will get to it. The committee is saying we need the guidelines as this is being now put into the amendment. We need a commitment from the department in terms of the guidelines. It cannot be that we are being told what can we say or not by the department.
Honorable Tia.
Chair, I think everybody is on the same page that we're accepting the change. I think the emphasis is that what is the alternate to, what is it that must be done? The department must help us there. Because don't refer to section 9. It speaks about something else. But the alternate to corporal punishment, we need for them to speak the issue of the definition is the alternate tool. What is it that we can do for our schools to run outside of corporal punishment? We accept section 10, Chairperson. Let's go to section 11. Thank you.
Honorable Maji.
Chair, I think we're confusing ourselves here. When something sorry, very straightforward. 10 talks about basically the abolishment of corporal punishment. Now, if the honorable member behind me is asking as to what is the alternative, what alternative are actually looking for? Because this is about saying that don't beat up a child. Now, you say, what must I do if I don't beat up a child? We are saying, then we can find other softer things to say on section 9. If this is too strong here about gangsterism and drugs and whatever. If you have a child that does not do homework, what do you do with the child? What is it? I mean, it's almost like we're looking for a justification to beat up children here. You know, section 9, if anything, then we can maybe have a subsection of not suspended, maybe, I don't know. But it's in that category. We must not get ourselves confused. Section 9 is the category that deals with a wayward behavior. So we can classify it that wayward behavior. So your recourse as a teacher is on section 9 to say it's at this level of severity. But if it gets to a serious misconduct, that is section 9, then you suspend whatever. Maybe they must have a subsection on subsection 9 that talks about not serious, then they should deal with it. But section 10 is dealing with one thing only, no violence. That's all.
Okay, fine. Sizwile.
Thank you.
No violence, no corporal punishment.
Yeah.
And no alcohol.
Chairperson, we also accuse of not taking instructions from the committee when the committee instructs us to come up with alternative. But we have been saying it the whole morning that we have started. We're working on it. Yeah. That is why we are told speeding up the process. Taken like we're not listening. We said we're working on alternative to corporal punishment. Give us time to do that.
Okay.
Sorry, Chair, point of exigence. There should not be any alternatives that we're working on. Is it alternative to be violent to children? What are we working on?
Clause 11.
Amendment of Section 10A of Act 84 of 1996 as inserted by Section 5 of Act 50 of 2002. Section 10 of the South African Schools Act 1996 is hereby amended by the substitution for subsection 1 of the following subsection. 1. A person may not conduct or participate in any initiation practices against a learner at a school, during a school activity, or in a hostel accommodating learners of a school. It ends there, honorable members.
Thank you, members. Prohibition of Asian practices in schools and hostels. Great.
All agree.
Clause 12.
Amendment of Section 12 of Act 84 of 1996, as amended by Section 8 of Act 15 of 2011. Clause 12, Section 12 of the South African Schools Act 1996 is hereby amended after subsection 3 of the following subsections. 3. The governing body of a public school may in writing apply to the member of the Executive Council for the public school to be designated as a school with a specialized focus on talent as contemplated subparagraph from figure 3. 3. Head of department may, after consultation with the governing school, identify this and recommend to the member of the Executive Council be designated as a public school with a specialized focus on talent as contemplated in subsection 3, paragraph A, subparagraph Roman figure 3. 3C, the member of the Executive Council may in writing designate a public school from which an application contemplated in section 3A has been received and a school identified and recommended contemplated in subsection 3B as a school with a focus on talent added in subsection 3, paragraph A, subparagraph Roman figure 3. If it is in the interest of education in the province, and if the school complies with the norms and standards determined by the minister in terms of subsection 3, paragraph B. 3D. Before designating a public school as a school with a specialized focus on talent, as contemplated in subsection 3, paragraph A, subparagraph Roman figure 3, the member of the Executive Council must, paragraph A, give written notice to the school in question and to its governing body of the intention to designate the public school as a school with a specialized focus on talent and of the other reasons thereof. Paragraph B, notify the parents associated with the school and the community in which the school is situated of the intention to designate the public school as a school with a specialized focus on talent and of the reasons thereof. Subparagraph Roman figure 1, by means of a notice in at least one newspaper circulating in the area where the school in question is situated, if any newspapers circulate in that area. Subparagraph Roman figure 2, by causing the principal of the school in question to item AA, hand to every school a notice containing the relevant information, and item BB, instruct the learners to hand the notice to their parents, and subparagraph Roman figure 3, by means of any acceptable form of communication that will ensure that the information is spread as widely as possible. Paragraph C, give the school in question and its governing body and any other interested persons an opportunity to make representations within a period of not less than 90 days from the date of the notices and communication referred to in paragraph B. Paragraph D, give due consideration to any such representations received. And paragraph E, be satisfied that the employers of staff at the public school have complied with their obligations in terms of the applicable labor law. It ends there, honourable members.
Thank you very much. Clause 12, provision of public schools. Honourable Manyu.
Chair, I'm just rising on not to deal with this thing specifically, but maybe to propose, given what ensued, that maybe from our process point of view, there is something missing. And I want to propose, Chair, that perhaps before we deal with a particular amendment, that the department must first tell us why was it necessary? What is that we're trying to do? So that when we go through it, we go through it with an understanding of what is this mischief that we're trying to cure, so that the discussion can be a bit more structured. Thank you. If you look at this one paragraph on 10, it took us a whole hour. Now, if I have 10 paragraphs here, we're going to be here the whole night. So we don't have a structure of what is it that we're trying to cure. So they must first tell us this is what we're trying to cure, and then we see if this is the remedy to cure that. Thank
So
you.
you are changing our approach now. Can you just make that clarity?
No. The clarity is the schools that we have at the moment are schools that you will do your normal general subjects, your math and science schools, your commercial schools. But seeing that things are changing, you now have schools of aviation, you now have marine schools, you've got agricultural schools, you may have schools that focus on music and acting and all that. So here we're saying if a community realizes that they want to change the focus of their school from a general school to a sports academy school, for example, then they can apply to the head of department and the MEC so that the school then gets changed and becomes a Rosina Sidibani School of Sports. That's what we're trying to do. And we're saying at the same time, the MEC himself or herself can also initiate the process and say, I'm looking at this, you are next to the sea, let's introduce marine whatever in order to do that. Do you agree? Then the clauses then begin to give steps that needs to be followed. The consultation, the writing, the advertisement, the involvement of all parents. So either it's brought by the SGB, the process is the same. Whether the department that is suggesting, the process is the same. So that we give these children more options and not channel them every time.
Isn't that nice, Chair?
Any hand on this matter? Clause 12, Boshoff?
Thank you, Chair. I would like to know if this might include some programs of the National Certificate Vocational, the NCV, which is actually managed by the Department of Higher Education. Maybe in many schools it might be appropriate to replace the FET phase rather with the NCV because it is more career-oriented. Would that be feasible in terms of, being two departments and that one would be hesitant to bring into a basic education school qualification which is actually managed by higher education, or was this not contemplated at all?
Honourable Lucia?
Yes, Chair, on a lighter note, we agree. I think we're moving on. I was just saying to maybe Honourable Boshoff that he must not, even though this will be specialization schools, will not be doing anything called specialization schools on Orania practices. Where they will not go.
Anything from the lawyers? Must we move? Clause 13, measure of schools. What? What I was saying? What? She must lead us. Yeah, but you said you must explain. Let me read.
Yeah, that clause is already in SASA, section 12, which gives the MEC an authority to merge schools. That is.
Where are we now, Mr. Lem? This is supposed to read clause 13. Okay.
Oh, okay, okay. Okay, it's fine.
Honorable members, we are now looking at the amendment of Section 12A of Act 84 of 1996.
Sure. Sorry, I was checking if my process that went 12 went smooth. Why don't you follow it? So what she's reading there, you must listen to it in context. I'm not saying she mustn't read it, she can read it, but can he give context first so that as he reads, we see whether that is responding to what it's to do.
Don't come and change our meeting approach, please. We have agreed on a way forward here. I'm not sure whether you were here already or what. What we are going to do, I'm going to follow what she's going to read. But then after that, immediately, Mr. Ndebe, then...
The logical thing is for him to start first.
Don't do that. Don't do that. We are going to chase you out.
What is that coalition?
Okay. Amendment of Section 12A of Act 84 of 1996, as inserted by Section 8 of Act 48 of 1999. 13. Section 12A of the South African Schools Act 1996 is hereby amended in paragraph A by the substitution for subsection 2 of the following subsection 2. Before merging two or more public schools, the member of the Executive Council must, paragraph A, give written notice to the schools in question and to their governing bodies of their intention to merge and of the reasons thereof. Paragraph B, notify the parents associated with the schools and the communities in which the schools are situated of the intention to merge the schools and of the reasons thereof. Subparagraph Roman figure 1, is in at least one newspaper circulating in the area where the schools in question are situated, if any newspaper circulate in that area. And subparagraph 2, Roman figure 2, by causing the principals of the schools in question to item AA, hand to every learner at each school a notice containing the relevant information, and item BB, instruct the learners to hand the notice to their parents, and subparagraph Roman figure 3, by means of any other acceptable form of communication that will ensure that the information is spread as widely as possible. Paragraph C, give the schools in question and their governing bodies and any other interested person an opportunity to make representations within a period of not less than 90 days from the date of notices and communication referred to in paragraph B. D, give due consideration to any such representations received, and paragraph E, be satisfied that the employers of staff at the public schools have complied with their obligations in terms of the applicable labour law. Paragraph B, by the insertion after subsection 2 of the following subsection, which is 2A, subparagraph A, the member of the Executive Council must, within 30 days after receiving the representations referred to in subsection 2C, take a decision whether or not to go ahead with the measure. And subparagraph Roman figure 1, in writing, inform the schools in question and their governing bodies of the decision. And subparagraph Roman figure 2, by means of the methods listed in subsection 2B, notify the parents associated with the schools and the communities in which the schools are situated of the decision. Paragraph B, if the member of the Executive Council fails to act in terms of paragraph contemplated in A, the contemplated measure will be deemed to have lapsed. Paragraph C, if the decision of the executive member is to go ahead with the measure, he or she must ensure that the measure is proceeded with within 30 days after giving notice, as contemplated in paragraph A. Paragraph C, by the substitution for subsection 4 of the following subsection 4A, if the member of the Executive Council decides to merge the public schools in question, he or she must, after consultation with the governing bodies of the public schools that are to be merged, determine by notice contemplated in subsection 1, subparagraph Roman figure 1, the date of establishment of the public school, subparagraph Roman figure 2, the name of the public school, and subparagraph Roman figure 3, the physical location and official at the public school. Paragraph B, the single school contemplated in subsection 1 must be regarded as a new school. Paragraph D, by the substitution for subsection 6 of the following subsection 6A, after the notice as contemplated in section 4A has been published, the governing bodies of the schools that are to be merged must have a meeting to continue a single interim governing body comprising all the members of the governing bodies concerned, with which single interim governing body will govern the new school for a period of not exceeding 3 months. Paragraph B, not paragraph B, subsection 6, subparagraph B, the interim governing body must, subparagraph Roman figure 1, elect office bearers, subparagraph Roman figures 2, decide on the budget, subparagraph Roman figure 3, reach consensus about differences in codes and of conduct and school fees, and if applicable, about contractual obligation and the utilization and disposal of movable assets. Subparagraph Roman figure 4, make recommendations to the head of department on personnel as well as on any issue that is relevant to the measure or which is prescribed in terms of this Act until a new governing body is constituted in terms of section 23 and 28. Paragraph C, the member of the Executive Council may extend the period referred to in paragraph A1 for a period not exceeding 3 months. And paragraph E, by the addition of the following subsections, which is section A8, a measure contemplated in subsection 1 does not affect the liability of any person to be disciplined or prosecuted for any misconduct, crime, or offense. Subsection 9, a learner is subject to the code of conduct applicable to the new single school as from the date of the measure contemplated in subsection 1. But if any proceedings in respect of a charge of misconduct has been instituted or commenced before the date of the measure, such proceedings must continue in terms of the code of conduct relevant to the public school immediately before the measure. Subsection 10, the new single public school or the head of department, as the case may be, may undertake rationalization or redeployment of its workforce according to operational requirements in accordance with Section 189 and Section 189A of the Labour Relations Act of 1995, Act number 66 of 1995, the Employment of Educators Act 1998, Act number 76 of 1998, and any ratified collective agreement that deals with the rationalization or redeployment of a workforce. Subsection 11, if two or more public schools are merged into a public school in terms of subsection 1, the new single public school continues with all academic programs offered by the former public schools under the programs applicable to the respective public schools immediately before the date of the measure, until such programs are amended or restructured by the governing body or education department where applicable. It ends there, honorable members.
Thank you very much. That's clause 13, measure of school. Dr. Jebe?
Thank you, Chairperson. We're not discussing whether schools can be merged or not, because that is already in SASA. But what we're talking about is the how to go about the merger. There are two types of schools, secondary and primary schools. But what is happening at the moment is that we've got a mixture of junior primary schools, sometimes senior primaries, some are junior secondaries where they'll start from grade 7 to 9, others will start from whatever, 8, 10 to 12 and so on. So these are misaligned schools. So what happens is that we need to ensure that our schools are starting from grade R, according to this new bin, to 12, and others are starting from 8 to 12, and nothing in between. So if a school is misaligned, then there's a need to remove some children and put them in another school so that there is that continuation. So that section 12 deals with that type of a thing. It then deals with a definition of what is a school, where we say a school, if it's a primary school, it should have a minimum number of children for it to exist. And the number that is put is 135. So if a primary school has less than 135, then it doesn't qualify under the definition of a functional school. Then it can be merged with another school to bring them together. And the high school, it's about 200 of those learners. The reason why this is done is that any school that has very few children will tend to have less teachers, because you allocate the number of teachers according to the number of learners. So a school probably that has 50 children will probably have 2 teachers, and 2 teachers can teach all subjects and all the required hours per subject and so on. So at the end, children end up not being taught all the subjects and all the required amount of hours that are supposed to be there. Then children don't cope as they progress with education. So it is important that these schools that are small are then brought together so that more manpower and be able to participate even in extracurricular activities and all that. So that is covered in SASA, and that's how it has been. Now, the mischief that we're trying to resolve by this amendment is that provincial departments were now not following procedure in the closing and the measuring of schools. They were doing it willy-nilly. And during the hearings, the public was saying, our school is being targeted, we were not told, we just got told that we are merging. We were not consulted. These things never happened. Other schools were merged, but then there's no system on what happens after the merger. So this section that Sisposhia was reading was saying, provincial departments, you have the authority to merge schools, but don't do it your way. Follow the following. So these procedures of gazetting the intention,
consultation, having to take the views of the public into it until the process is completed. So these are the steps that we have. Then the next step is, after the merger, then what happens? Then it gives steps. SGBs, this is what you do. And teachers, this is what you do according to the Employment of Educators Act and the collective agreement in the ELRC. So the whole section that has been read is about how do you implement Section 12 of the Measure of Schools. And it's a checklist for the public. It's a checklist for everybody. That if the school is about to be merged, ensure, tick these boxes that it has happened. If a box is skipped, then the measure is illegal. Then the minister can step in there and reverse that measure if it was not done accordingly. Thanks.
Members?
Chair.
Honorable
No,
Principal.
I just worked out why he keeps calling Section 13 Section 12. It's because we deleted Section 8. So he has already worked the numbers down.
Honorable, just to let members, there is tea outside. We are not going to break. We can grab tea, come back and have a working tea. And then it's principal, it's not Dada, it's Boshoff, in that order. Principal, are you fine?
No, I'm not fine, but my principal has advised me to talk after
Not Dada, it's fine. You don't want, can I move as per the recommendations of the department?
Thank you so much, Chair. This is a chance to get tea, Chair. It might take a while.
If you go for tea, we are proven fast.
No, I'm just joking, Chair. Chairperson, obviously this already exists. This is within the current legislation. I do think that obviously there's a need to exercise caution as she walks out. It's good to exercise caution on this particular point. I know there's been a moratorium in the Western Cape to close or merge small or non-viable school, because this is a very big issue for farming communities. And the reason why there is a big issue from farming communities, because in many instances these are the only schools that are available for children of either farm workers or those farming communities to be able to attend. And ultimately, when these schools are closed, you'll find that in the merger of schools, there's no mention of teachers losing jobs or being having to relocate, or the possibility of increasing travel costs for learners and all of those things. And I do think that it requires a different consideration, because even smaller schools make a meaningful impact in quality education. So I do think that there is a need for an approach to try and see how to protect the pockets of excellence of these schools that do exist, despite the fact that there's an understanding of those that are non-viable. I remember doing an oversight at a school in a farming community in the Free State, where there was one teacher for grade 1 until up to grade 7, I think, and she couldn't do justice to those children. So we understand those circumstances, but I think we do need to look at it from a case-by-case basis. And even though the law does exist to merge these schools, this particular clause outlining the greater procedure for a merger of schools, we need to also be cautious in how we deal with it. And there may be something that we may learn in what they are trying to do, for example, here in the Western Cape. I'm sure you will engage with them as a DBE, because it's a department that you work with directly, on how do we deal with those farming communities that have those concerns. And I think it's something that it was raised quite sharply in the public hearings by smaller communities, where these merger of schools happens where children are applying to a hostel at a very young age and so on. So I think we need to have a very cautious approach on this particular one, lining the process of how this does happen, but also saying what recourse exists to make sure that they are functional where there's no other alternative, as has been done, like I'll give an example where we are in the progress. Thanks, Chair.
Thank you, Honorable Nodata. Honorable Boshoff, you're next.
Oh, now I can speak. Thank you. I was thinking along this more or less the same lines than Honorable Nodata has just mentioned. But the angle that I want to have to it is to ask, well, actually to observe that there is no mention made of what happens to the facilities of the school which is vacated. Now, quite often the community might have some plan, some educational plan with that. And maybe that could also be, what's the word, formalized on, let's say the school, the community wants to make an independent kind of educational institution out of this. How do they acquire the buildings or the facilities and the land on which it is constructed and so on? Thank you, Chair.
Thank you, Honorable Boshoff. Honorable Sukers.
Thank you, Chair. Chair, I want to, the procedure that is outlaid is very strong. And the issue that I want to highlight, I think Honorable Mbe would be familiar with it. It's you are an honorable man, I think we can say. So what why I'm raising the issue of procedure is because the issue that is top of mind in all the members' minds, Siekugat Primary, for instance, it was not a merger but a closure, but I want to talk about the procedure behind it, is that the school was closed in December. It was gazetted only in May. And I think that speaks in May, but the school was closed in December, and so in January, those children was meant to then start at a different school, where all the necessary blocks of transportation, all of those things, and even the appeals by the community has not even been addressed. So the issue of process is very important, right, where it's needed. But I want to also, me and Chair and Mr. Ndlebe had a conversation actually about this, I think in Northwest, when we saw all of those schools, the mega school concept that he was speaking of. And this we must highlight. We're merging schools in those areas, and that was our conversation. The small schools, and we merged all together. I think in the Northwest it was 10 schools, if I remember. 10 schools were from the farming community, and they were all moved. I cannot remember the place that we were in. That the process of that and the impact that it has on those communities must be recognized. And the process that the department embarks on, especially where communities are very widespread, and the consultation processes, how it is done, like in the case of Siekugat, where you have people 30, 50 kilometers away. So how did you really do a consultation? How did you really reach them, and by which means? So that's why I'm referring to the fact that the process as laid out is very strong, but then we also, like Honorable Nodada has said, and he's come to Jesus moment in terms of the closing of schools and the merger of schools is acknowledged with the moratorium that they have placed because of Siekugat and the issues that was raised by in this committee, and because of the pressure as well from the committee. Thank you, Chair.
Honorable Litio.
No, thank you very much. Thank you very much, very quick. I just wanted to say, I think, to correct Honorable Sukers that the Western Cape Education Department did not take this decision to put a moratorium because of Segehat. It's because of elections. They've taken a decision of moratorium because of elections, because remember the moonshot, you are the Women's League of the DA. Thank you very much. It was on a lighter note.
I just need to correct that, Chair. I must correct that. There is no trips to the moon that the ACDP suddenly must. You shouldn't speak for us, You mustn't speak for us. Sir.
Order, honourable members. He said on a lighter note, take it in that spirit. Anyone who wants to speak before? Oh, sorry.
So close.
No, I wanted to check there before I give you the king.
The naira in blood. But she's even switching me off. Colleagues, Chairperson. Yeah. Chairperson, thank you very much. Let's first admit. You see, sometimes we need to face reality head on, DBE. If you go and Google and look for life stressful moments, you will realize, number one, they will talk about divorce. Number two, loss of a loved one, losing your job. And I've forgotten number four, but number five, they talk about, they just say moving. Moving. And when you go deeper, it's true. In as much as is something unavoidable, and something which is already policy or which is already ongoing in as far as the department is concerned. What we should to advise the department on this measure of public schools subject is that the ground must be well leveled. Consultations, I can see that you're talking about consultations. And even when you go through the consultation processes, you see, Chairperson, it's very important that the manner of communicating with stakeholders should be very well refined to such an extent that you don't communicate with part thereof and leave some of the stakeholders because communications lines were not cleared off. And one thing is, when such measures are done, are being accomplished, you see, you should not be seen moving kids or learners from the well-roofed schools and only to go and accommodate them in temporary structures. It demoralizes, it hurts, it affects their education level. And the last point is with regard to the transportation means. It does happen sometimes you merge two schools and only to find out that learners are unable to access the new school because there is no provision of scholar transport. It's one of the huge challenges. We can't change, we accept this, but we were just trying to indicate some of those highlights which you need to take into consideration before you arrive at the point that the two schools have been measured. It's true, we have got schools which are not viable at all, and as a result, the department must chip in the interest of education of our children. Thank you very much, Minister.
Thank you very much, honourable members. Before I... Yeah, I'm looking at it.
Sorry, I had no other way to call because you can't see me from where I am. I just had one clarity-seeking question, Chair. I think it was Honourable Mani, I'm not sure, that spoke about the infrastructure where schools are empty, or Honourable Boshoff. The reasons are mentioned, but are these limited to educational reasons? The draft policy on rural education acknowledges that in the rural areas, a school is not just a school. So the other question that I have, the two questions actually. The one is around the infrastructure. If the DBE is looking into what those infrastructure, I have many schools, for instance, that are open in the Karoo, nothing happens to it. Is the DBE working on a plan where those schools has already been merged, but there's infrastructure that is standing unutilized? I think Honourable Boshoff mentioned that. And then the reasons, I said what that was mentioned, I think Honourable Mr. Ndlebe has heard my question, the last one. Thank you.
You can continue by responding, Honourable Ndlebe.
Thank you, ma'am. Members are arguing on their experiences before the bill, where the frustrations was around consultation, schools closed without even consideration where they need to move and all that. This is exactly what the bill is seeking to achieve, that there need to be these procedural processes that need to be followed if a school has to be merged or not. So your experience is what the bill is trying to correct and give them those steps. Let me indicate that when we deal with the merger and closure of schools, we don't merge schools and close them at all cost. And members have been given the rest of the guidelines from the department that indicates that a school might be small and non-viable, but it may still remain untouchable. These are schools that are in mountainous areas, big rivers to cross, far away from another school. So those will remain untouched. But at the moment, we're sitting with over 1,000 schools in KZN that are small and non-viable. Another 1,000, we get them in the Eastern Cape. And some of these schools are in the same vicinity where children can simply be moved, and then we have a viable school out of it. So our proposal is that departments need to start moving faster in dealing with those schools. That will release resources at a later stage for those schools that we can merge and can close, that we can then give additional resources and additional teachers as a way of supporting. Specifically, you're mentioning farm schools, where nothing happens, the next school is 100 k's away, and it has 2 teachers. But if you do release resources from those that you can easily merge, you'll then find enough resources to support this one, where nothing can happen because it's the only school around it. We use the term called decommission. We decommission schools that we have merged and are left empty. What it means is that you take them back to the Department of Public Works. That's where they belong. We write them off from our books so that we are not responsible for water usage and electricity in there. Then Public Works need to see what to do with it. But before we decommission it and we take it back to Public Works, we work with communities so that they can guide us. Communities need to guide us on what we need to use the schools for. Let me give you these examples in the Eastern Cape and also in KZN, where distances from districts are too wide. Districts then utilize these schools as circuit offices. Sometimes they convert them and have subject advisors placed in there. You can also get that in areas like Witbank, where the office is in Kangala, but the circuit managers are placed in an old school that is in Witbank. That is one way we utilize old buildings. Another way we use it in Wamashu, in KZN, we found a school that has been closed, empty. There are 3 ECD centers operating there. One ECD center has 3 classes, another ECD center has 4, another one has 3. They are operating from the same environment, but the school, the children have been moved from homes into that school. And these principals, 3 of them, have demarcated the school and it's being utilized and it's being very successful. In other places that are very rural, traditional leaders use those schools as tribal offices and the community uses them. Then we normally give a community an opportunity to decide what they want to use the school for. It's only when we have failed and there's no need for the building to be utilized by anybody, including converting them into churches and all that, that's when we decommission them and send them to the Department of Public Works. But they are used as churches, they are used as ECD centers, they are used as offices by tribal, they are used as what you call cultural centers for youth centers by children in there. It's only when the community doesn't have a use for the school that sometimes might lead to demolition, because it might come a crime haven where criminals hide.
No, thank you very much, Mr. Ndlebe. Legal? No legal opinions? There's a Now, Boshoff.
Honorable Chair, thank you very much. I would like to just engage with Mr. Ndlembe on that, because there are at least 2 schools in the Northern Cape, 2 hostels, which exactly what you described now is happening. The corrugated iron is stolen from the rooftops, the light fittings are stolen, people are staying there without any documentation. Not that somebody without documentation doesn't require to stay somewhere, but it's not what the school premises was meant for. And in one of these places, the community has brought forward quite a number of suggestions about what could happen. So I mention it here in the hope that maybe you could direct me to the correct person so that we could really take action, because it's, the schools are in the main road. It makes the town really unappealing if you have this 2-story building crumbling down, literally. Thank you.
No, thank you very much, Honorable Boshoff. I think that was just a chat with Mr. Ndlebe. I think members are agreeing that the clause suffice.
Yes.
You will see that it is with the explanation that was given by Mr. Ndlebe. Can we then move to clause number 14? And I'm handing over to you, Chairperson, Ms. Posh.
You see, they are taking your
I am very glad.
In the spirit of the clause that DM has removed and the alcohol that we're removing, Honorable Litsia said, why should we go through this? And clause 14 we like to remove. Chairperson, it's a clause that talks to SGB members having to declare their financial interest, including those of their spouses and all that. In the public hearing, the complaints were that it's an administrative burden, and surely we have close to 25,000 SGB, up to 250 SGB members. And then if we were to all ask them to provide us with the declaration of finances, it was going to be a mammoth task. And people were saying to us, they are volunteers, and if we're going to ask them to give us these mammoth documents and going to the banks and all that, when they are volunteering. So we listened to that and said, it's not, we can live with that. But how we're going to deal with it is that there's a clause on recusal that comes in there that talks to an SGB member having to recuse himself when people are discussing issues where he has an interest. If it's an appointment and there's a relative in there, as an SGB member, you sign a form, you declare, and you leave. If it's a tender process that is being discussed, you want to build something and you are a contractor, you sign a form and declare, you leave. And that's how departments operate. Honorable Manya is a former HOD. You'll remember that when you deal with tender processes, there's a form that you sign to say, I declare that I have no interest in blah, blah. Then you're allowed to sit. And should it be discovered you're lying, it's something else. So instead of asking every member to be giving us their bank statements and their white bank statements, we're saying we're withdrawing from that and we'll allow SGBs to be elected as they are.
No, I'm saying on a lighter note, Chair, this thing of honorable, it's here opening my computer when I'm not here. And then, you know, I don't know, I walk in that is saying everything that is on here now. I don't know whether what you have got my password or what.
You've been which team yesterday if they are coming back?
No, I must sit behind now.
If you are being
Yeah. No. I'm happy, but
Are you also considering
Yeah, okay. Yeah, we will talk English.
Clause 16 deals with central procurement.
my brother is tired.
No, I'll have coffee not long, don't worry.
3 hours.
Yeah. Yeah. This one deals with central procurement, and we want to leave it to the honorable members to make a ruling.
Sorry, Chair, I may have been for a moment out of the meeting. Are we dealing with, is 14 and 15 deleted?
Yes.
Thank you, Chair. 16, we really want to leave it to the honorable members to debate it and make a ruling on it. We will give both versions. When you listen to the members of the public and the complaints around central procurement, it is through experience which is very justified. When you look at Section 21 schools, these are schools that are supposed to be given their allocation and money deposited in their account to go and make purchases on LTSM themselves. But the experience on the ground of provinces that have done that has given this negative perception around central procurement, because then the department withhold that money and go and make purchases on behalf of the schools, sometimes things that the school did not own. Things that we received was that the materials that is supplied by the department after they have purchased on behalf of schools has been very inferior. There has been very late delivery of material to as late as April. So that has given us that negative perspective around central procurement. This year, the Eastern Cape was taken to court. It was challenged on its implementation of central procurement. And the Eastern Cape lost that case because the court realizes that it was not implemented correctly. But when we put this central procurement as a department, we were looking at an enabling clause that will allow for central procurement to happen, not in the way in which provinces have been dealing with central procurement, which has put us in trouble. What we were thinking of central procurement is use the buying power of schools so that we can benefit from economies of scales. What we were thinking of is that if you were to buy a book, you'll have to buy it from a particular supplier. But the question is, where does the supplier buy this book? If we were to go directly to where the supplier is getting these books from, we might get them a little bit cheaper. So when we say central procurement, we were thinking, especially the DG is very passionate about it, and it drives it with that understanding that the department will use its government authority to go to suppliers and negotiate for prices, then come back to schools and say, school, this book costs so much, but if you go there where we have negotiated, you're going to find it far much cheaper than where you normally would buy it. Then this clause begins to say, no school will be forced to join this central procurement thing. It's a matter of consultation, and SGBs can decide to get in or get out. In other words, if you're a Section 21 schools, you still get your funding. But we then say, in order to buy this, this is where you can get it. We will give pointers of where you can get this material cheaper. So some of the things that we're thinking of, it's schools, for example, under nutrition, use a lot of tin fish. How much is a can of tin fish? And if we were to negotiate with the producers and then say it costs 20-something rands, but because we are many want to buy it at 10 rand, then direct all schools that that's where you're going to get it. Because we're paying a lot of money to different service providers. The prices of things, books, pens, and all that depends on where you're buying it from. Others will buy a simple pen at 30 rand each. Then we're trying to look at that if we do negotiate as a department and then give schools money, but direct them where to can buy this thing, then that's how the central procurement goes in. But we're saying we want to leave it to the honorable members, because all we wanted was an enabling type of a clause that will say, yes, go ahead and negotiate on behalf of schools and direct schools to buy it. But because of the negative perceptions, people see red when they see central procurement. They think provinces will go and buy on their behalf. And if provinces were to do that after this act has been passed, then they'll be acting illegally, because this clause is not saying go and buy on behalf of schools and deliver for them and keep their money. That is the difference, Chairperson.
It's a full house, Chair, with this one. Yeah. One Chair. Let's be clear that as things stand, provinces can still buy in bulk on behalf of the schools, as things stand. And provinces are buying what a certain school does not need. So, for an example, on LTSM, School A wants 72-page exercise book that are 1,000. The department buys 32-page, what, because they were saving there. Was, the economies of saving. As things stand. So that is what is happening. So what does this clause seek to achieve? It seeks to regulate the departments that you can buy without consulting SGBs. What does this mean? It means it re-emphasizes the powers of the SGBs. I agree when we're lobbying, we're saying, no, what? But they want to take powers of the SGBs. So we're clarifying that there's no such. In fact, this clause seeks to strengthen the powers of SGBs, so that we're clear. Honorable Dada must not go and campaign on that. So this is what it seeks to do. So I agree with it, but I want us to be clear that I think we must, I don't know how, they must add that should any provincial department go and procure without consulting with SGBs on this economies of scale issue, those people must be charged. We must find a thing that we must add there, that we must charge those people. But other than that, I think it makes sense to buy in bulk, because as things stand, like that then Lebe said, all the schools in Orange Farm in Gauteng, in the south of Gauteng, and high schools there that, and primary schools that have a feeding scheme, all of them, they buy different. This one buys from this Pick and Pay, this one buys from ShopRite. But if they were to combine all the assets they have, all the money they have, the resources, to go buy the beans that they have, the rice, at manufacturers, directly from manufacturers, they will be saving a lot of money. So the issue where we must now talk about here is, what then happens after saving this money? Where does this money go? Because it can't stay in the department, they float. I want to make a suggestion that that money must then be channeled to infrastructure project in the schools. So that must improve our infrastructure there. Our toilets, if they are short, let's rather use the money that would have saved there to put those things, get rid of pit latrines in the Eastern Cape, so that some people don't make noise during the week, But for me, I think it will assist us if we agree on this deal, because that is exactly what it means. We are re-emphasizing the powers of the SGB, but also taking the savings to addressing our infrastructure challenges. Thank you very much, Chair.
Oh, no, I don't have to switch on the mic. since Litsi and I are sharing the same mic. No, thank you very much. I think Litsi would have covered much of what I would have wanted to speak on. And so let me not waste time. I'm covered.
Thank you, Chair. So the issue of corruption and the consequences of centralisation procurement in South African schools is a significant concern that affects the overall quality of education and mismanagement of public funds. While the concept of centralisation aims to streamline processes, increase efficiency, and reduce costs, it often leads to several unintended consequences. One of the most prominent issues associated with centralised procurement is corruption. Centralisation creates centralised decision-making authority, which can be vulnerable to corrupt practices such as bribery, favouritism, kickbacks, etc. And I think that's what the fears, the red lines that Mr. Ndlebe was talking about. Corruption within the procurement process not only diverts funds away from the intended purposes, but also results in substandard goods and services being provided to schools. And this has a direct impact on the quality of education received by students, as essential resources like textbooks, stationery, infrastructure, and technology may be of inferior quality, which also was allayed by Mr. Ndlebe. I think there should be an alternative clause, or we have our legal guys here today. In consultation doesn't, for me, equate to an agreement. So I think it should be saying, in an alternative clause, that notwithstanding the provisions of subsections 1C and 3 and section 22, the head of the department may, in consultation and after agreement with the governing body, centrally procure identified learning, and so it goes on. So I think we need to add in there agreement, because to me, it doesn't intend only by saying after consultation. So I think we must work in agreement to that. Thanks, Chair.
Thank you, Chair. My ideas go along more or less the same lines. I might just mention that we have a history of state capture, which makes the idea that centrally procured things are cheaper not obvious. It might be much more expensive, and I think that is where a lot of the mistrust comes from. But maybe if I could add to what Honourable Van Zyl said, if one could change that to say, notwithstanding so-and-so and so, the head of department may, after, on request by the governing body, centrally procure. So that would mean that the head of department informs on what is available at what prices, and then the school governing body requests it at that price through that channel. I think then the decision where to buy is firmly in the hands of the school governing body itself, and if it's cheaper. The one thing that I thought of is one should not forget that there might be corruption on the community level too. You know, it might be that the SGB has somebody at the local, some kind of stationery dealer. So people tend to think centrally procurement opens the door for corruption, but the opposite could also be true. So I think the whole thing about scrutinizing the financial statements of schools is very important to make sure that we don't make local procurement the default mode and then have exactly the same corruption just on a micro scale. Thank you.
Thank you, Chair. I think mine is a comment that I want to make just in terms of what was said by Mr. Ndlebe. Aggregate procurement works when you are in an efficient system with strategic procurement principles and processes, and where the capacity is present to do that. We don't have, I think to a large extent, when we just look at what we are dealing with within procurement or even contract management within the system. We don't have that. But I absolutely hear and agree, because I worked with strategic procurement, that aggregate procurement is the ideal for any organization, because you are able to determine and to negotiate price that is at the lowest possible level, because it's aggregate. But it works within an efficient system. And so the controls of in consultation with is an important one. With the SGBs, and I've heard what was proposed as well as a stringent, more stringent control, I think, or the aim may be for more stringent control. But mine is, Chair, just to make that comment that it is true that with aggregate procurement, it is the ideal, but only if it is within an efficient system. And I do not think we have that yet, I think.
Yeah, Chairperson, you know, I think we should always never forget that we're still trying to drive transformation. We must never forget this. You know, let me give you just a quick example. I always give this in my BE talks, that if you had to look at Ntate Maponya and Ackerman, they started the retail business around the same time. But look at where Ackerman is today. Ntate Maponya passed away not having grown beyond Dube and so on with the one thing. So what am I saying? Yeah. So what am I saying? What I'm saying is that, you see, it's the same lamentable approach that the public procurement bill is taking, which says value for money. When you say value for money, the only people that can benefit out of that whole infrastructure are the people that have got the wherewithal for economies of scale and all of that. So then that means this thing called small business, we can forget it. Then it's all dead. Because when you say aggregate, when you say central and all of this and then economies of scale, what actually, it's a very elegant way of saying only white monopoly capital should be the producers. This is what you're saying in a very elegant way. And you're just saying, no, value for money, efficiencies and all of this. But in essence, what you're saying is that fledgling SMEs must just die, as it were. So I just have a transformation problem with this thing that is expedient, that looks good, but in fact it kills. In the long run, what this does, it might look good now in a short term, years will save and all of that, but in the long run, you will end up with a lot more. You see, for instance, the government is very quick to say, we've got 17 million people in the SASSA grants, and they sound very proud to say that. And most of those people, if we didn't have this central procurement, they'll be running their SMEs. They would be productive in the space. So if we do this central economies of scale, that 17 million that the government is very proud of will grow to 30 million people, because you are just killing entrepreneurship, you are killing entrepreneurs. So I'm saying we must take the long view on issues and say that these issues of procurement should be devolved so that small businesses can participate. Just not lock them out. No, if we have a province, don't have a province. I mean, look at what KZN nearly did with the food thing, that they wanted one supplier for the entire province, and there was an outcry. Now I want to do it in education now. Why do you want to do this? When what you could do is to look at what is sizable, maybe even at a regional level, at some kind of level, devolve this thing, but don't, it's short-termism to be saying, centralized procurement and all of that. It will give you a quick win now, but at the end of the day, that 17 million that my comrades are very happy with here to say so many people, that 17 million will make us a nanny state in no time. We'll be sitting with 30 million people because we're killing them. with this process. So I don't think it's a progressive thing to be short-termist in our approach. So I would be saying, for me, from our side, to be saying the department maybe must relook at how do all these good intentions ensure that the small to medium-sized businesses are not destroyed in the altar of economies of scale, value for money, and all of that. It's a very lethal process, Chairperson, that I would say let's not go that route. It's a poison chalice. Looks good, but the long-term effects of that are just devastating to small businesses. Thank you.
Thank you, Chairperson. I might not want to muddy the water that Honorable Mani had brought. Nevertheless, I can say that we might be very careful not to create legislation that, because of the effectiveness and efficiency and economic reasons, we block out young, upcoming business people, and only creating law that will create and more pushing on the side of monopoly, because now only those who have money and who have established businesses will benefit from the laws that will be creating. The blame.
Thank you very much once more. Can I humbly persuade my fellow honorable members in red by starting here? Honorable Mani and Honorable Magligos. This is one piece, I mean, a balanced piece of legislation. I will explain why. Number one, there is no element of making any compulsory infusion. That's the first one. And number two, it is progressive piece of a legislation. Why? Because you see, it is true on this whole concept of economies of scale. Let's agree that it is true that people who are seen to be the only ones selling something, they tend to double their prices for the local consumers to such an extent that that's why at the end of the day, our people will leave the spaza shops and drive for more than 100 kilos to go to the nearby town and go and buy there for a number of reasons. It does happen, Chairperson, that some of these things we are seeing them even on TV, whereby our people have got a tendency of even selling expired commodities. Now we are faced with the two devils. We seek to empower them, but at the same time, they are giving us a shoddy quality of products. Expired stuff given to our local consumers, and some of these elderly people and kids do not even check at the expiry date. They just take and consume. What happens next? You see, it's a question of quality versus, okay, trying to empower our local entrepreneurs, but at the same time, affordability gets into the thing. So I would say, simply because there is no, in this clause, an element of compulsory to the SGB or schools to get into the centralization process, we are likely to differ from one area to the other. There could be other schools in a particular locality who are able to get into deals with the local entrepreneurs and then come up with something which will be of quality and at the same time affordable. But because it is not compulsory, they will check the pro and cons. You see, when Mr. Ndlebe explained, he said, it is up to the SGB to decide if they would love to be hooked into the centralized purchase or not. But at the same time, they must be monitored that they do not sell or buy expired products for our children, because we love those kids. Hence, I would say, let's live with the clause as it is proposed, because it is actually offering all those, the left and the right. Thank you very much.
I'm fine, Chair, thank you.
No, thank you so much, Chair. I'm worried that Honorable Mani there took our economic justice policy over the. I was actually surprised when I was listening. I said, hey, the CIC must be worried with this approach. But that's just on a lighter note. No, Chair, I just want to say that.
And those guys are in alliance with Lizzie. Now we are starting civil war.
Yes, thank you, Chairperson, for your protection. I appreciate it. That's why we must attend. So when you see people are very excited because it's evening now, they've got hope waiting at home. Chair, centralization in general is as a concept is problematic, and it's interesting that on one portion of it, people support that we must centralize, and in the other portion we don't. And I think the dangers we've seen firsthand of centralization with the Eastern Cape province that I come from, and I always fight with those officials because they never deliver textbooks on time, and they think that they own those particular schools at the detriment of those learners. And I think KZN is another case in point. But I think it must be made clear that centralization as a concept is problematic because it's open to corruption. Sometimes we make laws with good intentions, but at the end of the day, they end up backfiring because the people that are supposed to apply the law see an opportunity. As with the NSNP, for example, where there's billions of rands that are available and somebody wants someone somewhere to benefit, as is the case that's being investigated in KZN of an official that gave her family friend an opportunity with that particular tender, and we're watching that one very closely. Yeah. But I do think that, Chair, the proposal that has been made that there must be an agreement between the school governing body and that particular department is very important. Because we don't want to find ourselves in a situation where it says we may consult, because consultation, I can sit in a meeting with you as a tick box exercise, and then I'll go and determine that the best method to use for us to procure textbooks in this particular province is for us to centralize or centrally procure those. So I do think that there needs to be an agreement, and that addition that has been made to say in consultation and agreement with that particular SGB is very important. That is the only way this collaboration you talk about principle of saying that this clauses two ways can be able to be functional, because then SGBs will have true just a consultative method that is being used to box tick exercise. Because it does happen where in other places where centralization, when it's done properly, it does function. It, as a principle, becomes a challenging one. That's why it's important to decentralize what the are able to participate in the economy, or the economy scales, that is. Thanks, Chair.
we need to finish now. We need to move.
Just one thing, Chair. You
No,
see,
proceed.
a quick one, just to say it's incomplete if you say in agreement and then you don't pronounce on deadlock breaking mechanism, because what happens if there's no agreement? So I'm saying then it becomes incomplete. Then you must complete the sentence that in the event they disagree, then what? You know, otherwise you have a deadlock, then the entire project is messed up because the two can't agree.
No, mine was the insertion of the word must, because I think the emphasis, where the emphasis is placed, must in consultation with, is different than saying may, comma, in consultation with. So you can take that, you can almost take them out of the equation if you may. But if you must in consultation, it's a stronger word. That's just what I wanted to add. Thank you.
Thank you, Chairperson. I think your last comments, Chairperson, maybe are the ones which sort of got me worried. But I think if we would recall, Section 21 starts somewhere, then this is an insertion. So I thought just maybe to bring clarity, one, in consultation, even our courts have explained it. It's basically as the equivalent of agreement. There is nothing that can be done unless both parties that must consult one another find one another. So that is clear. As the provision is drafted, it's actually achieving exactly that. But then I think going back to the provision as it exists, 21(1)(c) starts by saying the SGB initially gets the application to do the procurement on their own, and the application is done to the HOD, and this provision is then saying once that is done and they already have the power to do the purchasing on their own, and there would be a need for some reason or the other that they need to centrally procure, then this is where this new insertion 3A comes in. So the provision as it stands, it's basically speaking to all the issues that have been canvassed.
Yes. It takes nothing away from
Guys, Jerry, stop now. Jerry, tired. The brain. The brain. Chairperson, our babies have no one.
No, we will have to vote. And then you will defeat it. No, sorry.
Chairperson, we didn't arrange for our babies. No one is looking after them.
Close the mic.
Chairperson 17, it's about the withdrawal of functions of an SGB. In SASSA,
No, he says he's going to walk out. We're not going to go now.
Okay.
Chairperson,
Give a minute.
We need to pull, we need to push.
Yeah.
there are general functions that are given to school governing bodies, but there are specific allocated functions to governing bodies. Now, this clause is talking about functions of SGBs that have been allocated to them, such as the purchase of LTSM, such as paying for rates and taxes. These are allocated. So if the SGB doesn't deliver on the allocated functions, or the SGB is found wanting and it's not delivering on that, the clause is saying the HOD must withdraw those functions. For example, you need to purchase LTSM for children, whether centrally or not, and you fail as an SGB to provide those, then the HOD must withdraw those functions and take them over. Just to go back a little bit, that we do have these functions as in section 20, and these are general functions, and in section 21, this is where they are allocated. So if it is withdrawn, it means that functions will then fall under 20 and the department will do it on your behalf. But what this clause is trying to do is to put steps that the HOD must follow if he wants to withdraw a function. And the whole of those sentences about what the SGB must do. The SGB just can't come and pounce on the function and take it. The HOD must write to the SGB and say, you are failing to deliver. And can you explain why I should not take this function? And consider the reasons given, failing which then the HOD will then follow particular step until the function gets withdrawn. So that's what the clause is all about.
Okay. Any? No, thank you very much, Chairperson. I think this is necessary so that at least there's dealing with the corrupt SGBs or those that are unable to deliver as expected. And also it will assist in terms of the HOD, because as you're saying that there are procedures that need to be followed, I think that will also help so that at the end of the day, after the HOD have withdrawn, the members of the SGB do not find any reason to can go and make an appeal on the MEC. I think I support this clause. Thank you very much, Chair.
Understood. With us in Limpopo, we know what the intention of this is all about for a good cause. Section 100A or B. You see an institution which is not functional and for whatever reason, according to the expected purpose, surely it must be put under administration. I believe this is exactly what you are trying to say when you withdraw the powers that were given to it. We support. Thank you.
Chairperson, how long is the period of withdrawal?
We run SGBs in a 3-year cycle. So we always have SGBs elected after 3 years. So if a function of an SGB has been withdrawn, it is withdrawn with a hope of assisting it to can grow or not. If the SGB can demonstrate that they have repented, they put systems in place, they now can do their things, that functions can be retained. Let me be specific here. We're taking a function on the basis that you have no ability to manage funds correctly. There's a misuse of funds and all that. You don't even have financial statement, your accounting is haywire. The function can be withdrawn following all those steps. But as time goes on, the SGB becomes functional, Sometimes new people are co-opted into that SGB, and the SGB can demonstrate that they are now of sound mind. They can reapply to the department and say, we fine, come and check us. In fact, the functions that are allocated under Section 21 are allocated on the basis of the SGB itself having to apply to the department that we are okay, we have the ability to do these things, so give us the function. So when we withdraw, we're withdrawing by saying, you promise you have the capacity, but you're failing, so we're taking it up. So if you're ready, come back. And in the next elections, if there are new members of the SGB, they need to demonstrate that ability. Then the function can be given back.
Just to say, in passing the chair, that, these SGPs, the competence of the SGPs is a function of the sophistication of the parents that form this thing. So these things, they differ from area to area. For me, I would think some thinking must be given to the rationality of legislating something to people that for them to become SGPs, there's no panel interview process. It's just, I'm available. And then they become SGP members. And all of a sudden, they are settled with millions to decide what to do with. It doesn't sound like that is making sense to me. In certain areas where you have parents that are generally professionals and all of that, maybe you can live with it. But not all areas are like that, So for me, I would have thought that as the key issue, the key function really for SGP should be more than anything else governance, as it were. But when it comes to strict things like these with monies and all of that, people in the department, but I'm not saying we must go back, I'm just thinking aloud. People in the department who get employed based on CVs should be the people that has got somewhere that has been to some accounting school, somewhere that understands tier accounts, is a person that should be charged with tasks like this. But just to take my father, with due respect to my father and his grandfather and all of that put together, and for some reason, these parents, they find themselves having to decide where and how to spend millions. I don't think it's a fair arrangement, but I'm not opening a discussion, I'm just thinking aloud.
Thank you very much. Anything from the
They need to co-opt. We're asking that SGBs should be given the authority to co-opt people outside themselves and even outside their communities to bring people with skills. Your example is finance, for example. In the entire SGB, there's nobody who understands these financial processes. That clause is saying, can we allow the SGB to go and headhunt people outside themselves and even outside the communities to come and assist them on the weaknesses? It could be finance, it could be any other thing. If you are to deal with appointments and all of you are not at that level to can interview a school principal, the clause is saying allow them to go out and seek help from people that can assist them as an SGB. But there's one thing that we need to correct, that we normally think the SGB it's parents. And the SGB is not parents. The SGB is a combination of parents, teachers, the principals, and even learners in a high school. So if you go to an environment, you can't say the SGB is illiterate, because what you're saying is that the teachers in that SGB are illiterate as well. And you're saying even the learners in a high school are also illiterate. So an SGB is a collective. And for an SGB to function, An SGB functions like parliament, where you set up these policies and laws and you take decisions on what needs to happen. You don't have to run the rands and the cents, but the purchases that happens in a school are due to the decision taken by the SGB. So the old man who lives next door, who has never been to school, has the capacity to decide whether we can build a carport there or not, irrespective of how to calculate how much it costs. So that's the value of the SGB. The only problem that is happening is that the SGBs become so divided in such a way that in some schools, the principal becomes the key and runs the show. In other schools where the SGBs are strong, the chairperson is the most powerful person and is the god in that institution. But that's not how decisions are taken in the SGB. If we decide we want to buy a photocopier, for example, the processes of the SGB says, go down there and make a requisition that you want a photocopier. And the entire SGB sits and analyzes that. And you go and get quotations and you approve the purchase as an SGB, not individuals, not the executive, but the SGB as a whole. So if we can get this understanding of what the SGB is, these elements of saying the SGB, it's illiterate, they don't understand finances and all that. Yes, there are administrative clerks in the school that must add the rents and the cents. But the decisions of what needs to be bought and how much it costs, it comes from the SGB. And when you report on the financial expenditures and all that, is based on, did the SGB agree on this purchase? Who was in that meeting? Can we have registers? Did we have quotations? And then we do the reconciliation. It doesn't require a degree to do that. So the understanding of an SGB, if it's understood in this fashion, that in case you really need expertise, if it's a school of music, for example, you want expertise, then invite Honorable Madlingosi to be part of the SGB, even if he's not a parent there, and he becomes a member of the SGB. That is what the court is asking for.
Covered, Chair.
The LSN.
Members of SGBs, especially in special schools, differ from an ordinary school. And this will include those schools of focus that we spoke about, that the composition differs. In an ordinary public school, we determine the number of parents that are need to be there, and they need to be parent in the true sense, the number of teachers and all that. But when you come to special schools, that should not apply. You can have parents as parents, but then here we're requesting that the minister be allowed to allow schools to add other components. If it's a school of children that are deaf, for example, you can have parents coming in, but they are not specialists in terms of, so get organization, outside organizations that deals with this element to be included in the SGB as well. You do have some schools where there are no parents at all because children are at homes. I'm thinking of New Nation in Mayfair, if you know the school called New Nation in Mayfair. The children do not have biological parents, but they are in homes. Then this will then allow the minister to make it easy to establish an SGB. Out of those, I don't know, do you call them step foster parents and all that? And in special schools, there are a lot of activities that go in there, including sponsors. If, for example, SAB, alcohol again, is a sponsor of this particular institution, there's no reason why SAB cannot have a rep in there. because they are a sponsor of the school. They are pumping a lot of money. So the decisions that deals with how money is utilized in that school, they need to be there as sponsors. So this clause, it's saying, allow the minister to allow schools to expand their SGBs on the basis of expertise of people that are not part and parcel of the institution, including sponsors, including other organizations of the deaf, of the blind, of the physically disabled, and all that. So in other words, the SGB may not be that SGB that has a maximum of 10 people. It will be a ballooned SGB because it has other people of interest in it.
Now, I just see that the department wants to sell special schools out to white monopoly capital.
No, Chair. Firstly, I think the explanation by Mr. Ndlebe about SGBs I accept. But I think the one point which I must just make in passing, which just worries me, is a situation of an imported Marcus Uoste, for instance. Marcus Uoste is a wizard in terms of finances and all of that. Now, my worry is that if you have a team of people, you can call them teachers or anything. These things are highly specialized. You can be a teacher, and you can be a teacher, and you can be a teacher. These things are highly specialized. So if you get a Marcus Uoste, for instance, dealing with some finance subject, I don't think anyone would want to embarrass himself arguing with the Marcus Uoste in that meeting. So that is the issue that I'm worried about. But I'm not saying let's go back there. I'm just saying let's just be careful about this thing. This thing of saying we can import skills. If you import skills to people, and I don't want to insult people, but I just want to create a clear realization that there's this thing called specialization. If you, let's say, for instance, for argument's sake, we're sitting here as this committee, as everybody here is not, there's no RR here. Well, if everybody here generally literate, a lot of graduates here. But if you were to say, bring call it a mining engineer for argument's sake, he'll run rings around us here, because what we know, all of us here put together about mining engineering is dangerous, as it were. And yet we might sit here as a collective of generally educated people. But that specialization might not be resident amongst us. So I'm just mentioning the risks, although when you talk generalities, these things, they get obscured and all of that. And when you push it, you sound like you're insulting community and all of that, when the truth of the matter is that some of these things are specialized, and for people to get the maximum benefit out of the specialist, they themselves need a particular level of competence on the subject matter. But again, it's one of those things I'm just throwing and passing. I'm not opening a debate, but I'm just saying that's where it comes from. Thank you.
Thanks, Chairperson. Just on a general note, before I go into this clause, Chair, I was very serious about this time issue. Because we applied for these meetings for a specific time period, and it's reasonable because it's not just for us, but also the public. So let's not try and steamroll everything. We've got time. We've set out this process until Friday. So let's please make sure that, we're an hour already into what we've requested. So please, Chairperson, let's make sure that we conclude as per the agenda. We've got obviously matters of the country to deal with that are other issues to help other people. This particular clause seeks to provide powers. You know, when Mamposha was reading these clauses, it was also important because it also outlines what the clauses themselves are about. But this particular clause seeks to empower, provide powers to the minister to determine the number of SGB members and the manner of election of such members at every public school for learners with special needs. That's what the clause is about. Now, first and foremost, I've been warning, throughout the day and other platforms that centralization is not a good idea. Let's remember that education is a concurrent function where you've got your provincial members of executive council. And I don't see why we now need to substitute members of executive council and give those powers to the minister. Yet these particular schools are run and administered at a provincial level. It's another centralization of power, and I think it's unnecessary, first and foremost. Number two, it's also dangerous because someone somewhere will sit in an office and say, look, these are the SGB members that we recommend that must serve at that particular school. And I don't think that is in line with the democratic principles in which SGBs are established by. So I don't think that this particular clause on principle, because when we make law, we must not make law out of our own emotions. On principle, one, we're centralizing power to the hands of the minister, taking away power from members of executive council. And then secondly, we then wrote the principle of democratic participation in the SGB. Let that determination be made by the SGBs themselves. Let's not try and impose people to them. If they need assistance, they'll contact the department and they will be channeled to the right place. But on principle, we can't centralize power. Number two, we can't impose people to a school governing body. So this clause, I move that it be scrapped, this clause 19 itself. Thanks, Chair.
Notata is moving that we scrap clause 19. There is a hand of Honorable at once, and then Honorable Fansale, and then Mithia.
Thank you very much, Chairperson. I'm not in agreement with the proposal by Honorable Notata because obviously there is a reason why there was a need to look into that. And as and when we did even our oversight visit to schools, we could even get challenges whereby some of the special schools, they would even struggle about having the specialized, whether it's teachers or nurses or social workers. So I think when this clause is there, it will also cover such schools that are not well being taken care of or looked after. So I believe this clause must stay as it is. Thank you, Chair.
Thank you, Chairperson. I'd like to second Honourable Nodada's proposal that it be scrapped. I think and I fear that taking the power from the provincial governments, never mind the SGBs, you've taken it away. Now provincial you want to scrap as well. So it might be an unjustified intrusion on the provincial government's powers as well to be looking. So the centralisation, it just goes up and up and it ends up at the top. Thanks.
Yeah, thank you very much, Chairperson. I'm not sure if we are reading the same proposal as Honourable Van Zyl. Are we on 19?
Yes.
Yeah, so I think we're probably not reading it the same way. And because it's English, expect to be me struggling with this thing, but it looks like so quite a trap everybody. This thing, Chair, we're not, it says there number 2, subject to this act, the member of the Executive Council, who is that? MEC.
Substituted.
That's removed. Minister, by notice in the Provincial Gazette.
Don't do that. Don't do that. Don't do that.
No, I'm coming to you, don't worry. Yeah, you see, so what does this seek to do, Chair? And I'm sure on this one I want to lobby Honourable Sukers. I'm sure she's going to agree with me. On this, currently what is happening, each province deals with the elections of their special schools, or special school SGBs, their own way. So in the Western Cape, they deal with it their own way. In the Northwest, they do their own things. In Free State, the same story. What does that mean? It means there is no uniform approach on how special schools, SGBs, members must be elected. So each and everyone does as they please. What is the problem with that? Or what does this seek to achieve? The amendment seeks to bring about uniformity across the provinces with regard to the elections of these SGB people. And then LSEN is not being marginalized, but it will enjoy the benefits created for them and is based on the principle of inclusivity. So this thing, what it seeks to achieve, Honorable Nodad, that there must be standard, because I'm sure, you know, when we went to every year, Chair, when we do our oversight to different provinces, you get different experiences everywhere. In the KZN where we went this year, I'm sure Honorable Sukers will remember that we would get to other schools where they would literally cry that there's no SGB in that school, because the measures, stringent measures that are put there by the provincial department at that particular province makes it very difficult for parents to participate and be members of the thing there. So I think I also want to second the proposal by Honorable Adjones to reject any form of scrapping on this. I think we're seconding. I think it must sit as it is. From where we're standing, it seeks to assist us moving forward. Thank you very much.
Thank you very much, Chair. I think without delving too much into detail that otherwise Honorable Litsie and Advance might have covered, all this clause seeks to do is to create uniformity across all provinces. We know that the schools for learners with special education needs are not in the majority. And as such, because of that, it is a pliable environment to change these sections, these subsections. It only changes subsection 2 and 4 of the Principal Act. And all it does is just to replace, substitute MEC with minister, which is obviously the next level above MECs, to allow for central coordination of these particular elections, of these specific SGPs. So I do not think there's a crisis in this specific clause with the elevation of this responsibility for uniformity purposes, and to ensure that in all other provinces, the mechanisms of electing or appointing SGBs are similar across, so that you don't have a province where it's stringent, another province it's lax, another province it's left to chance. You're creating uniformity. I don't think there's an issue. So I support that the clause be left intact as is. The intention really is noble. It's not an intention that's acerbic in nature. Thank you, Chair.
Honorable Moerane.
Thank you very much, Chairperson. I also want to support, because also I wanted to raise the issue of uniformity. Thank you so much, Chairperson.
Honorable Sukers.
Yes, Chair. I think the principle of subsidiarity, where you can, is the most potent one against the issues of centralization. because of the empowering and enabling people at a community level to act. And I would only say this one thing, Chair, because it seems my brain went on holiday now for a moment, is that I absolutely agree and support what was said by Honorable Nodada around the issues of centralization.
I don't really politics. We are in politics. How can you do that? But this must be the mandate is support.
Chair.
Look, my sister.
It's about principle.
You won't be sinful.
No, I absolutely. Chair, I need to say this. I thank you, Honourable Letsie. It's a matter of principle. And that's why I speak about the issue of subsidiarity. It's not an issue.
Just give him a synonym of subsidiarity.
Anything from order members, order.
Chairperson, I was not expecting that we're going to differ a lot with this clause, so my summary was not very detailed to indicate where this comes from. The minister at the moment is responsible for determining even the election period of the SGBs. That is why you're sitting with a government gazette that indicates the 2024 elections. That is the minister's responsibility. As soon as she does that, under the current SASA where the MEC is in charge, the MECs are supposed to develop regulations for that 2024 elections. It happens every cycle of SGB elections. So what happens is that we now end up with 9 regulations in my office. Right in my office, 9 different regulations of different provinces. And there'll be differences somewhere in those regulations. The challenge is that the law expects those regulations to be done. But the frustration is that the elections might kick in before a province even comes up with a regulation. I can quote, the Eastern Cape will fail to bring you regulations for those election periods. The Western Cape, in the last elections, they promulgated their regulations at the 11th hour. Gauteng didn't. They just said the previous ones will be utilized. Whilst at national we have agreed that there are different modes of elections, even including electronic elections in there. But because they're saying they're going to use the previous one, then the elections in Gauteng were run without these electoral elections, which was a deviation from the rest of the provinces. Now, directly in my office, we meet with SGB associations on a quarterly basis. Every 3 months, we meet with associations. And this clause was sponsored by SGB associations. You must have had SGB associations in the hearings, FETSAS in particular, supported by SOU, who were saying these things of provinces promulgating their own regulations are frustrating all of us. Can you give this authority to the minister to have 1 regulation, then we don't have 9 anymore? And if you've listened to the hearings, that is the support that was coming from SGB associations. And what the department did was to accede to the request of the associations because of those frustrations around different regulations that compromise us. When we monitor SGB elections, I have to think, where am I? Am I in Gauteng? And Gauteng will have these rules that the other province doesn't have. And one province will call the department and say, why are we not allowed to do this whilst these other provinces are allowing us to do that? Then it creates confusion all over. And that is why we were saying one regulation. I can tell you now, we have finalized guidelines, national guidelines on SGB elections for 2024. These were discussed by HEDCOM yesterday and day before yesterday for approval. We'll give these to provinces and say, these are the guidelines. And how these guidelines are manufactured, they are done by the department and SGB associations. And we all agree, then they go and pass. So when they pass, we then give it to provinces. And then SGB associations and ourselves are expecting these guidelines to inform the regulations by provinces. And some provinces show us a middle finger and change this. So that's where the frustration comes from. And associations are saying, can we just have one regulation? And that one regulation can only come from all of us, signed by the minister. Then you don't have different provinces frustrating us whether they do regulations or they don't, or they change other things. Things like when you elect, are you going to have a proxy? And then we'll discuss with all of us and say, no proxies in the elections. Then Gauteng comes in and say proxies are allowed. It really frustrates the whole country when that happens. That is why that clause is saying MECs replaced by ministers, so that we have one document that runs elections all over and not 9. Thanks, Chair.
Yeah. You see? Okay, we've got a lot of time. Thank you, Honorable Bishop. But it's you who was lobbying them to speak now. So don't call him to order. Honorable Bishop, Honorable Mani, Honorable Sulkers, Honorable Muerane, in that order.
Thank you, Chair. Now, I just want to say, we'll talk to FETSAS about this undermining of subsidiarity when it suits them, because it makes it difficult for us. You know, one loses a little bit of coherence in your presentations.
Yeah. It's Mr. Deliberations. Yeah. No, Chairperson, I was going to say this kind of proposal reminds us that South Africa is a unitary state. I like this because if we had this on many other aspects of life, we wouldn't have wasted so much resources and the mess that happened in this town, where you have a particular transport department thing that says when do we impound, and then before you know you have some Paza shop laws at a lower rank wanting to impound for every conceivable reason. So this thing is actually trying to solve such a mischief of that particular nature. So I think for us, we would support this. It brings order in the country. Thank you.
Mr. Ndlebe did such a great job of bringing this matter home in terms of the practicality. Yes. But then the fighters came and immediately exposed the ideology that is underpinning all of it. So that is a problem.
No, thank you. Thank you very much, Chairperson. I think the expansion and the elaborations that Mr. Ndlebe has made, I've seen that it made also Honourable Nodada to accept, though he's not saying anything, because you can see it's clear, and based on what I indicated and other members indicated, the uniformity of the matter and also to be aligned in one, it makes us to continue to say we support this clause. Thank you very much, Chairperson.
So, have you closed now your screen for Litsia?
He's reading wrong things that are being deleted.
Mara, you see this? Mara, you see this?
I've made my writing small.
You see this coalition of purpose. Sukari has left you now. All right. Can we allow legal service? Can we allow legal services? Legal services, not that is. Advocate, my advocate. Thank you very much. So, clause 19. Clause 19 states. Clause 20 is the membership of SGP of public schools with specialized focus. Mr. Ndebe?
Chairperson, it's a short one. They are not covered in SASSA because these schools just came up. Premier Sufi made them famous in Gauteng. It's a new breed. And if we have to have SGBs in those schools, they need to be covered. We're covering special schools, public ordinary schools. We need to have SGBs in specialized schools. So we're asking for permission for them to be included.
Yes. Can we move? Clause 20. So why are you looking at me like that?
I will stop at this text.
It's clause 20. It's clause 20 now. I propose that the advocate really has asked for a break, and we need her to stay put. So I'm proposing a 10-minute stretch break. It's quarter past 7. We are reconvening at 7. Yes.
And I raised this while I was dealing with clause 19, Chair. As a committee, you have applied to the chair of chairs for these meetings. You've stipulated a timeline that we'll start at this time, we'll conclude at this time. We're now sitting at 7 o'clock, 20 past 7, having started at 9 o'clock in the morning. So, 9:30. So, Chair, I'm just asking for an adjournment time because we're not going to sit here and steamroll when we've got 3 days to do these things. And if the chair of chairs has approved a particular time, we're bound by that. So I don't want to get into that argument. That's why I'm asking what is a time that we're going to adjourn, because we're not going to sit here until 10 o'clock. That is not going to happen. So I'm just requesting you to get understanding so that if there's a push to do that, we then consult with our whips as to how to approach it, because honestly speaking, we've been here throughout the whole day, and we've still got 2 days to go. There's no rush. We're going to do this thing properly. There's no rush. So I'm just requesting that, Chair.
All right. Okay. Honorable Litsia, then Yabo.
Thank you very much, Chair. I think, you know me, I'm a fair person. I'm known for being a very fair person, possibly the most fair person.
You can take a break. It's like that.
So I wanted to say, as much as we want to bring principle in terms of time frame, we must also blame ourselves, Chair, that we had an opportunity which was stipulated in the same time frame for yesterday. And we decided ourselves as these members that we are not going to continue. I think it's important that at least we take a portion of this thing and not put it on the table of the chair as if the chair is making us work till late. Yesterday, Chair, we could not continue. But I want to make a proposal that today we moved slowly because obviously we were, establishing principles as to what is it that how are we going to move forward. So you saw after lunch, we're flowing. So I want to, because at lunch, I think at number 6, it was 6 or 7. So we have really progressed very fast. So I want to make a proposal, Chair, that we are now on clause 20, we move until 25. So which means it will be again up to us. If you come back at 7:30, 30 minutes, I'm sure it's fine. We should be done by 8. If not, maybe 8:15. Then tomorrow we start on time. We should be able to finish. My proposal, I think, if we can move with the pace that we're moving in tomorrow morning from 9 o'clock, by 5 o'clock, we will be at clause 53. I've calculated, used calculus and statistics, and I've realized
Matrix,
that indeed using the matrix as well. We are there. So tomorrow we should be able to finish. Just 5 more clauses until number 25. Then we adjourn, come back tomorrow morning. So that's the proposal I want to put on the table.
Thank you very much. Thank you very much, Chair. I think I want to agree with Honorable Letsie that let's try and push until clause 25 for today, and more as no harder after that.
No break.
No, but Chairperson, I win any elections, so Chair, we none.
No, of course.
Thank you, colleagues. Let's start. Thank you, colleagues. Let's resume. Let's resume with the meeting, colleagues. Thank you. Thank you so much, colleagues. The meeting is back in session. Thank you.
From the chair's chair.
This is called decentralization of power. The meeting is back on.
When are you going to take me one?
Mara, you see that, I'm sure you guys realize we don't have to fight, man. There's no need to fight.
Let's move. Let's move.
We can just ask the technical team to just proceed with things. Now we can just ask the technical team to finish now till 56. Siyavana mosmo. Awusayifuna report on it.
Don't take advantage of me, Chair.
Why can't we just rise up and say we support it?
Exactly!
No, we don't. Don't be
no,
there.
Let us reconvene, members.
I do.
Members, can we...
Don't be misled by my smile.
Can we reconvene? In fact, you are not a difficult person, but I think yesterday you were given a specific mandate. That mandate, a specific mandate. Can we, it's clause 21, dissolution of governing bodies.
Chairperson, we have dealt with the withdrawal of powers. That previous clause was talking about an SGB that fails to perform a particular function, and that we have given authority to the SGB to take back the power. But the one that we're dealing with now is dissolving the entire SGB that has failed to perform its function, and it's putting up conditions under which an SGB that has failed to perform its function can then be removed by the HOD.
Honorable Van Zyl.
Thank you, Chairperson. Really, on this one, I think we need to advocate for a longer appeal timeline process. 14 days is not a lot. I know in the rest of the policy document we talk about 30 days for this and 30 days for that. Streamline that we make it up to 30 days for everyone to remember that it's 30 days thing. But I think the legal guys can also assist us. But I think it's just to advocate a timeline.
Otherwise, 20 days, 30 days. Honorable Principal.
Chairperson, thank you. You see, our approach should be derived from what the people said. I had no one say anything, and I want to therefore persuade my that we accept it as is. Maybe the issue of the 30 days or whatever. I would say 30 days, which may be equivalent to a month. Thank you.
Members, they agree with the clause. They just want to extend from 14 to 30 days. Our coalition. So just know that we agree with the recommendation. It's just the extension of days. Clause 22 So we agree, clause 21, we just agree on the days. Clause 22 is the recusal by a member of the governing body.
Chairperson, this is the clause that has motivated us to delete the declaration of financial interest by SGB members because we thought it's cumbersome, so we were supported in withdrawing it. We were withdrawing it with having this in mind, that it is covered by this clause of recusal, where we are saying an SGB member needs to declare in advance if we're going to be discussing issues in which he or his families have interest in. This could be appointments, because SGBs recommend appointments. It could be purchases from a particular place. If he's a businessman and is a member of the SGB, we request that they indicate in writing that they have no interest. This is where we spoke of forms that we should design, where people will declare that I, so and so, declare that, and then you sign, and then if you are part and parcel of, or you have an interest, or you know of a family member that is doing business with the school, then you recuse yourself from the deliberations that are in there. It goes on to indicate the repercussions for SGB members that may want to be out of order and get involved illegally in issues where they should have recused themselves, where it is said that the HOD may suspend them, or the HOD may remove them from the SGB for being dishonest in dealing with issues that involve their family members when they should have recused themselves. That is the clause, Chairperson.
Okay. Members? Okay. Agreed?
Agreed.
Advocate?
We just add financial interest after personal interest so that they are both covered.
Agreed. 23 is the reimbursement of members of governing bodies.
Sorry, Chair.
Okay.
Sorry. Just a technicality issue here. You know, when we're dealing with the issue of where the president got money or didn't get money in the Pala story, the public protector came up with an interesting technicality of saying, no, you must not confuse remuneration with financial interest. You can have financial interest, which is not necessarily wrong, but you can't have remuneration, and draw some separation between the two. So I'm just saying, whether that was footwork or whatever, I just hope that we're not going to have some SGB member that's going to pull a kind of tactic on us here. Say, no, but if the president can have financial interest, and you know, this is financial interest is allowed.
Yes, actually.
In the constitution, even the head of state can have financial interest. But the problem is remaining. I'm just throwing it to the legal people that we must not fall onto that space. Somehow they must find the formulation that's going to make sure that the objective is achieved. Thank you.
Noted. 23, reimbursement of members of governing bodies.
In the current SASSA, we don't want SGBs to spend their resources working for the school, then we reimburse them. If you take a taxi to attend a meeting, then the school must reimburse you for what you have spent. We have sent you somewhere else to do something on behalf of the school. You need to be reimbursed those costs. But in reimbursing, we have to ensure that we're not talking payments, we're not talking stipends. We do not pay SGB members for the services they offer. And we do not pay SGB members meeting attendant fees. we do get horror stories where SGB members are paid handsomely for having attended an SGB meeting. So salaries, stipends, payment to do SGB election work, it's something that is not allowed. But reimbursement for what you have spent whilst doing work for the SGB is what this clause is talking about.
Honorable Sokers.
Chairperson, this clause is problematic, especially for our quintile 1 to 3 schools, where our poorer schools, our SGBs, need support. And I would advocate strongly for what was mentioned and said in the public hearings, that a stipend, especially for SGBs and schools that are struggling, like I say, your quintile 1 to 3 schools, needs to be looked at. We cannot have, I think in one of the most rural areas, we had such a lovely chairperson of an SGB who was on foot attending when we were at their school. And it is one of the things that highlighted to me the need for us to advocate for SGB members, especially in your quintile 1 to 3 schools, that are doing great job, that are doing a great job to support their schools, that are many times sacrificing in order to ensure that those schools are functional, that there should be a stipend together with training of SGB members to further empower them. And you can link it. I mean, you can link it, especially in our rural areas where you have SGB members of great moral character that has, because of circumstances, not completed their education, for instance. And I'm making the social motivation around it, where you can link a stipend and you can link an a training and empowerment program to ensure that those members of the community that are serving with excellence our communities, that they are getting a stipend that supports them. And secondly, that further learning, as per the Constitution, it happens for them through a training. Thank you, Chair.
No, thank you very much, Chairperson. I want to, this one is very close to my heart. Okay, I sympathize with what Honorable Sugars is saying. But the reality is that with the number of SGBs in the country that we have, it's practically not possible to pay a stipend. It's not possible. I happen to get a billion that the state don't have. We also have teaching as SG members. What are we saying? I will also saying they must get stipend. Because I don't think you must say there must be stipend for SGBs who are not employed by the school, but elsewhere, probably as councillors. So they must double dip now from the state. That's what this thing will bring to us. Number 3, this thing is problematic, Honorable Speakers. You may not know. It might very well bring us the problem that we have with councillors, where somebody contests to be a councillor or on this because there's money there. So we'll be opening an unnecessary contestation for benefits instead of for saving our schools. If you know, in some parts of this country, killed for what? When you are a councillor, you are supposed to be serving. But they will be killed for that remuneration. They will be killed for that stipend. Because unfortunately, that is the nature of things we were. So, I've given 3 reasons. Opening contestations unnecessary, in my view, and then it's going to create problems. Number 2, it's practically not possible to afford those billions, extra billions, to the Department of Basic Education paying these people. And also the discrepancies, whether a person working in the school must not be paid and somebody else working somewhere must be paid. What are we saying? Is the stipend for those who are unemployed only? How are we going to verify that? The administrative processes generally is a kind of forms. I think I'm moving for the bid. In fact, our SGBs, if you listen to them, so many of them were saying maybe let's try and get the stipend, but now we have a responsibility to check if that is possible, and I'm proposing that it's not possible to pay the stipend of all these SGBs in the Democratic. I don't think any country, probably only the USA, they can afford to pay all SGBs. I don't know if it's possible, but let's not create an unnecessary here. We have a responsibility to take decisions in the best interest of this country. And let's not, because we don't believe that we have any prospect of elections, want to throw people under the bus. Let's take sober decisions. And I sympathize with those who are not working and are doing good job in the SGBs, but let's not force matters. It's not going to materialize. Thank you very much, Chair.
Thank you, Chair. Now, I was thinking both ways while Honourable Soekers spoke, and although we are not on our way to the moon with the ACDP, we move really near each other. But on the one hand, it's true, it was a big breakthrough for democracy when they first started paying parliamentarians, because before that it was only people with property and lots of money who could go to parliament because they were not paid for doing it. And so the idea of people working in the public domain being paid for it and that leveling the playing field is a sound idea. But in terms of schools, I can't really envisage it happening. Because if you start by saying, okay, in Quinta 1 and 2 schools, it must be done because the people really don't have the resources, then somebody in a top school may respond by saying, you know, I'm a chartered accountant. Do you know what I work for per hour? And you want me to sit here in the school governing body thinking about which gutters we have to apply and which we are not. If you want my opinion, you can pay for it. And then one gets into a quagmire of all that. So it goes, a heavy of my heart to tell Honourable Soekers that they don't agree with her. I have to do so.
That's the nicest way somebody has disagreed with me for 2 days, in the last couple of days.
No, Chairperson, I think for all the reasons espoused all round, in addition, I take nothing away from what has been said. In addition, we are also headed for elections. So even if we had a good heart, it might be interpreted as some kind of inducement and so on and all of that. So it's just going to be in bad taste that all of a sudden, this government that has been saying he hasn't got money for this, hasn't got money, all of a sudden now, there's money for Nasispani, there's money for... So, yeah, no.
Okay, now we are in agreement. Clause 23 stays. Recommended by DBE. 24 is the election of members.
The same explanation where SGB associations and the GBE and their stakeholders are saying they are tired of different regulations. Member of the Executive Council, minister, that you distribute that and the elections are uniform, you're done. It's the same as the previous one for special schools.
It's the same one as the previous one. It's a matter of principle for me. No, but jokes aside, Chair, but it's similar to 19. I think also to look at international best practice. You know, I don't know what the obsession is around centralization. Even when you deal with, you know, administrative things, you know, even local delivery in schools, whether it's NSNP, construction, and all of these things of schools. So this, again, for us is a principled issue that we don't think that we should be centralizing and giving more power to the minister, but make sure that provinces own guidelines on this, on how to handle school governing bodies, because environments are not the same. The Eastern Cape is not the same as the Western Cape. Gauteng is not the same as the Free State. And how you handle that in terms of schools and the type of schools in those areas, you have to have a differentiated approach. There's a member of the Executive Council that is elected to be there to facilitate that, because in that particular province, an education concurrent function. Again, this one for us is a principled issue, as rather than giving more power to the minister. I don't want to belabor the to 19. Thanks, Chair.
Prosper.
Honorable Nodata, for that progressive input. Let's live with this recommendation for the amendment. Thank you.
DA and ANC agrees. It's supported. Man, not that.
No, it's a support. Then I withdraw.
He's supporting us.
No, you can't, don't allow him to withdraw. He's here now.
He's supporting us, that's why I say.
Just to clarify to Principal and everyone, Chair, I'm not supporting. Remember the principle I raised on 19, where we gave the powers to the minister from the member of the executive to determine special needs school governing bodies. Again, it's the same argument that I'm making. That's why Mr. Ndebe was very quick to say it's the same as that one. Then I said it's the same argument for me as that one, because it's a matter of principle, Chair. But now I've got principles, so it's fine. We don't have
to. Kicking things through. And now that he has become clear, that is in this argument, let me withdraw my sympathy and support to him. By way of saying, look, almost if you could check all the written submissions when the teacher unions appeared before us, they supported this unequivocally. And it is for this reason that as a product of teacher organization, I support the proposal for the amendment as is captured.
No, thank you very much, Chair. I was going to disagree with the principal, my father, if he was agreeing with Honorable Noda. Honorable Noda, is a person of federal arrangement. So they want provinces to run on their own. That's why they even put a motion in the Western Cape legislature that they want to be independent. So we're not surprised that this is the move that they want. We are disagreeing with them. South Africa is a unitary state, as things stand. We are the same way we supported 19. We are supporting it, but we are further saying this is about the SGBs. We listened to what was the point of going to listen to public hearing, opening up written submissions, bringing them here, speaking to them in the very same room last year, November, and then going to all provinces 27 districts that we went to, and listening to these people, what did they say on this one? The same as GB's people, Honorable Nodat. FETSA, SAO, SATU, COSA, SGB, all of them, they said we support this thing. Now, Rona was saying, no, they don't know what they are saying. Well, when I by saying Rona, I mean these ones who are not agreeing.
Whose interest?
Yeah, whose interest are they serving? So that is the point we are making, that you can't then bring your own. You fail to lobby this. Who's this rule or this course is about them? Who as they are agreeing with this thing? Because obviously you are on campaign mode for elections of 2024. You want to disagree. I think, Chair, I want to support all these SGB formations. SATU, COSA, FETSAS, all of them, I want to say their views are listened to and accepted by us. And I'm speaking on behalf of the ANC. Thank you very much.
That will... Order.
Okay, thank you, Chair.
Yo, call man. Call. Honorable Yabo. I have been to Benin.
Thank you very much.
Order, Principal.
Thank you very much, Chairperson. If I were not that, I'd agree to these things, because if the moonshot pact is anything to go by, he'll be minister most next year. We are doing this thing for him. Yeah, so I'd agree. But if wishes were horses, beggars would ride. Thank you very much, Chairperson.
Okay, Chairperson.
Man, kasi can udala man.
I rise to agree with the Honorable Nodata's slogan, we are stronger together. So this proposal here is exactly that, together, under a minister. So the proposal is supported. Thank you.
Honorable Boshoff?
No, I just want to put my opinion on record too. That very often organizations who work very specialized don't really take the whole picture into consideration. And the question before us is actually, do we see South Africa as a unitary state or as a federation? Because the Constitution makes both interpretations possible. And definitely I'm in favor of a federalist approach, and that determines my opinion on this, even though FETSAS may have, lost their way a little bit for that one moment, but just for a brief moment. But then I just also want to say I understand why Honorable Morwatshela first agreed with Honorable Nodada. It's because Honorable Nodada said it's a case of principle, and he thought it's a principle like a headmaster. Thank you.
We can as well stay till 12. It's getting nicer now. All right. We're going to 25 now. 24 agreed. We proceed as recommended by DBE. 25, it's the office bearers of governing bodies, and it's the last clause for the day.
Thank you, Chairperson. Please allow me to add this sentence, that if you look at anything that has to do with governing bodies, their roles and responsibilities, their functions, whether Section 21 and all that, everything, it's in SASA under the minister. So when we add elections to be under, it just puts everything that call SGBs in under one roof. And there's no that type of separation of powers. the one that you're referring to now, Chairperson, about members of the SGBs, where are we?
25.
It's just to emphasize the fact that in SASA we say SGBs must establish committees, and all committees of the SGBs are chaired by SGB members. Remember, a committee may be made of different members who are not necessarily members of the SGB, but only SGB members can chair them. So this one is becoming even more specific and say, if it's a finance committee, the chairperson of that must be a parent who is not a staff member of a school. Because normally we've got a lot of problems with staff members that chair finance committees and do stuff on their own. So you need somebody who's not an employee of the school to ensure that the decisions taken by the SGB on how finances are used is a parent and not an employee. You get chairperson who's an employee, a teacher, is in cahoots with the principal, and money start getting lost in them. So we're putting the parent there so that it can neutralize this functioning between the SMT and the school. Thanks, Chair.
Members, 25? Clause 25? Agreed? Awufuna uhamba ne siqhube because ungahamba siyaqhuba ungahlala siyaqhuba.
You know this numerical arrogance is not. No. Voila. Just know that these two behind me might not be here tomorrow. But Chair, I just wanted to say that I know that we're not dealing with clause by clause. We'll deal with that when that comes. But those we've raised opposition to should be noted as such. And anything else the committee had deliberated on and there seemed to be support, there's a reservation from our side. That's the only point I'm trying to make to you. Thanks, Chair. We can go home and sleep now.
Yeah, no, I think.
No, order. Honorable Sukers.
No, I think mine is also just clarity, not to ask for clarity, but to give clarity in the sense that we do the clause by clause. It was my understanding anyway that the voting process is only after we are presented with the list, and that we are deliberating at the moment. So the same applies. Thank you.
The A list, which amends the.
But that was clarified. What are your fears now? It was clarified. Why must we clarify when we start and when we close? One thing, A list, voting. We will vote and we will still be many, 8. Oh, and Boshoff.
Yeah, you will be number 9.
There's a small business, this one. I've got something for them.
Remember, FF Plus is the veterans league of the DA. That's what they're doing. So they are mostly going to be together, but on certain clauses were together.
No, I think let us thank everybody. Let us thank everybody for the cooperation today. I think our meeting went very well. Today, I think also as the chair, I must really say that the manner in which we have conducted ourselves today is actually proving that we are bigger individuals, but also in the same vein, I think we are also learning, Uri. There's nothing that stops us from working together. We can work together and we can put our issues across really without emotions. You know, out of every situation you learn. And I think one is appreciating. Let us go and sleep, those who are going to sleep. And then we are meeting at 9 tomorrow morning. Same venue. Honorable.
No, yes, Chairperson. Thank you. I think we can allow ourselves to follow Honorable Manye's process. It's quicker.
Which one?
The one that we're following now.
Honorable Litsie, you have collapsed us yesterday.
We just want to ask our committee staff to help us with arrangement in the morning, transport.
Yes, yes.
Today it was almost messy. In fact, they had left me. Whereas there were 2 cars there, but the cars people, I think they take calls from the DK. I expect not that I call the transport. I think not that I call transport. So, but tomorrow let's organize that so that we arrive on time.
Yeah, so that we arrive on time and those who want breakfast have breakfast. But let us start at 9, man, tomorrow.
Maybe
Let us start at 9.
Letsie and I can just sleep over here in the NCOP chamber.
Huh?
We can just sleep over in the NCOP chamber, Letsie and I.
Hey, let's see. Thank you very much. Thank you.
I'm straight.
Yo, I'm tired today.